Welcome to the board's second day of our hearing on demurrage and accessorial charges. I would like to thank the first panel of witnesses who agreed to accommodate us late yesterday so that we were able to be as productive and not miss an opportunity to also talk to all the rest of the witnesses, and there are about 17 to go for the day. It'll be probably a full day. Looking forward to it. Yesterday was very informative, very interesting, very enlightening, and I believe that today will be equally as helpful to the board. I'm going to just quickly remind witnesses of the rules, if you will, with respect to time. Each witness table is equipped with lights, and they will guide you about your allotted time. 1 minute before your allotted time expires, a yellow light will appear. When you see the red light, if you could please conclude your remarks as soon thereafter as possible. Again, a video archive will be available on the board's website in the next few days once it's available to the board. And the record will be open for 14 days following the close of the hearing for any written comments or responses or grievances that you wish the board to consider in the context of these issues. June 6th would be the deadline. Thank you. Unless my colleagues want to say anything, we will start with the first panel. Jeff Sloan from ACC, Kansas City Southern, and Diversified CPC International. Jeff, if you want to go first, I appreciate it.
Good morning. I appreciate the opportunity to be here on behalf of the American Chemistry Council. Before I begin my remarks, I'd like to thank the board and the staff for the work that went into the Rate Reform Task Force report. Very pleased to see that and appreciate the board's commitment to pursuing meaningful changes in the board's rate review processes, and we look forward to working with you going forward on that. The topic of today's hearing is also a source of growing concern for ACC member companies. Our industry is one of the largest customers of the U.S. freight rail system, and our transportation needs are growing significantly. More than $200 billion in announced new capital investments are expected to result in about 2 million new chemical and plastic shipments per year, including 300,000 additional rail car shipments. It should come as no surprise then that ACC members are very concerned about the major operational changes in today's rail industry, including the litany of recent changes to demurrage, storage, and accessorial charges. My comments will focus on some specific problems that have affected a broad range of ACC member companies, and then I'd like to outline some key principles of commercial fairness that I covered in my written testimony, and then conclude with several recommendations for follow-up actions by the board. The single biggest concern for ACC members is the reduction in free time, particularly the storage time for ACC members that, and the majority of them own or lease their own rail car fleet. So I won't go into the details of that because I think a lot of that was covered in testimony yesterday, but would reiterate that the effect of service inconsistencies by the railroads and bunching of cars really exacerbates the problem of the lack of free time. And those, the bunching issues can happen for a variety of reasons, but essentially none of those are the fault of the shipper. ACC acknowledges that railroads do offer storage credits in some circumstances, but there are limits to the effectiveness of those credits. First, the delivering railroad does not offer storage credits when an upstream railroad in the route is responsible for the bunching. I heard in UP's testimony yesterday that they will cancel charges in those circumstances, so I'm pleased to hear that and hope that's the case with other railroads as well. But the second concern is that the credits are not always automatic. A shipper must request the credits, and then the information that the railroads provide may be insufficient to determine, for the shipper to determine if the credits are warranted. And then the window for disputing charges is often narrow, and as we heard yesterday, at least in some cases, there's an additional handling fee for the privilege of disputing a charge. The zero free time rules eliminate any buffer that shippers have to mitigate the impacts of bunching. And for some members, compliance with the new rules requires significant operational changes or even building new infrastructure. And for others, compliance is simply not feasible. They're stuck paying the bills no matter what they do. Second major concern for ACC member companies is the NS congestion charge. And again, that was covered extensively in testimony yesterday, but I think the fact that this is imposed at the sole discretion of the railroad makes it particularly problematic. Moreover, despite being a per car charge, my understanding is that NS does not appear to identify the cars on which the charge has been assessed, nor do they offer credits when the congestion is due to bunching. And lastly, this charge appears to serve much the same purpose as the demurrage and storage charges to which the same traffic is also subject. And then ACC is pleased that Union Pacific recently modified its charges for rail cars that are not prepared for service, and this does significantly reduce the negative impact on ACC members. However, there are still some concerns about this charge. The charge is understandable when unprepared cars impose actual costs on UP, such as requiring the railroad to make an unnecessary trip to the shipper's location. That's not always the case at a large facility where the UP is picking up and delivering multiple cars. In such circumstances, it's not impacting UP's service, and it's more, at least members see this as a revenue source for the railroads. The concept of commercial fairness is critically important to shippers, particularly those that lack access to competitive transportation options. Without effective competition, railroads can impose rules and charges with little regard to the impacts on their own customers. And lacking recourse in the marketplace, rail customers have to look to the STB to ensure that such practices are in fact reasonable. ACC has developed 6 high-level principles that we believe should inform the board's thinking on the reasonableness of these kind of rules and charges. Many of these have been addressed in one way or another throughout yesterday's testimony, but I'll outline them kind of in the way we see them. So first of all, there must be a rational justification for the rules. The benefits and efficiency realized by the railroad are only one side of the equation. To be economically rational, the newer change practices must produce benefits that outweigh the cost that's borne by the customers to comply with the practices. And also would note that while most Class I railroads have adopted their tariff changes as part of the implementation of precision scheduled railroading, it is not clear to ACC members when or if they will share in the benefits of the new operating models. Second, there must be a direct relationship between the rule and the desired effect on rail operations. Charges should apply only to actions that are within the shipper's control and that actually impair rail operations. And for example, there's no justification for imposing storage charges for delays triggered by bunching, whether that's caused by the delivering railroad or an upstream carrier. Third, railroads must allow a reasonable time for shippers to take actions that are necessary to comply. And I think it was discussed yesterday, a longer time may be necessary for major changes. And then regardless of whether a railroad gives 20 or 90 days notice, it's unreasonable to impose charges while a facility is acting in good faith to implement the changes necessary to accommodate the railroad's needs. Fourth, there must be transparency in implementation. The rules have to be based on clear and objective criteria. Changes like the NS congestion charge imposed at the railroad's sole discretion utterly fail this principle. In addition, railroads must provide well-defined standards and procedures for disputing charges and obtaining credits. Fifth, there must be true reciprocity. Reciprocity should mean that a railroad may not impose charges on shippers for actions that adversely affect rail operations unless that railroad also compensates its customers for the railroad's actions that adversely affect the customer's operations. And finally, no double dipping. Railroads should not impose multiple charges that serve the same purpose. The NS congestion charge, again, is a glaring example. In addition, charges for railroad services that customers use to comply with the storage rules also warrant scrutiny. For example, as the elimination of free days forced shippers to move more cars onto storage track, the NS increased its fee for intra-terminal switching by 50%. The fact that a railroad is receiving additional revenue regardless of whether a shipper pays the storage charges or takes the actions to avoid them raises serious questions as to the railroad's motives underlying the rule changes. ACC proposes 3 potential board actions as follow-up to this hearing. First, we ask the board to develop a policy statement based on the principles that I've outlined and principles that others have outlined during the hearing. And this policy statement would establish standards for evaluating the reasonableness of railroad practices. A policy statement would provide badly needed guidance to both railroads and to shippers and hopefully help minimize the number of disputes that the board may have to resolve. Second, ACC asks the board to initiate a rulemaking proceeding to adopt rules for billing and disputing demurrage and storage charges. The board has a model for such rules in its principles and practices for processing cargo loss and damage claims. Analogous rules should establish minimum information requirements that enable shippers to audit demurrage and storage charges, as well as clear deadlines for the railroads to respond to disputes. And finally, the board can exercise its investigative authority granted in the STB Reauthorization Act of 2015 to proactively review and determine the lawfulness of problematic tariffs. Thank you again for this opportunity, and I look forward to answering any questions.
Thank you, Jeff. Sandra?
My name is Sandra Dearden, and I'm president and executive consultant at High Road Consulting. Prior to starting the firm in 1996, I was general manager of marketing and sales at Chicago Northwestern, and I stayed on with Union Pacific through the end of the year following at UP's acquisition of CNW. High Road has managed transportation for Diversified CPC International since 1998. They asked me to present testimony in this proceeding on their behalf. Diversified is headquartered in Shanahan Rail Station, Lorenzo, Illinois. It has 6 manufacturing and distribution facilities in North America. At Lorenzo, which is served by BNSF, Sparta, New Jersey, served by NYSW, Sebring, Florida, served by CSX, Anaheim, California, served by UP, Pedal or Dragon, Mississippi, served by Norfolk Southern, and a distribution terminal in Ontario. In 2017, Diversified established a transload operation at Lumberton, Mississippi, also served by NS, to support the Dragon plant, managing inbound product that is subsequently trucked to Dragon with the primary objective to mitigate demurrage. Dragon has track capacity for 10 cars. Lumberton's track capacity is 27 cars. I am accompanied by Chad Rainey, who oversees the plants at Dragon and Sparta and the transload operation at Lumberton. Diversified CPC manufactures propellants for aerosols. All commodities shipped and received moved in private tank cars. While Diversified initiates some shipments by truck, they are dedicated contract carriers, and the trucks are commodity and grade specific to avoid contamination of the products. In 2017, Diversified entered the hydrocarbon refrigerant business, serving the LNG market. So we are in the process of locating a terminal in Texas to serve those customers that do not have access to rail. The gas will be produced at the Lorenzo plant and shipped to transload. Even though Diversified is considered a leader in the aerosol propellant industry, it is a relatively small shipper. Our largest customer receives approximately 225 cars a year. However, for every gallon of finished product produced by Diversified, we receive an equal amount of raw materials inbound for production, thereby doubling our volumes. Today's testimony will focus on charges and changes to the Norfolk Southern tariff. Norfolk Southern published a new charge, the congestion charge, of $100 per car per day to apply on all cars destined to a location that, in the sole judgment of Norfolk Southern, has an excessive quantity of cars that congest NS facilities, resulting in operating problems. NS may hold these excess cars at various locations and assess the charge for cars that exceed 2 times the average number of cars that the consignee received at that location during the previous 2 weeks. Diversified's plant at Petal has experience dealing with congestion in the NS yards. Currently, the Birmingham yard, which is a major interchange point for shipments to Petal, where NS receives Diversified CPC cars at interchange, is consistently congested. In 2016, the NS yard at Dragon was extremely congested, resulting in missed switches and the interruption of inbound product needed for Diversified's operations. As a result, NS assessed demurrage charges of more than $65,000. If this rule had been in effect at that time, the congestion charges would have been in addition to the demurrage charges. NS has not established standards for the definition of a congested facility, and without standards, the charge appears to be arbitrary. However, it has been our experience that the congestion at Birmingham and Dragon yards was not caused by Diversified. Instead, the congestion is and was the result of limited capacity of the yard at Dragon and at the interchange at Birmingham. Yard congestion has a negative impact on Diversified's operation and production. The railroad has missed switches of inbound raw materials at Dragon, and the cars have been delayed at Birmingham, and Birmingham continues to be a choke point. Yet there is no consideration of potential reciprocity by NS when assessing these charges, so Diversified and other customers can recover costs, for example, for interrupted production, plant shutdowns, and potential loss of business. Customers do not have control over NS operations, and the charge appears to be unreasonable. Finally, because congestion charges are in addition to demurrage charges, it appears the assessment of congestion charges results in double dipping. Effective January 1, 2019, NS reduced its credit days on empty private cars under constructive placement and on loaded private cars with no forwarding instructions from 2 to 0 credit days. Concurrently, the credit days on railroad controlled cars were reduced from 2 to 1, although they increased credit days on loaded railroad cars from 1 to 2 when NS fails to make an ETA. As a result, railroad controlled cars are allowed 1 credit day for loading and unloading, while private cars are given 0 credit days for loading and unloading. These changes will result in demurrage or storage charges on private cars, and the charges being assessed whether the shipper is diligent in its loading and unloading operation. Under this new plan, the storage charge for a private car begins to accrue at 12:01 after constructive placement of the car. After NS notifies the shipper the loaded or empty car is ready to deliver to the shipper, and continues until the shipper directs NS to deliver the car to its facility and it is placed. NS storage charge for private cars is an average assessment. Upon constructive placement, each empty car will receive 0 credits, and each day thereafter that the car remains on the track, 1 car day is assessed until the shipper orders the car delivered and it is placed. Total credit days for private cars are subtracted from total car days for the month, and the shipper is charged a storage fee for each net car day. Here, there can be no credits because of the 0 credit days set forth in the tariff. If a private car is constructively placed, that means a storage charge will likely be applied. For example, if a car is destined to a customer who orders the car in at 11:59 p.m., that means the railroad will only have 1 minute to take the cars off constructive placement in the system. In other words, this change related to private cars will likely result in situations where a customer cannot possibly avoid storage charges being assessed, no matter how diligent they are. Using this example, absent a reasonable period to accept the cars, the ability to avert the storage fees is lost. We respectfully submit that the changes in the tariff as they relate to private cars are violations of 49 USC 10746, which provides a rail carrier providing transportation subject to the jurisdiction of the board under this part shall compute demurrage charges and establish rules related to those charges in a way that fulfills the national needs related to freight car use and distribution and maintenance of an adequate supply of freight cars to be available for transportation of property. The 0 credit rule for private cars fails to fulfill either of these national needs. This new policy simply appears to be a revenue generator for NS, and in no way does it satisfy the 2 national needs for freight cars. Also, the new policies appear to be one-sided in favor of the railroads. In NS announcement to, quote, rail business partner and NS tariff subscriber, end quote, they state, service window, the designated block of time within a service day that NS anticipates it will physically pull and place customers' cars. These times are not guaranteed, and delivery outside of these projected times will not impact the obligation to pay demurrage and storage charges. It seems that NS does not realize the significance of the need to be committed to customers as business partners. Missed switches and bunching are 2 examples. As explained previously, missed switches can result in plant shutdowns and bunching. Currently, bunching is perceived as the accumulation of cars arriving at a yard from various origins for loading and unloading. From various origins that exceed the customer's capacity for loading and unloading. Frequently, bunching situations are due to service failures, and in most cases, railroads will waive demurrage or storage fees for cars that have already arrived at the destination yard. However, they don't give any relief to waive fees for cars already en route. that subsequently become backed up in the yard. So the railroad's bunching practices should be investigated and potentially found to be unreasonable. I would like to apologize to the board for the numerous sites of case law I presented in my written testimony. However, case law supports our position that the new demurrage and storage rules are unreasonable, and I thought it was important to share the results of our research. We submit the changes in tariff as they relate to private cars constitute an unreasonable practice. 49 U.S.C. 10702 provides rules and practices on matters related to that transportation or service. In Section 10702, Congress did not limit the board to a single test or standard for determining whether a rule or practice is reasonable. Instead, it gave the board broad discretion to conduct case-by-case, fact-specific inquiries to give meaning to those terms, which are not self-defining, in the wide variety of factual circumstances encountered. This broad discretion is necessary to permit the board to tailor its analysis to the evidence proffered and arguments asserted under a particular set of facts. The reasonableness standard applies to demurrage. The principle underlying demurrage is straightforward. When a shipper holds a car beyond a reasonable time, it is taking up a railroad asset for which the railroad should be compensated. Demurrage charges therefore serve two purposes: to compensate the railroad for added costs. For example, car hire charges it pays to carriers owning the equipment being held, or loss of use of assets, and to encourage shippers to return freight cars to the system, thereby making the entire system more efficient. The STB has defined demurrage as a charge that both compensates rail carriers for expenses incurred when rail carriers are detained beyond a specific period of time for loading or unloading, and serves as a penalty for undue car detention to encourage the efficient use of rail cars in the network. Finally, the STB also defined who is subject to demurrage: any person receiving rail cars from a railroad for loading or unloading who detains the cars beyond the period of free time set forth in the governing demurrage tariff may be held liable for demurrage if the carrier has provided that person with actual notice of the demurrage tariff, providing for such a liability prior to the placement of the rail cars. Notably, both definitions acknowledge a specific period of time for a rail customer to use the railroad's assets. The question then becomes, what is a reasonable period? Certainly, it is more than zero, because zero is not a time period. Finally, there is no transparency by NS to assess the fairness of any of the charges, and singling out private cars for the reduction of credit days to zero seems unfair and discriminatory. Demurrage and accessorial charges are a major source of revenue for the railroads. Revenues for demurrage and accessorial charges reported by 4 Class 1 railroads totaled $1.2 billion in 2018. We thank the board for opening this proceeding and allowing time for diversified CPC to submit its comments. This is a topic that has a significant impact on rail customers, and we encourage the board to launch a full investigation of the rules and charges.
Thank you, Sandra. Mike?
Good morning. Good morning, Chairman Bagman, Vice Chairman Fuchs, Commissioner Oberman. Thank you for affording me the opportunity to speak with you this morning.
Can you get a little?
Sorry, we'll try that again. How's
There you
that?
go. We heard the open.
All right. I'll introduce myself. My name is Mike Natz. I'm the Executive Vice President and Chief Marketing Officer for Kansas City Southern Railroad. I've been with the railroad for about 7 years. In total, I have 30 years of transportation experience on the buying, selling, and operating side of the business. Prior to joining Kansas City Southern, I served in a number of positions with YRC Worldwide and its predecessor companies for about 18 years, including a term as president of USF Holland and as president and chief customer officer for YRC's customer care division. In these positions, I was responsible for both working with customers to meet their needs and for working with railroads as a rail customer. I also worked in the manufacturing sector as a consumer of rail services. Having worked on both sides of this equation, I can certainly appreciate the many perspectives that are being discussed during the course of this hearing. Since we have submitted our written statement, I do not intend to read that statement here. I hope you found our response to be forthcoming and valuable. I believe it is appropriate to start my testimony with the KCS vision statement. Our CEO carries our vision and value statement in his jacket pocket, and he asks his officers to do the same, and I have mine with me today. Our vision communicates our desire to consistently be the fastest growing, best performing, most customer-focused transportation provider in North America. And we realize that a railroad is in the business of serving customers, and that providing excellent service is what will enable us to grow. In fact, we have a very simple mantra: service begets growth. In my role at KCS, I advocate for the customer as well as Kansas City Southern. In doing so, I try to look at things through the eyes of our customers. While our customers often have unique goals and objectives, it's our job at KCS to demonstrate value to each of them. In the context of this hearing and our filing, we acknowledge that KCS recently adopted changes that increased our demurrage and accessorial fees. These increases followed many, many years without taking an increase. We realize that our demurrage rates distorted the marketplace, and we had unintended consequences. Very specifically, our low demurrage fees were creating an incentive for some customers to store cars on KCS versus other alternatives. This is contrary to our objectives and may actually inhibit the fluidity of our rail operations. As a single mainline railroad, it is particularly important to us that we avoid having sidings congested with stored or inactive cars. Cars that are stored in sidings prevent our trains from meeting and passing on our main line. This impairs the fluidity of our network and inhibits service to other customers. Similarly, inactive cars in our yards create operating inefficiencies. Because of this, we believe demurrage and accessorial charges are a legitimate and necessary tool that facilitates service and promotes the efficient use of assets, whether they be rail cars, track infrastructure, locomotives, or crews. Our use of demurrage is consistent with the STB's E707 ruling. In the month of March, 62% of our customers did not incur demurrage. And in fact, 50% of our demurrage was concentrated in only 8 large customers who have large rail car fleets. In most cases, those customers accept demurrage as an alternative to building capacity or pursuing what they would regard as other less attractive alternatives. Of course, our objective is not to place an undue burden on our shippers. If a situation permits alternatives, such as leasing space where capacity is available to do so, we will work with customers on an alternative to demurrage. We are trying to balance the needs of the railroad and all of the customers we service. We cannot put the needs of a few ahead of the needs of many. To maximize value for everyone, railroads and shippers need to work together collaboratively to ensure we operate efficiently. It's in the best interest of all parties to do so. Demurrage and accessorial fees represent less than 3% of our revenues, and disputes on a per-car basis represent a small fraction of 1%. We prefer to generate revenues through growth in line haul volumes. We do not view demurrage and accessorial charges as a primary revenue stream, nor as a mechanism to produce profit. And we share the concerns that administering exceptions can be difficult. In fact, we would prefer not to be in a position to have to charge demurrage to begin with. But that is not the reality. I would like to share a few examples of collaboration and the actions that KCS has taken to improve operations. KCS employs a team of business process improvement engineers and service design professionals, and they work with customers, partners, railroads, and internal teams to eliminate waste and find more efficient ways of doing business. This work has included collaborating with our customers and partners to improve transit times, eliminate causes of demurrage, and improve asset utilization. These actions directly benefit our customers and the railroad. As noted in our filing, KCS has elected to waive demurrage charges for customers that committed investing those funds in building additional capacity at their facilities in order to avoid future demurrage activities. KCS has also made direct investments on other railroads because we thought it was in the best interest of our railroad and our customers to do so to speed up the network. We also pay for reroutes with other carriers even when those reroutes are not the result of KCS-induced problems. At the core of these actions is our desire to grow our business, improve service, and improve asset utilization. And certainly we realize there will be disagreements from time to time. We work with our customers to reduce these conflicts and strive to be easy to do business with. And why is the question? And the answer is simple. Because we value our customers and believe that this is in the best interest of KCS. In 2018, 80% of our customer disputes over demurrage and accessorial fees were resolved in the customer's favor. We have not embargoed customers for failure to pay their demurrage bills. Again, we prefer to work collaboratively with our customers toward a solution. I would like to briefly address our implementation of PSR and communicate how we believe our approach differs from that of our peers. I will begin again with our mantra, service begets growth. We are implementing PSR at KCS for better railroading and more reliable growth. We have 4 objectives. The first is customer focused. Our desire is to improve and sustain the consistency and reliability of our service. We also wish to create a more resilient and dependable network. Number 2, we wish to facilitate growth. If we're successful with PSR, we will free up capacity for new opportunities. Number 3, we wish to improve asset utilization. This will help us meet growing demand with the same number or fewer assets. This should also benefit private fleet owners. Improved asset utilization allows us to hit our 4th objective, which is to improve our cost profile. We believe that we can successfully increase our profitability by driving volume and revenue growth while improving productivity and asset utilization. The information I just shared with you comes from a single version of a slide that we use to communicate with all constituencies, including internal employees, our board of directors, customers, and investors alike. We will look for additional efficiencies as we move forward with our implementation. Our goal is to improve service and customer satisfaction, not to disrupt it. I would like to close with how I opened. Our vision is to be the fastest growing, best performing, most customer-focused transportation provider in North America. We realize that a railroad is in the business of servicing customers, and that providing excellent service is what will enable us to grow. Service does beget growth. And we will continue to work collaboratively with our customers to identify and resolve problems. And after a slow start, thank you for your attention. I'm happy to answer questions when you have them.
I'll kick things off, and backdrop to some of these questions, Mike, is that I think it's clear in the filings and what we've heard that it's not, KCS is not the center of where most of the complaints are coming from. But nonetheless, there's been a number of ideas already this morning and yesterday. I've kind of been cataloging them, and I'm just kind of wondering what your views are on some of those. One of which is the notice before changes are made. There's you have the statute and regulation, but what is your view on extending the notice time prior to, say, major changes, however defined, take effect?
Again, trying to put ourselves in the seat of the customers.
Right.
As much notice we can give them, the better off everybody will be. In our case, when we were making changes, we started communicating with our customers about 3 months before we made the changes. And then we did permit 23 days after the formal change was initiated.
So in your view, a minimum of 3 months and is acceptable for at least a minimum of 3 months for anything that would constitute, say, a major increase in rates or a reduction in free time or what have you? I should say a major increase in fees. Excuse me. Go on.
I think that's going to be situational.
Yeah.
I think my objective is to give customers as much time as we possibly can. Again, we want to be reasonable. We certainly realize that they have planning objectives and changes that they may need to make, given the changes that maybe we are pursuing. So as much time as we can give them, we would like to afford them. think
And
it'll be situational.
deadlines to respond. You know, your customers have a deadline to dispute things, and I guess I'm wondering, does KCS have an internal deadline that it imposes on itself to respond to customers' disputes?
Yes, generally speaking, as soon as possible.
Right.
The reason for that is very simple. It's much easier to resolve a problem when it's fresh than it is to resolve it if it comes in months later.
Right.
So, our systems and tools that are available for our customers permit customers to begin the dispute process even before an invoice is generated.
Right. And that came through, and that's appreciated. But I guess I'm wondering, is there a situation where, and I saw some other folks have like a 15-day deadline internally for them to respond. Is there a situation where it would be appropriate or reasonable for a railroad not to respond to a customer's dispute for more than 15 days?
I don't believe so. I mean, we would like to respond again as quickly as we possibly can.
And on bunching, did I see correctly in KCS's tariff that bunching is not considered railroad error?
That may be the case, yes.
And so, the hypothetical we were using a lot yesterday was the 5, 5, and 5. You have 3 days and 5 cars go out on each of the days, and they have different transit times. So just naturally, with everybody operating perfectly, you get 15 back at the same time. That customer who's shipping out 5, 5, and 5 may have a maximum of 10 spots. And so you got 5 that go into constructive placement. If that's that situation where the customer sent it out individually and they got back more than they could physically take in, would KCS charge them on those 5? Do you all not give any credits?
We do give credits. Truth of the matter is we would evaluate that on a case-by-case or situation.
So it's not an automatic thing when empties come back and outstrip capacity, the credits aren't automatic. In other words, that 5 is just, hey, listen, we know our customer doesn't have the capacity for these 5, we're crediting them automatically.
That's correct.
And why isn't it automatic?
Well, we have rules in the system that are designed to simply create efficiency.
Yeah.
And could we improve the rules technologically that may result in changes?
Right.
I think the answer is yes, but I think there's so many different circumstances that apply. Each of those need to be evaluated. So we might be able to make improvements.
Right.
There's certainly always opportunity for that. But I think it would be difficult to try to define each and every circumstances under which we might consider waiving.
And is the problem because defining the customer space, or is the problem defining exactly how many empties came back? Because it would strike me that those are the 2 data points you would need. So help me understand what the problem is.
Well, I actually believe it's more complicated
Okay.
than that. So 80% of what we're handling in the U.S. is usually interchanged through another carrier.
Right.
We might be dealing with our own railroad, another railroad. We might be dealing with a third-party logistics company. We certainly are dealing with the shipper. We might be dealing with the receiver.
Mm-hmm.
There are reasons in each of those categories why bunching may occur.
Right.
And there may be some proportionate impact that each of those entities have.
Right.
And so I think it's difficult to program that. I think there's
I
some
see.
judgment involved.
So what I'm hearing from you is not that you all couldn't figure out, hey, these are 5 and our customer has 10. Is the problem that you all are saying, okay, but if we give credit for those 5, that assumes that we're at fault when it might be someone we're interchanging with is at fault, and that's why we don't want to give the credits. Is that kind of inaccurate?
Yeah, absolutely.
That isn't so in the technological problem is figuring out who, but I guess, all right, so then playing this scenario out, if you were interchanging with another carrier, you would know how many empties they gave you, so wouldn't you just say, okay, they've given us 15 at one time, so therefore they've already started the bunch, and that's going to outstrip this person's capacity, and so you couldn't assign fault to that at that moment, and why is that?
Because there's usually some other upstream or downstream activity that may.
Or there's something you could do to break up the bunch or something like that?
Absolutely, and of course, yes. I mean, if we can take other actions to eliminate the pain different organizations are going to feel, we would try to do that as well.
But it's kind of this unusual scenario where, on one hand, it sounds like a complicated scenario and difficult. On the other hand, the result of the complication of the interline move is that the carrier just gets no credit, or excuse me, the receiver gets no credits. And so I guess I'm is it your view that it would be good for the customer to get those credits if only we could figure out this assignment of fault between us carriers?
I go back to the magnitude of the problem, and I think that's going to vary depending on the railroad, the customer, the number of circumstances. For us, given some of the information I've shared with you, I don't view that this is a particularly significant problem for us and for the customers that we work with. And I'm really not in a great position to speak to, the customer or the railroad situation.
Sure. It's something I want to explore more. I have more questions, but I want to make sure.
So I'm going to start with you, Mike, but I have some for the others too. But by the way, my perception is consistent with Patrick's. If we just look at what we've heard from the world of shippers and receivers, KCS doesn't seem to stand out as a target. But I'd like to get on the record some of the issues that I dealt with yesterday from KCS. So as I see it, I mean, obviously all the demurrage rates are not identical, but one of your standard rates is $130 from your submission. Do you break down how much of that 130 is compensation and how much is penalty?
Yes, we did do an evaluation to understand what the rate should be, and the preponderance of our rate is associated with cost and opportunity cost.
And did you do that before you set the rate?
Yes, we did.
I'm going to guess, based on what I heard yesterday, you don't want to say what that breakdown is in public.
I would rather not.
All right, but you'll provide that to us under some protective order if we ask for it?
Certainly.
And has that always been the case with your demurrage rates, that you internally calculate some amount for compensation and some for penalty?
Yes, it's primarily cost-based, but yes.
All right, so one of the things that you talked about that the other railroads did not talk about, which I found interesting in the context of this whole policy question about the purpose of demurrage. You talk about half of your demurrage is five customers? Eight customers are who just have large fleets. And in your written statement, and I think you alluded to it this morning, you said that some of these customers simply choose to leave their cars on your tracks as a way of doing business and pay the demurrage.
Correct.
But you also said that you have been able to arrange for lease agreements with some customers so that they do the same thing, but they do it under a lease rather than just paying the demurrage charges.
Correct.
So what's the difference? Why are the lease rates higher than the demurrage charges? Or I mean, why would any customer who feels that their business model is to use your tracks for storage, why wouldn't they just enter a lease rather than suffer the demurrage?
Well, again, it's situational. There are areas on our network where we have more capacity, and there are areas on our network where we have less capacity. If we have a capacity that is available, and we believe that it would be in our customers' best interest, we would go ahead and enter into a lease arrangement with those customers, and they would consume that underutilized capacity we have, and they would be able to do that at usually a lesser rate than demurrage. The idea being that we would rather get those cars out of the way so that they don't impair our operations. We also don't want to have to deal with the ongoing burden of calculating demurrage on cars. So to the extent that we can move them off, it's a win-win relationship for our customers and for the company.
So, well, that makes sense. I'm wondering about the customers who are using the storage regularly, you allude to it, and aren't getting a lease. Well, why aren't they leasing that space?
Well, they're not leasing it because we don't have additional capacity or available capacity in their areas with which to lease. In this particular example, we are actually building a storage and transit facility that some of these customers will use in the future once that facility is done. And that will lighten the burden from a demurrage perspective for those customers.
Well, the reason it sort of caught my attention is you seem to be comfortable, and I'm not being critical of this, I'm just trying to understand the business from both your side and the shippers. You seem to be comfortable with those customers who choose to accept the demurrage charge and just regularly leave their cars on your tracks. Or at least the tone of your statement is, yes, this happens and we're fine with it. If the purpose of demurrage is to incentivize people not to do that, and I'm not urging you to raise the fees, but it seems to me it's not really part of a demurrage plan because they're not incentivizing them to leave the track. You're saying it's fine, leave the cars on the track. It doesn't make sense to me from that point of view.
So I certainly appreciate what you're asking. I guess I look at it a little bit differently. We have ongoing dialogues with our customers, including the ones that are choosing to use demurrage in this case. In some situations, they're evaluating their alternatives. Maybe they're going to reduce their fleet size. Maybe they're going to build their own facility. In some cases, we've agreed that we're going to build a facility and that they will enter into an agreement with us. I don't believe that if we're all working together collaboratively to find a solution, I don't know that I want to penalize them through a...
So you're saying these situations are not really permanent, they're more interim.
Correct, they're interim, exactly. We're working towards a longer term solution that will benefit everybody.
Well, that makes more sense, but it didn't come out that way in the statement. I mean, you didn't elaborate on it, that's why, so I was sort of curious about that. I wanted to ask a couple of questions about the collection process or the dispute process. Did you say 8% or 80% are resolved in the
80%.
Are resolved in the customer's favor? So I'm sort of curious about that. Does that mean you just gave in, or that your bills were inaccurate?
No, and I anticipated that you might ask this question. Debated whether or not to put that statement in. Again, I'll come back to the other piece of information that indicated that far less than 1% of our car totals actually end up in demurrage. When we're looking at a situation, we're not necessarily admitting that KCS is the reason why something has happened, and we're granting the customer's request to waive demurrage. That certainly will be the case from time to time, but there are other circumstances that we take into consideration, and sometimes it just boils down to customer accommodation. We're trying to look at the big picture of what we're trying to accomplish with the company, with our company and our customers' best interest. So that's probably why you see those numbers the way they are.
Well, it's vastly different from anything we've heard from any other railroad so far. So you're saying it's a more customer-friendly approach as distinguished from who was right or who was wrong.
Exactly.
So let me ask you what your process is, because I think one of the things we're trying to figure out is what's a reasonable or feasible process throughout the industry. Before you send a demurrage invoice, how much internal sort of due diligence or investigation or establishing a prima facie basis for sending the invoice do you do? So I got the impression yesterday that in some railroads, it's if the time is wrong on the clock, an invoice is automatically sent out by the computer. And there's not much thought given to it until the customer decides to investigate and protest. How does that compare to how you do it?
Again, it's somewhat of a complex answer. So we at the core of what we do, our field operators will be, when they're spotting cars or when they're pulling cars out of industry, they're basically creating a system transaction that has a date and a time of what's happened, and they're applying a status to that information. By and large, that is the rule that we operate by. Again, it's a system process.
So you're saying you have field observers, it's not a computer churning out the bill?
Well, the computer will turn out the bill or the invoice based upon inputs that are happening by field operators.
But based on actual observation, you mean?
Based on observation right now. I will tell you that those operators are not always aware of some of the upstream, downstream, or other activities that are going around. So there will be times when the information they put in, or a status very specifically that they apply, may be inappropriate to that situation. That's regrettable. That's why we acknowledge that there are challenges in the billing process.
It sounds like, Mike, given the way KCS operates with so much of your traffic being interchange traffic, that on a relative basis to the other class ones, you have more upstream and downstream variables, I suppose, that affect this than some of the other cross-country railroads. Is that a fair statement?
I don't know if it's a fair statement or not. I can only speak to what our environment is. And, you know, it's fairly complex. There's a lot of moving pieces, which is why we try to be flexible and collaborative in our approach.
All right. One final question on this point, and then I'll hand it over. Do you charge your customers for the privilege of getting a refund?
No, we do not.
Good, thank you.
I'll echo that good.
Thank you.
Jeff, can we talk about the zero free time issue for a bit? And I know this may be a little bit difficult since you're not actually the shipper. So I understand that, but I'm curious to know if your members could take a reduction in free time, just not to zero. Do you?
I think that's going to depend on the individual customer, but certainly zero is kind of across the board unreasonable for unworkable for them. You're having some buffer zone to accommodate the variability in the service, in the bunching that will inevitably occur. Having some time to accommodate that is necessary. Exactly if it's 24 or 48 hours, I can't speak, and I'm sure my members would probably give different answers.
And one of the latter panels yesterday seemed to have some differing opinions too. Some thought 24 certainly was better than zero. And Sandra, if you want to chime in as well, one of the comments throughout a number of folks' testimony, not what we haven't necessarily heard from all of them yet, but is the idea that if someone delivers at 12:59, we have 1 minute before we're charged. To your knowledge, has that happened?
I'm sure it has. It depends on when the cars arrive.
Because it's sort of the clock is the clock.
Right.
So even when you had more time,
Right.
you had a lot less time before a charge would accrue if it would be delivered that late.
But one of the issues with this is if the customer is a 5-day-a-week operation, the plant manager has to monitor those inbound cars over the weekend, and he's staying up until midnight to see if he has to order cars in to take them off constructive placement. So from that standpoint, it is a major issue.
And Mike, I wanted to ask you, one of the comments that Jeff made, assuming I can find it quick enough, I think it was the concept of, just bear with me for a second, that the shipper shouldn't be charged if they're not responsible for the action. Do you agree with that? Or the customer should?
I'm shaking my head. Yes, again, I think it's going to be a situational. We would review each case and we'd make the decision accordingly. If it's not something that the customer has has direct control over or has not been able to influence things, we'll have that discussion with them and we'll act accordingly.
And just so I have that correct, it was that the charges should apply only to actions that are within a shipper's control and that actually impair rail operations. So I didn't want to be unfair to you by not giving the exact
Sure.
comment.
I
One of
think-
the things I've also asked yesterday's rail folks was whether or not you would be willing to participate in board-sponsored arbitration if requested by one of your customers.
We would certainly consider that. My objective, again, would be to avoid having those situations where we have to go to arbitration.
Great.
And just to pick up where the chairman left off, so you believe that when a shipper is not at fault, they shouldn't pay demurrage. And I guess I'm wondering, to Jeff's point, should the onus be on the railroad to show that it was the shipper's fault in that adjudication? What I mean to say is, who should have the burden of proof?
I'm not prepared to answer that question. I'll defer that one to the attorneys.
Okay.
I would just, I guess, answer it by saying, these are often very complex
Right.
decisions. Not always, but very often there's a lot of moving pieces that need to be.
So say a missed switch, and we heard a lot about first mile, last mile. In the event of a missed switch that causes some sort of difficulty then with kind of a loading and unloading in subsequent days, when a railroad misses a switch, should the credits or however they're trying to alleviate demurrage charges, should that be something that's automatic and not have to be requested by the customer?
Again, I come back to, I believe it's going to be situational.
If a railroad, why would it not be automatic? I guess I just don't. What's the argument against, or why it would be situational?
There could be multiple contributing factors to why that switch was missed.
Mm-hmm.
And I just would want to make sure that those things are evaluated before making a decision.
Keep on talking me through that. So multiple factors. So what's a factor that would result in a missed switch that would be something that the shipper could control?
Well, if the shipper has not maintained their track, or if they have other cars in the way,
I see.
or whatever the situation may be, I do believe that there are circumstances, again, it's situational, where the customer or the shipper might have a responsibility, and there will be situations where we certainly, as the railroad, have responsibility.
I see. And Sandra, you mentioned this private car versus system cars, again, something we hit on yesterday. But, this phenomenon where, we're seeing more and more folks go to, leasing or owning their own private cars and away from system cars. And, some of the recent developments are that, and to confirm in your testimony, that private cars actually have a more difficult demurrage regime, both from a free time standpoint in some instances and from a charge level standpoint. Is that accurate?
Yes.
But that's not the case for you all, right, Mike? The private cars and system cars. If anything, I think I saw correctly that in some instances, private cars actually might have a little bit more, I think it was lower charge level or some aspect, but private cars are not disadvantaged from a demurrage standpoint relative to system cars. Is that accurate?
That's correct. We treat them the same.
And and maybe this is a question for railroads that treat them differently, particularly on the private car side, in terms of them being disadvantaged. But can someone give me the argument for why private cars ought to have a more difficult regime than system cars, even though the owner is, owner or lessor has chosen to take on that asset for themselves in some form?
I would agree with your earlier statement, which is you probably should ask the railroads that are differentiated.
Okay. Can anyone offer any discussion? Jeff or Sandra, have you spoken with railroad folks? What is the, help me out. What's the argument that's given for that differentiation? And to help us kind of in preview for future questions.
Relative to private cars versus railroad.
Yeah, why do they have a tougher demurrage regime than system cars? What's the reason a railroad might offer you if you ask them?
Well, first of all, it makes no common sense. Because the railroads on the railroad cars, especially if they're foreign cars, they're paying per dime to the foreign carrier.
Right.
So that's an added cost. And also, if they want to turn their assets, then they should be focusing on railroad cars. Instead, they're penalizing the customers who lease cars because the railroads don't want to purchase those
Right.
cars. And so they have a commitment to that railroad, and by incurring those costs to lease the cars. And by the way, it's been my experience that if a railroad establishes rates for system cars
Right.
and for private cars, and you look at the cost differential, the customer does not get adequately compensated for purchasing those cars.
Right.
So because of that, you know, they should be equal, if there is going to be a differential, then I would think that lease cars would have a lower cost and more credit days than system cars.
Right, right, and we've been talking a lot about a compensatory effect and an incentive or penalty effect, depending on your terminology, and why that is, particularly for 24-hour difference. Why is it that private cars need a greater incentive or impose something greater when it comes to the compensatory side? That justify that type of thing. It just needs to be explained to me, and I haven't heard that yet. And it sounds like, Mike, from a KCS perspective, you didn't feel that private cars need some sort of greater compensation or penalty / incentive from a railroad perspective.
Correct.
Just quickly, both Jeff and Sandra, let me start with Jeff. Jeff, you had commented in your testimony and to us, you recognized that UP has made an adjustment to it's not ready for service charge, and you were appreciative of that, your members are. And I'm curious, and I don't want to give any type of impression that there's only one fix that needs to be changed, everyone's going to be happy. Clearly, there are a whole lot of issues that we've been talking about the last day, and really before that, the last day. But if any, if you have a magic wand, if the railroads would change, what is it?
Extension of free time would be the number one.
Okay.
And
That's what I thought you would say. I was just curious. And Sandra?
No double dipping.
Okay, thank you.
I'm going to ask a somewhat unfair question to Mike. You might say, among others. But so you all obviously have decided, for when you're evaluating how to improve efficiency on your network, not to go to zero free time. Is zero free time unreasonable?
We didn't believe that zero free time was in the best interest of our customers.
And talk me through that. When you were making that decision, your customer's best interest, how did you come to that conclusion? How did you evaluate your customer's best interest?
We talked about it extensively as a team, soliciting feedback from our customers and understanding what their operational requirements are and what our operational requirements are. And we tried to find something that we thought was workable for both parties.
Appreciate it.
Actually, that was exactly sort of a follow-up question to what Patrick just asked, but I wanted to direct it to Sandra. And it's a legal question. You're not here as a lawyer, but since your operation's in Illinois, I figure you're all wise, so I'm going to ask you to elaborate on this. And I sort of had some of the same reaction as I was reading the case law. You seem to be saying, I think others may have alluded to it, but not in their testimony, that the way the cases have been written, and you cite some of these, in defining demurrage as a charge after free time, aside from the question of whether zero is reasonable, that by definition, there has to be some free time or you couldn't have the definition. Is that your position? That
Yes.
as a matter of law, it can't be zero, whether it's reasonable or not?
Correct.
That's the way I read your testimony. It's also the way that sort of, the cases don't say it, it's by inference is the way I read it, but it
Yes.
seems logical. Jeff, I wanted to direct you to the broader question. You were here yesterday, and you heard a lot of this discussion, and I'm still trying to come to grips with the broad statistics that are provided to us by the railroads about all of the improvements in metrics from PSR, and all these numbers, velocity, dwell, so forth and so on. And yet, the room is filled with shippers and receivers who say that PSR has made their life worse. And when we focused on this yesterday, it seemed to be a matter of first mile and last mile was responsible for the reason shippers aren't feeling the benefits and railroads yet are seeing the metrics. I wonder if you could, the ACC, gathers a lot of data, and I wondered if your organization has had an opportunity to evaluate and make consistent, because I assume the metrics are accurate, the numbers that were being given. So could you shed some light on where the problem is? Is it first mile, last mile, and could you explain it if that's the way you look at it?
I don't have hard numbers on the first mile, last mile issue, but that is clearly at the top of minds of our member companies. And consistently when we ask them, is service better than before PSR was started, they say no. At best, it's back to where there were problems with implementation. At best, those problems have been resolved and are sort of back to where we were as far as the service that members are seeing at their facilities. So, I guess I struggle with that discrepancy too between the metrics that are improving, that the railroads are reporting. I think it may be those are metrics based on the perspective of the railroad and what they are looking at from their performance and not necessarily a true measure of customer service.
And are you hearing beyond the members who actually have been here, like Olin and so forth, at this hearing, are you hearing reports, even anecdotal reports from other members, that when they have this first mile, last mile service problem, that part of the reason is that PSR has resulted in fewer human beings in the yard to make switches or fewer locomotives?
There is frustration that there are fewer people providing service in some cases and fewer people to talk to when there's a problem.
Sandra, you were nodding, you're getting this.
Yeah, it's a combination of factors. First of all, PSR, obviously, in order to get their operating ratio down, they cut personnel and stored locomotives. However, it goes back further than PSR. When the economy took a downturn, they reduced crews and they also stored locomotives. So then, when the economy rebounded, it rebounded faster than the railroad. This is what a railroad told me. It rebounded faster than they had anticipated. So then they didn't have the resources to adequately serve the customers. So as a result, they were missing switches because they didn't have a crew and they didn't have a locomotive.
Well, that was a few years ago, right?
No, that's current.
Oh, well, but when you said it rebounded, I mean, when
did.
I know, but what year are you pointing to when this
Well, that's an ongoing problem, and every time we talk to the railroad, it's like we just don't have the resources. They are training crews, and they are getting locomotives, but they're not there yet. So I don't know how much is due to the situation with the economy and how much is due to PSR. You see what I'm saying?
Yes.
Okay.
But it would seem, from what we keep hearing, that as a result of PSR, they're continuing to cut, when I say they, across the boards, I'm not singling out a railroad, personnel, which seems to be inconsistent with what some have told you that they're trying to train new. We always have to train, there's some turnover. But there seems to be some disconnect here in what we're hearing. I take it that neither of you challenge those metrics from the railroads about dwell and velocity, that you accept them as accurate. Thank you both, that's helpful.
Mike, I just have one quick question. Yesterday, towards the end of the day, we were talking about credits. Does your process also provide for credits to your customers?
We apply credits, again, on an individual situational basis.
And do they expire monthly? Or
We don't handle things that way.
can you tell us how you do handle them?
Again, on a situational basis, if we deem that we are the reason for a problem, we will work with our customer towards a solution that they believe is appropriate. It could be in the form of credit days, it could be in the form of other things.
I see something, and maybe I'm not reading this correctly, but is there something in the tariff that says excess credits earned in one calendar month may not be used to offset demurrage days in another calendar month? Is that what the chairman is referring to when it comes to credits not rolling over, or is that something different?
No, that would be the same, but again, our application of that is going to be very situational.
So the default rule is that credits expire, but you might have case-by-case exceptions where you would allow the rollover of credits.
Correct.
And why do credits expire at all?
I'm not in a position to answer that. I don't know.
Okay.
I think that we will conclude the first panel. Thank you so much. Very, very helpful, very much appreciated. Could the next panel please come forward? Barilla, U.S. Clay, Nor America, and SA Recycling. Adolfo, are you here with U.S. Clay? Well, if you show up, we'll put you on another panel. All right, we will start the next panel, which again is with Barilla, Nor America, and SA Recycling. And Sandra, we will go ahead and just kick it off with you. You moved a chair.
Well, as mentioned before I started the firm, I was with Northwestern and UP. But I think it's significant for this testimony to mention, I was general manager in the ag commodity business unit. Is it on? Okay. So because of that, I'm really familiar with the transportation landscape in Iowa. I'm accompanied by Greg Veers, who is the Barilla purchasing manager for Durham wheat and semolina, U.S. and Canada. And Greg is based in Ames, Iowa. Barilla was founded in 1996 and is headquartered in Northbrook, Illinois. Barilla produces and distributes pasta and sauces, and it offers filled and whole grain pastas. Barilla America has a production plant and Durham wheat mill served by Union Pacific Railroad in Ames, Iowa, and a production plant served by the Livonia, Avon, and Lakeville Railroad in Avon, New York. The LAL connects with 3 Class I railroads, Norfolk Southern, CSX, and Canadian Pacific via operating rights over NS. The Ames plant has a Durham wheat mill, but the plant in Avon does not have a mill. So the Ames mill produces semolina for its own production, and it also produces semolina which is shipped by rail to the Avon plant and to some co-packers. Barilla is a spot-on arrival customer at Ames. The Ames mill sources its wheat from 2 primary regions, U.S. origins, which are Arizona, California, Idaho, North Dakota, and Montana, and Canadian Northern Plains in Alberta and Saskatchewan. Sourcing of the wheat is based on quality demands, market conditions, and delivered cost to the mill. Domestic shipments originate at stations on UP in Arizona and Idaho and California. Shipments from those origins move in manifest train service and comprise a minor portion of Barella's inbound durum. Approximately 80% of the wheat originates in the northern plains. 90% of the wheat originates offline. Barilla receives approximately 22,420 wheat cars and ships approximately 210 co-product cars annually. Starting with the 2014-2015 crop year, railroads serving the northern plains initiated a new dedicated train program. The railroads committed 75 to 80% of their covered hopper fleets to dedicated trains of 100 to 110 cars, changing the way they manage their grain-covered hopper cars. Union Pacific Railroad encouraged Barilla to expand the track capacity at Ames to accommodate 110-car trains. In the former configuration of the mill's infrastructure for unloading rail cars, Barilla would not have been able to turn around a 110-car train in the 48-hour window to comply with UP's scheduled switches on Monday, Wednesday, and Friday. However, with the track expansion and continuous motion scale, Barilla was confident they could turn a train in 48 hours. Therefore, Barilla made the decision not to spend an additional $1.2 million to expand the capacity of the unloading pits. On September 17 of 2018, UP announced the railroad's Unified Plan 2020, which is precision railroading. Subsequently, a UP representative told Barilla that UP may change direction in the future, trending away from unit trains, the first hit. In November 2018, Barilla took a second hit when UP announced changes to its demurrage and accessorial rules and charges. UP 6004 to become effective January 1, 2019, which included reduction of the demurrage credits from 2 days to 1 day for unloading. Needless to say, after spending $9.3 million on a rail-related CapEx project, Barilla was not happy with this potential change. With the current capacity of the unloading pits, Barilla cannot unload a train in 24 hours, and the cost to increase capacity of the unloading operation will require an additional $1.2 million. Barilla decided to do the rail expansion project, and UP signed off on the design. Barilla made this decision to expand its track and storage capacity based on UP and rail industry benefits proposed, including the flexibility to purchase wheat from any origin or vendor and buy wheat that meets Barilla's quality requirements and most competitive price. Reduced per car freight cost for 100 to 110 car trains versus 25 car units. Shorter lead times from origin to destination. Positioning Barilla to be market competitive and mitigation of the risk of running out of wheat and shutting down production. This project required the purchase of additional land, amount was $210,000, plus a capex of $9.3 million, for modifications to the rail yard and construction of additional silos to increase storage capacity from 20,000 to 30,000 metric tons. The project was recently completed in November 2018.
Can you hear me? I'd like to go through just briefly the design of a rail yard and how the UP sets cars into our rail yard. If you want to go ahead and go to the next slide. Okay. That's a picture of the rail yard as it sat before the expansion. One stipulation that the Union Pacific made when we designed the new rail yard was that the movement of the UP would not change. In other words, when they set cars into our yard, they didn't want to change their regimen. They wanted to drop the cars off in the same pattern as they did before the expansion happened. So this is the way the rail yard looks before the expansion. Go ahead and go to the next.
Could you just go back for a minute?
Sure.
So where's the track there? Is it?
Okay, yeah, that's a good question. Okay, the lead line comes off to the top right-hand corner or the top of the slide. We've got a 4,800-foot lead line coming into our property.
So that gray stretch is not a highway,
Yeah.
That's a railroad track.
That's the railroad track.
Okay,
Now,
all right.
yeah.
I see it. Okay, now I understand it. Thank you.
Okay, yeah, and the northernmost track is the UP east-west main line. It's a double track that goes clear across the state of Iowa. So what we did with our rail yard is we moved those switches to the top right-hand corner of the picture. We moved those east, that's where the new property was purchased, and we extended the three main long storage lines inside our rail yard. So go ahead and go to the next slide. Okay, so here's the left-hand picture is the way the storage looked before we added the steel hopper bottom storage tanks. And go ahead and go to the next slide. And this is the way the rail line looked. We should have got a little bit higher vantage point, but again, the two tracks that are that are darker in color are the UP east-west main line. The next two tracks are the storage tracks that the Union Pacific uses when they bring cars in. The north track on the White Rock holds 56 cars. The second track to the left holds also 56 cars. So there's your 110, 112 car storage capacity for loads coming in. The third track is for storage of empty cars. Once we unload the cars, we position the empty cars on the third track on the White Rock there.
Just, if you don't mind, just for clarification, so when a 110-car train is delivered, does the UP cut the train in half?
They do. They set the first 56 cars in, pull out, throw the switch, go to the second track, do the same exercise. And then, so what we do internally is we're able to grab 14 cars at a time. We've got enough storage on the west end of our facility to position 14 loaded wheat cars over the unloading pit. Prior to taking the cars to the unloading pit, we installed an NTEP, or that means in motion scale, so we never have to stop the cars as we're putting the cars over the pit. So we get it in motion weight, and then we unload those 14 cars, bring those 14 cars out, position them on the third track from the railroad's UP east-west main line, and go through that exercise until we have all the cars placed. And I'll make the comment right now, this may come up later, we do not or cannot release any of that unit train until all the cars are empty. So we're paying demurrage as we set with empty cars. So that's really all I was going to explain, is just the movement with inside our yard, and Sandy can go ahead and finish her oral testimony.
Okay, in today's testimony, I'll focus on three primary topics, and that's the demurrage rules and charges, the prepared for service charge, and UP operations and customer service. On November 5th, 2018, UP sent an email regarding changes to accessorial charges published in UP Tariff 6004 to become effective January 1 to, and I quote, to encourage the efficient use and release of rail cars. A significant change was the reduction of credit days for loaded and empty rail cars from 2 credit days to 1 day. The same rule applies on single car shipments and cars in unit trains. Barilla receives 100 to 110 car trains. Therefore, the shipper has only 1 day to unload a car or a train at its facility as opposed to 2, which has been the industry standard for decades. As stated previously, when Barilla committed $9.3 million CapEx to expand its infrastructure to accommodate unit trains, UP worked with Barilla on the project design, and the decision was made not to incur the additional cost to expand the capacity of the unloading pits because Barilla was confident it could unload a train in 48 hours. However, with the new facility design, Barilla cannot make the 24-hour unloading constraint. The primary claim under ICC Termination Act of 1995 that is at issue here is pursuant to 49 USC 10702, which requires the railroad to establish reasonable practices related to transportation and service. The question is, what is reasonable? In section 10702, Congress did not limit the board to a single test or standard for determining whether a rule or practice is reasonable. Instead, it gave the board broad discretion to conduct case-by-case, fact-specific inquiries to give meaning to those terms. Applying that broad discretion and ability to adopt rules of general applicability to the facts at hand, the board should find the UP's demurrage and accessorial charges addressed herein to be per se unreasonable practices. The UP tariff also includes a provision that if UP does not pick up or deliver a car due to UP's actions, an accessorial charge will not be assessed. Instead, under UP's standard demurrage program, UP would give the customer 2 offsetting credits for its operational failures in order to maintain a fair and balanced approach. UP also adopted a UR Next policy, so customers are notified to prepare for loading or unloading a train. However, it's been Barilla's experience that they cannot rely on the projected ETAs, and Barilla does not know actually what UR Next means. UP service is not reliable, and we are not talking about missing the ETA by a few hours. Trains have actually arrived 24 to 28 hours late. During that time, Barilla and the third party incur additional labor costs for employees called in to service the train. There have been a number of operational failures, yet Barilla has never seen credits when UP fails to deliver cars as promised and planned. There are a number of problems with the demurrage rules, and as a result, Barilla is faced with hidden costs that were not included in the cost-benefit analysis to justify expansion of the track and storage infrastructure. For example, when UP delivers trains to Barilla's plant, UP does not leave the locomotives with the train. Instead, locomotives are returned to UP service and a deadhead charge of $3,200 is assessed. Subsequently, when a locomotive returns to pick up the empties, a second deadhead charge of $3,200 is assessed. So for every unit train Barilla is paying $6,400. Removing the 3 locomotives was at Barilla's request due to asset utilization charge proposed by UP of $200 per hour per engine after free time, which was 1 day. Barilla concluded that the deadhead charges were less costly than paying the hourly rate for 3 engines. The deadhead charges are unreasonable because the shipper is financially forced to agree with UP's decision not to leave the locomotives with the train. We can only assume that the railroad's decision to return the locomotives to service is based on the railroad's operational needs, and there is a cost benefit to the railroad to have access to the locomotives for other trains that move while Barilla unloads its trains. The cost and potential cost benefit incurred by the railroad when deadheading are not transparent. So we do not know what's behind the $6,400 per train. However, because the shipper is financially forced to concede, and because deadheading is beneficial to the railroad, we submit this charge as unreasonable. Another addition to the tariff was a $400 prepared for train service charge when a car cannot be spotted or pulled because of shipper's actions. UP gave examples of reasons for this penalty. We appreciate UP's recent announcement to modify this rule to only apply per occurrence versus per car. However, UP did not go far enough. The PFS charge is immediately imposed even if the shipper is unaware of the situation blocking service, and the PFS could apply on individual cars shipped or received that are single cars or multiple car shipments less than unit trains. The PFS charge deprives shippers of a reasonable period to remedy the situation, and it is double dipping, so this charge should be terminated. In UP's announcement of the changes to the accessorial tariff, it stated, "Our top priority is to provide safe, reliable transportation for our customers. Part of that commitment is to maintain a fluid and adequate supply of rail cars and to ensure that all rail car assets, both railroad and privately owned, are utilized as optimally as possible." This is a noble goal. However, it seems UP is not participating in their own initiative. UP's service has not improved. The railroad misses switches, and UP's service and communications have become so unreliable that Barilla cannot plan for even an approximate arrival time. As a result, Barilla has incurred increased labor costs, scheduling crews to unload trains that arrive 24 to 28 hours late. Furthermore, a single missed switch can have a significant impact on Barilla's operation. As an example, on April 12 of 2019, the UP local switch crew did not switch Barilla's plant, which would have provided empty pressure differential covered hoppers for the Ames Mill to load Semolina. This missed switch, which was caused by UP, resulted in a shutdown of the Ames Mill for 49 hours. Shutting down a mill is lost production and it's very costly. There have been times when released empty unit trains have remained in Barilla's yard for up to 4 days before a UP crew shows up to pull the empty cars, thereby impacting on the railroad's equipment utilization. For trains that move in private cars, delayed pickup of the empties has a negative impact on the optimization of the private car fleet. Changes to rules, highlighted in this testimony are not fair or reasonable. While this testimony focuses on Union Pacific, these are issues not isolated to UP, but they represent attitudes and actions that are occurring throughout the rail industry. Union Pacific's UP 2020 plan and its consideration of potentially discouraging customers from shipping and receiving unit trains, unscheduled trains, after Barilla invested significant capital to expand its rail infrastructure and storage to accommodate unit trains, is a major concern at Barilla. This uncertainty and attitude of UP is a symptom of the disregard and disrespect railroads have for their customers. Barilla is a good, consistent customer that is local on UP. Unlike other grain shippers, Barilla's business is not seasonal. Also, the trains move in railroad cars that are furnished by the origin carriers, or they move in Barilla's private cars. So as a result, this is just hook and haul business for the UP. One of the questions asked by the board was whether or not these issues can be addressed in contracts. Initially, when UP located the plant at Ames, UP established the contract rates, but only for the initial contract term of 5 years or 2,500 week cars, whichever happened sooner. To our knowledge, the railroads in general have decided to only publish green rates in public tariffs. Therefore, when rates are published in tariffs, this is not an option. Changes to the rules highlighted herein are not fair or reasonable. While this testimony focuses on Union Pacific, these issues are not isolated to UP, but they represent attitudes and actions that are occurring throughout the rail industry. UP's 2020 plan and its consideration of potentially discouraging customers from shipping and receiving unit trains, unscheduled trains, after the customers commit significant capital to expand their rail infrastructure and storage to accommodate the unit trains, is again a symptom of the disregard and disrespect railroads have for their customers. Barilla cannot unload a train in 24 hours. As a result, Barilla either incurs demurrage costs or they spend the additional $1.2 million to increase the capacity of the unloading pits. The questions are whether or not 1 day for loading or unloading is reasonable, and if the same standard should apply for loading and unloading unit trains when it takes longer to handle 110 cars versus a single car. Current rules for calculation of demurrage need to be reviewed for potential change. Assessing debits for a full day when cars are, for example, released at 12:02 versus 12:01 simply does not seem right, as it does not seem fair to apply a full day of debits for only 1 minute. Considering the clocks of various people involved may not be in sync. So we encourage the railroads to reconsider their demurrage policies, or the board should launch an in-depth investigation of demurrage and accessorial charges. UP's rules seem to include some empty promises, including offsetting credits for operational failures, and the UR Next policy lacks substance when trains arrive 24 to 28 hours late. Barilla has not received any credits for operational failures, and the UR Next policy is not helpful and can be detrimental. Trains that arrive 24 to 28 hours late result in a lost labor cost for Barilla. We also submit that the deadhead charges assessed against customers are unreasonable. Barilla is paying deadhead charges for all trains received for unloading. Without a more in-depth investigation and analysis, it would seem that the railroad benefits from not leaving the locomotives with the train and returning the power to service while trains are being loaded or unloading. This assumption is supported by Mr. Rocker's testimony dated May 8th, where he says, "Not only is a consistent supply of rail cars critical to ensuring reliability, but having the right number of locomotives in our fleet is also important for consistent operations. Locomotives are costly to own and need to be utilized to their fullest extent. There is no foundation for the $6,400 charge." We commend the board for initiating this proceeding, and we encourage the board to initiate an in-depth investigation of the Class 1 railroads, demurrage, and accessorial charges.
Thank you. Miss, I don't know how to pronounce your first name. I
It's
don't want-
Denoja.
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 Thank you.
Good morning. My
Thank
name is
you.
Denoja Marianne Pillai, and I'm legal counsel at Northdown Industries and Normerica Inc., which is the Canadian affiliated company. I appreciate the opportunity to participate in the hearing. A little background on our business. Normerica operates 4 manufacturing facilities in North America, which are located in Dyersburg, Tennessee, Phoenix, Arizona, Brantford, Ontario, and Lethbridge, Alberta. We are the leading manufacturers and suppliers of various pet products, including our primary product, cat litter. The primary raw material is clumping cat litter is sodium bentonite, which is mined and processed in Wyoming. Due to the nature of the raw material and the volume requirements, shipments of the clay using the railway is the only viable method of transportation. Therefore, Normerica's reliance on the railway is a key component to its operations. Normerica regularly experiences business interruptions as a direct result of service-related issues caused by the railroads. Demurrage is imposed without establishing fault, there is no reciprocity, and there is no way to resolve disputes reasonably. The railroad's inconsistencies in service often cause a buildup of cars either at the railroad's yards or at our facilities, which inevitably cause increased demurrage and other accessorial charges. More importantly, Normerica does not have any control over bunched deliveries and are unable to avoid these types of service inconsistencies and the resulting charges. We are forced to either pay the increased demurrage charges or request an extra switch to ensure our facilities receive the necessary shipments to produce our products. In either case, the railroads profit from their own service deficiencies. Even with Normerica's team of employees tasked with strategically ordering rail cars, in 2018 alone, Normerica has incurred over approximately $470,000 in demurrage with CN, over approximately $220,000 with UP, and over $430,000 in demurrage and accessorial charges with CP. Additionally, shippers must unwillingly accept the service-related failures of the railroad, including their inability to stick to any sort of timeline. However, the railroads expect shippers to adhere to very strict and precise deadlines for reporting empties and picking up rail cars, or are penalized as a result. In recent years, Normerica has relied heavily on the Canadian Transportation Agency, or the CTA, in order to manage its service-related disputes and disputes related to demurrage and accessorial fees with Canadian railroads. One of the hurdles that Normerica experiences when challenging service issues in Canada is that when it is clear that the railroads are responsible for demurrage and accessorial fees, as well as delays in shipments, the Canadian railroads will place the blame on the U.S. railroads, since the shipment originates in the state of Wyoming and is first carried by a U.S. railroad. Up until this point, Normerica has not found a fair and accessible method of challenging these issues for the method of traffic in the United States. The railroads are not held accountable and do not face consequences for their completely unfair and one-sided practices. The absence of a fair and accessible process to challenge the railroads' exercise of power has led to subpar service. It has led to railroads' refusal to take ownership, over major service-related errors, including clear mistakes made by the railroads and delayed and missed shipments. There are no consequences for their service-related errors. A captive shipper's only option is to accept this subpar, unpredictable, overly expensive service, or else shut down its operations. Thank you for providing us with the opportunity to speak on these issues. I look forward to your questions.
Thank you very much. Bobby?
Good morning, Madam Chair
Good to see you
and
again.
Vice Chair and Member Overman. Nice to see you all again. Appreciate the opportunity to be here and speak to the board about issues facing our company. Once again, my name is Bobby Trish. I'm the Vice President and Regional General Manager for SA Recycling. SA Recycling is a full-service ferrous and non-ferrous metal recycler based in California, but we have 70 recycling facilities around the country: California, Texas, Arizona, Nevada, Georgia, Alabama, and Tennessee. We handle manufacturing scrap, appliance scrap, automobile recycling, demolition scrap, green waste, and even oil filter recycling. We process millions of tons of scrap each year, and this aids the domestic and international manufacturers by having raw materials to melt and make into new products. SA Recycling is also a member of the Institute of Scrap Recycling Industries. My job is I am the Regional General Manager for the Georgia business. In the Georgia business, we call it the Georgia region, but it's predominantly Georgia, but it's also 2 facilities in Alabama. But I'll refer to it as the Georgia business. It's 16 facilities. 14 of them are in Georgia and 2 of them are in Alabama. SA's Georgia region resulted in the acquisition of Newell Recycling, which was my family's business. Newell Recycling was started by my grandfather back in the 1930s as one little tiny operation. My grandfather was a successful entrepreneur, and he's the one who eventually, in the 1960s, came up with the idea for the automobile shredder and patented it. The automobile shredder is widely used throughout the world to handle obsolete, end-of-life metal products like cars and appliances. I want to thank the board for the time. It's been very informative to hear all the different people, and I appreciate you hearing our positions again. We do continue to face punitive demurrage and storage charges, and the railroads are failing to provide consistent service, and we just really don't see an increased benefit of the business from these higher costs. SA Recycling is heavily dependent on the railroad network for the transportation of our scrap between facilities and its customers. Our facilities we have about, in my fleet, we have 650 private cars. 400 of them are leased, and 250 of them are owned. Around the entire country, including the East Coast and the West Coast, we're served by the UP, the BNSF, and of course the Norfolk Southern, which is the only provider for my Georgia related business. During 2018, we collectively shipped a little over 8,200 rail cars. As a result of the serious service issues on the NS during 2018, and more recently as a result of the zero credit days policy, which took effect in January of this year, our monthly storage and demurrage charges on the NS alone have skyrocketed. The storage fees in January and February of this year were double and triple their already high levels, totaling $120,000 in January and $135,000 in February. Since July of last year, we now have an ongoing storage demurrage bill of $750,000. We have disputed these charges where we believe it's the railroad's own service was an issue, but many of these charges relate to empty cars for which the railroad offers no storage days, and they end up bunching up and coming to us, and these disputes basically remain unresolved. But it's a huge dollar amount that's out there that we're facing. Some of the demurrage charges that we've accumulated resulted from service problems and railcar bunching, like I said, that are out of our control. It is common for us to receive a string of railcars, far more than we can accommodate. And I tend to focus on our Doraville, Georgia facility, which is in Northeast Atlanta, because that's our busiest facility. There we have 14 car spots, and we are a closed gate facility. We've had situations where the NS will deliver or receive at their adjacent rail yard 30 rail cars at a time. And of course, when you can only take 14, you're going to be facing storage and demurrage charges in a best case scenario on the other 16 that came in. And if they ended up coming in on a Saturday at 2 a.m., you're not going to have those cars brought in and unloaded on Saturday or on Sunday until Monday morning. So it's structured for failure the way it is. In January of this year, the NS increased our service days from 5 days to 7 days. But realistically, we cannot expect our workforce to work 7 days. I think it's important to have 1 day off work. We work 5.5 days, which is what many people in the recycling industry do. I know that Ben does the same thing, who you heard from yesterday. It's impossible or it's not effective for us to bring in another crew to handle switching out rail cars on Saturday afternoon and Sunday. It just would be impractical. The unfairness of these steeply rising charges is amplified by the fact that we have made good faith efforts to accommodate and adjust our operations. We have made investments in our private cars. The NS came to us years ago and said, we're not investing in gondolas anymore. If you want to grow your business, you're going to have to buy your own fleet. And we started doing that about 20 years ago, and we've gradually increased that over the years. By 2007, 2008, when the financial crisis hit, we had already had a 450 car fleet. And that was enough to handle more volume than we're handling right now. So that fleet is right-sized. Last year, as I met with the NS to negotiate rates, I was not only using the 450 cars, and I was using about 250 system cars as well, and I was not getting the service I needed. Their response was, you need more cars. So I went back to our board, and I said, it's not getting any better. They're not investing in any more rail cars. We need to get our own cars. So we went to a company and we bought 50 more rail cars for $92,000 each, $4.6 million. And we leased from that same company 150 cars. So we increased our fleet by 200 cars last summer. So we now have a 650 car fleet. That investment is, as you can imagine, a disaster, because not only did we not need those cars, we would have been better staying with the system cars. But now we have too many cars. So what's happened now is we have taken 100 of those, or 106 of those cars, I believe, and had to pay to send them to off-site storage, just to relieve the supposed congestion in their yard. There's no way to get out of these leases. When you lease rail cars, you're not going to get out of a lease. We're obligated for these leases. The 150 rail cars that we lease for $550 a month is $82,000 per month. So almost $1 million a year. That's the lease. That's not even including the $4.6 million we spent on cars. We have investigated additional track space around our yard. I've included the Norfolk Southern Industrial Development person. I said, do you have any other space anywhere, anywhere 5, 10, 15, 20, 30, 40 miles? Came back and he said, there's nothing, because I don't have anything. So we've tried to come up with other scenarios, and even if they would have said, yes, we have a spot that's 10 miles away, there would have been a cost to that. There would have been transloading costs. We would have had to truck things over and move. It wouldn't have been like, oh, that's great, we have another facility. And where we are located, there's development all around us. There's no way to buy a piece of property next door to us. So it just simply can't happen. We recognize the importance of an efficient railroad network, but these improvements should work to the benefit of both. And when I'm talking about efficiency, I'm talking about their bunching or train building, which is a new term I heard yesterday, train building. So it makes sense. It's logical that they would want to put together the most efficient train and get it from the steel mill servicing yard back to the scrap yard. The reality, though, is, as y'all have heard and talked about, I can ship out 14 cars on Monday and 14 cars on Tuesday, and then on Monday I might not get anything back, and Tuesday I may get 30 cars. And putting those two together it's expecting perfection, and if there was a fair way of saying, look, we're getting a benefit of having this efficient utilization of our locomotives and our rail cars, and for that benefit, we're going to give you a couple days credit. So, turning to our West Coast facilities, which I need to also report on, we have service mainly from UP. We've had issues with the UP in El Paso and Las Vegas. There have been times when we've been notified about car placements happening after hours, after operating hours, but before midnight. That, of course, ends up meaning a day of storage, instant revenue for the railroad. You've heard this story from many other people before, but I think a reasonable free time period would help alleviate some of these charges. And then also the UP, their new policy of not prepared for service, I think, has some serious ramifications. This charge is basically assessed when the UP determines in its sole discretion that it's unable to pull the cars from the yard due to a customer's action, which can be made up or dreamed up. Once again, it's solely at the discretion of the railroad, and it's a recipe for a problem. Ultimately, the recent changes to the rules and charges have created a situation where the railroad customers are required to operate with a maximum efficiency and no margin for error, and we're penalized if we're unable to do so, where the railroads are provided maximum flexibility and are never sanctioned for their inefficiencies or failures. We believe there needs to be commercially reasonable free time and demurrage rules that incentivize efficiency for the rail system as a whole, rather than rules that force rail customers to dramatically reconfigure operations, lease their own rail cars in the storage track, but we've done it anyway, and pay higher labor costs to try to avoid these unfair penalties. We would ask that the board consider establishing requirements for the railroads to commit to reciprocal principles when they hold up private cars or disrupt customers' operations. We currently have a situation where the carriers enjoy a clear monopoly in the industry. They can make any operational tariff changes by exerting their inordinate market power over their customers. In return, businesses like SA Recycling are expected to accommodate these changes without any regard to the disruptions caused to our operations. We are simply asking the board to recognize our concerns and establish fair, reasonable, and reciprocal rules and principles regarding demurrage and accessorial charges. Again, thank you for your time and listening to my comments. I appreciate it, and I'm happy to answer any questions you may have.
Thank you all for your testimony. Sandra or Greg, I'll start with you. So you still have unit train service, which is good to hear, since one of the messages we've been receiving is
Yes, we do.
and was there any threat that you would have to go to merchandise, or that has not been on the table?
To manifest training.
Manifest, yes, thank you.
Even in the Union Pacific's opening statement, you may have heard this, and it maybe was kind of disguised, so you didn't notice it. In their opening comment, they said their focus was going to be the movement of all cars on their system to be as efficient as possible, not concentrate on trains. So that's one of our big concerns. Long term, we may have some tough decisions to make regarding adapting our system to be able to unload faster. That will depend on what you folks on the board decide to do. But long term, we have made this investment to be able to receive unit trains.
So I think before you spend the other $1.2 million to deal with a quicker unload requirement, you would want to make sure there was some kind of guarantee of continued unit service.
That's correct.
At least based on what we heard from ag processing and others, that a lot of investments have been made to establish the unit train facilities.
Yes. And so, that's really scary to us long term. We've made this huge investment, and we've had communications from the UP that have told us that they're contemplating moving to manifest traffic, and so it's not only the receiving of unit trains, but establishment of freight rates. They can adjust their freight rates to make unit trains not as feasible for us. And so that's what worries us long-term is, you know, their decisions and could be disguised in freight rates that would discourage unit train receiving from our side, you know, into our facility. So that's really a very big concern of ours.
But it does sound like from when you decided to build make the investment, et cetera, the over $9 million, like you certainly have had good discussions. I mean, there's a lot of communication with UP.
Yes, absolutely. But from the time that when we made that decision, Barilla does a lot of analysis before they make a decision. So we started thinking about unit trains back in 2015. The decision was made in late 2016. And so it's taken a while. From that time, the Union Pacific has gone through a wholesale change of management. And the people that we spoke to about our unit train unloading expansion project or plans are gone. All those people are gone.
Well, there are a row of very competent UP folks right behind you, a little squirmy but nodding, and I know that one of them will shake your hand before you leave the room, and you will have a contact.
And I will say that we will take the UP up on their comment when they made the comment that they wanted to work with their customers and try to find out or look at any potential ways to minimize demurrage. You know, I want to be the first to say from Barilla that we need the UP. We have to have them. There's no other way to bring durum wheat clear from the production areas of North Dakota, Montana, Canada. That's a long ways. You can't do that by truck. So we need the UP. In the first 18 years of my employment with Barilla, Barilla's been there for 21 years. The first 18 years were great. And I must say the last 2 or 3 years, not so. So we're willing and ready to get back to the quiet enjoyment of the UP service, for sure.
And just to clarify for the record, Sandra, when you mentioned some of the service impacts of late, you're not actually referring to any of the results of the flooding, are you? You were just, you aren't referring to any of the impacts of the floods as far as on the service frustrations that you have. It was before that time. Great.
I'd just like to follow up on this questioning that Ann led here. Because I asked these questions yesterday, just trying to get a handle on how companies like yours make an investment. So, from the way I understood the testimony, it was subsequent to the vortex problems in 2014, where you had, everybody had lost service, that you began to investigate the unit train facility and investing the $9.3 million. Is that right?
That's correct.
And you said the UP came to your place and helped or approved the design of what would work.
Yes.
So what I'm trying to get a hold of here is what kind of representations, if any, were made, or was it implicit? I mean, no one would say you should spend $9 million, by the way, we may cut you off in a month. So how did those conversations go? I assume there's no written promise.
Well, just based off of the freight rates that were in place at the time and freight rates, the through rates from the Durham growing regions were set in such a way that it made sense for us to make that investment. We also made the investment from a supply chain security standpoint where, you know, we did run out of wheat in late 2013, early 2014. Because of severe weather conditions at that time, but also due to the CP's change over to precision railroading, which really negatively impacted the service and the CP's decision on how to manage their hopper car fleet.
Well, what I wanted to get at, though, Greg, was what kind of assurance did you have if you would make a $9.3 million investment that the service, unit train service, would continue, or was it just a wing and a prayer? I mean, how does that work?
Well, the UP was encouraged us as a customer on their line to make this investment. We designed the plan, they approved the plan, it's called there's a process to go through, it's called the 10% conceptual plan. You have to submit that and have it approved. So, they were very encouraging that we make this investment.
Well, did they say, if you make the investment, we'll serve you long enough for you to recoup the investment? Or did they say, by the way, we're encouraging you, but we may quit tomorrow? I mean, how did those conversations happen before you write a check for $9.3 million? I'm sort of mystified.
Well, we thought that the freight rate spreads would stay in place. The industry in general sets up those freight rate spreads to be in favor of larger unit trains. That's the way the railroad industry has enticed grain companies and companies that use railroad in general to increase their capacity, and so that's why we made the decision, assuming that model to increase capacities, get larger unit trains, bring in larger unit trains would stay in place.
This is kind of a self-serving question, but would you say it was a reasonable assumption that you made based on past practices?
Yes.
Was there any discussion with UP about your unloading pit being able to accommodate a 48-hour turnover at the time, and they said that was sufficient?
The people that we talked to that were in management positions at that time knew exactly what our capabilities were.
And they said, this is fine, this will work?
They never mentioned the fact that they would decrease their credit days from 2 to 1. So there was no objection from the UP.
And at the time, it sounds like to have a larger pit to unload in one day was an extra $1.2 million.
That's correct.
How much would it be if you wanted to, or could you even change it today without redoing the whole facility? I don't know how it works.
It would be, it's been a number of years since the first study was done, but it would be probably close to that, probably a little bit more, just because, everything goes up in time, the materials and the labor. So, it would still be close to that same amount now.
And as I understand it, the $6,400 each for the two ways for the locomotives is because if you could unload it within 24 hours, you wouldn't pay that $6,400.
That's correct.
They'd leave the locomotives there, I gather.
That's correct.
Are you paying for the cars as well as the $6,400?
Yes, we're paying demurrage on the cars as well. As I stated earlier, we can't release any of the cars until all the cars on the unit train are empty.
So what is that? How much are you paying per unit train on the car demurrage?
Yeah, in our yard, it's $100 per car per day.
So you're talking about $10,000 on top of the $6,400 for the second day. So every unit train to unload with the 24-hour rule adds a little more than $16,000 to your costs.
That's correct.
So the debate in your...
Full year increase just due to demurrage, not including the deadhead, is $240,000 a year for us.
So, yesterday, I don't know if you were here yesterday, I spent a lot of time trying to figure out what it is the railroads are trying to incentivize shippers to do. I guess the UP would say, listen, if you spend $1.2 million, you can avoid $240,000 a year and you'll get your money back in 6 years. Is that the argument?
It is.
And you're saying, yeah, how do I know you'll even serve me in 6 years?
Well, that's right.
Has UP offered to guarantee you unit train service if you spend the $1.2 million?
No, we went to the UP early on when we talked about expansion, and we asked for what their appetite was for a contract to keep us, to keep our expansion at Ames, Iowa, because we also have a pasta plant in Avon, New York. However, as Sandra said earlier, we don't have a mill in Avon, New York, so we really wanted to expand at Ames, and so they at that time they never they never expressed interest in establish a contract with us and have not since.
So as a business person trying to figure out how to invest your capital, as you sit here today, you may not want to reveal this, but as you sit here today, how can you make a decision as to whether it's worth it to your business to save $250,000 a year by investing $1.2 million? I mean, with no uncertainty. Are you just playing it day by day, or what what process are you going through?
Again, I think that when we'll decide what we're going to do longer term, when the board decides what you may suggest that the railroads do. We'll have some tough decisions to make as to how we want to proceed. That's for people to decide that are higher up than me, but I think we need to make some decisions down the road, but I think it will depend upon your actions and what your suggestions may be for the railroads.
It just strikes me that, I'm sorry, Sandra.
The unit trains basically originate on other railroads. So they're interchanged to Union Pacific. Union Pacific has common obligations, so they have to bring the unit trains to Luella. Like Greg said, the way they could discourage that would be through adjusting
Change the rates.
the rates.
Well, this is very helpful because I'm trying to grapple with, what kind of, you actually have a physical choice if you want to spend money.
Right.
Bobby, Ben Abrams did not. But you've still got to make the decision. And with a lot of uncertainty, that's what seems to me the biggest issue is the uncertainty. I mean, it's
Right.
a big, aside from the money.
Right. I also want to bring this point up is, the Union Pacific knew fully well that we were making this big investment, or that we had made this big investment. I'm sure during that time they were talking about going to Precision Railroad, and maybe there's something that where they could not come to us and say and give us advance notice of what they were thinking about doing. I don't know, but we didn't hear any before sometime on September 15th or 17th. Was the first time we heard about them migrating to this new precision railroading model. And then, of course, we didn't hear the impact of the cost until November. So here we're sitting, we made this big investment, and now we hear that this is going to happen. Then we find out the impact of the cost. In some circles, they call that a bait and switch. And so I'm just...
Yeah, here it sounds like bait, but you're not getting the switches.
But I mean, it's just, and I really, in past history, the UP's done a very good job for us. So I'm not here to disparage them. I'm just trying to explain what's happened to us.
Very, very enlightening. Thank you. Go ahead.
I have a follow-up, kind of a little bit distinct from kind of the past investment, but kind of going forward and assessing what's reasonable. As the board's kind of thinking about what's reasonable, should it be thinking about, okay, so in order to avoid demurrage, whatever the incentive would have for you in order to avoid it, sounds like it's a $1.2 million cost to avoid that demurrage. And that's what I guess the incentive's designed to do. And the reason why they want the incentive is there's going to be some sort of benefit to the rail network, which will go to UP, but also other customers. Mm-hmm. So do you all view a good way for us to be thinking about this is, okay, how much is that benefit to UP and the other customers versus this $1.2 million? And if the benefit, particularly not a particularly congested yard, they're not really much of a difference when it comes to network performance, isn't that great? That $1.2 million, that incentive effect really isn't reasonable. Is that a way to think about it?
Yeah, well, one potential solution.
Can you mic it?
Turn your mic on.
There you go.
Okay, there. Sorry. One potential solution is to consider different free time, definition of free time for unit trains versus single car. obviously it takes more time to handle a train than it does to handle a single car. So maybe there should be different definitions if they want to go to, 1 day. Maybe that makes sense for shipments that move in manifest train service, but it doesn't make sense to expect somebody to unload a train or load a train with 110 cars in 24 hours.
But suppose, for example, a railroad, just hypothetical, a railroad could show, if someone were to just make that investment, it would really free things up. This is a very congested area. It's going to benefit all these other customers. We just really need to incent that person to make that investment. Is there ever a scenario in that context where actually it would make sense to make the investment? Maybe not for you all in this. It sounds like what you're saying is it's not. But could you imagine a scenario where it would make that incentive driving that investment would be a good thing for the network and other customers?
Well, the world's changed recently. Back when I I actually located 5 100,000-ton dry bulk warehouses for potash in Iowa. And this was kind of common in the industry when someone's locating on your railroad or expanding their infrastructure to handle trains and so forth.
Mm-hmm.
The railroads will participate in that cost.
Right.
And what you would do is figure out just a potential 50% of the cost you're going to invest.
Mm-hmm.
And you would take that and with the forecasted volumes, amortize it over a 3 to 5 year period and give the customer a per car allowance. The railroads don't make any commitment to the customers now. And it's been my experience. I talked to basically all the class 1s about this very thing except KCS. And it's just something they don't do anymore.
And I am hearing kind of two different issues that you're raising, and both important. One is how to make decisions going forward, and then the other is how to treat this situation of past investment. Mm-hmm. And so I appreciate what you all are saying. Can I ask a question of Ms. Merriam? You had, in your written remarks, you had an interesting passage on Canada. The Canadian Transportation Act, and I think you mentioned final offer arbitration as a way of not only addressing rates, but also issues of practices and charges and such. And so I'm wondering if maybe you can give us a little bit more information on how final offer arbitration works in the demurrage context, and a final offer process generally. And whether or not that's a good way to resolve disputes.
Sure. Well, most of the time, final offer arbitration in Canada is used for more of the rate aspect of it, but demurrage could be a factor in it. So because you can incorporate the tariffs or choose not to in your final offer. So when you put out your final offer, it primarily for the rate, so you would set a rate and you wouldn't know the other party's rate. And you can incorporate which tariff you want and which tariff you wouldn't want included in your final offer. And then the arbitrator would determine which is reasonable and which is unreasonable.
And that's kind of interesting because, how would you necessarily know what your demurrage is going to be when you incorporate it into your rate structure? Like, I get that you have the terms of the tariff, but that's going to be variable based on a variety of factors on the railroad end and the shipper, and whereas the rate, for transport, it's a little bit more predictable, I would think.
Yeah, I think it's you can kind of predict it based on how much you would be getting and what you would be ordering based on the rate.
And would you look to historical averages, perhaps? Or?
Yeah, it would be more on a historical average. And when we did go through final offer last year for a rate, we did incorporate demurrage, and we did discuss it during our final offer.
So, if I'm hearing you correctly, it's a standard practice in Canada that demurrage is considered for a reasonableness of rates, and that there are established practices for doing so.
I don't think it's standard practice, but it is considered.
And you all did that?
We did that.
Okay. And is it your view that overall experience was a good way to litigate things?
That's a difficult question. I wouldn't say it's the best way to litigate things,
Yeah.
but I think it helped. It's better than
You don't have. Okay. And if I could turn to Bobby, you mentioned a couple things. $4.6 million investment, I think I heard, in
Yes, sir.
cars, and just this thing we've heard quite a bit. This movement from, and it's obviously borne out in all the information from that the movement from system to private cars. And you also said the most helpful thing I think I heard was more free time.
Yes.
And the private cars with the railroad that I think you're focused on is the private cars have less free time than the system cars.
0.
Yes. And if you were to have a system car in your exact same situation, you would have 24 hours.
Yes, sir.
And so if in this particular case, where somebody has 0 free time, if a private car were treated like a system car, that would greatly alleviate a lot of your problems.
It would.
And in your discussions with the railroads, if to the extent that you've had them on this topic, I know you've had discussions with them on demurrage generally. If you were to say, hey, why don't you treat, notwithstanding what you say in your recent tariff changes, why don't you treat my car like a system car? What would they say? What is their best argument back to you?
Well, I haven't asked that specifically. I've certainly had lots of discussions with them because, as when we met before, I told you I genuinely like our Norfolk Southern people. I've dealt with them for 17 or 18 years, and I genuinely like them. They're likable people. I think, if I can say this, I think Wall Street has probably encouraged them to overreach as a negotiating tactic, and I think going from 5 to 4 to 3 to 2 to, I don't know if somebody said, well, let's go to 0. What's the worst that can happen? Somebody will ask us a favor and we'll go back to 2 and everybody will be happy. I don't know, but I think the overreaching is so significant that I haven't asked to say, well, can we just go back to 1? Can we just go back to what you treat the system cars at? So I haven't asked that. I've said you guys should have stayed at 2, and there's been some.
Yeah, but it sounds like from what you're saying today, obviously you'd prefer 2, but even 24 hours would be much improved for you. Would alleviate most of the problem. Give me a sense of how 24 relative to 2. I mean, obviously, again, stipulating that you want 2.
I'm negotiating against myself.
Right.
So,
Yeah. Right.
I think there was a long time that 5 was the number, and I'm not saying we need to go to 5, but 5 days allowed for the railroad and interchange with us, and it's historically inefficient. They've done great work to become more efficient, but there's still inherent inefficiencies in the process, and a lot of them have to do with the first mile and the last mile. We watch rail cars, and you can see rail cars, 2 different rail cars on the same day that are released from the steel mill. They go back to an NS yard. One may go directly back to Atlanta. The other one may go to some other state. Mm-hmm. And it's like, well, why does that even happen? Well, it's because that car got stuck in between some other cars, and they didn't want to stop and break it apart and bring it back where. So it's for their convenience.
Right.
And that makes sense. But to think that 0 days credit implies perfection.
Right.
And I think we're being held to perfection. We work lots and lots of hours and we strive for perfection. I think it's unrealistic to go below.
Well, and it sounds like from other testimony that you can actually have operational perfection, but just the natural variability in transit times, you may still get a bunch on the back end. So the railroad could be perfect, and the shipper, or I should say the receiver in this case, could be loading and unloading as fast as they possibly can with every single one of their spots, and you still could have demurrage.
That is correct. Because of the bunching,
And that's
and
the
once again,
incentive effect I think we're getting at.
I
Is
acknowledge
that how is that incenting changes in behavior if everyone's operating perfectly, and in a perfect scenario, you still have demurrage?
That's exactly right. And we respect the fact that train building or bunching makes sense. But, one way to argue this is say, if I ship 14 cars, then you shall not return more than 14 cars back to me. They're going to go, whoa, no way. We don't want to have our hands tied.
Right.
We want to be able to run our business and ship
And
cars
there
the way
are
they
good
go.
operational reasons why things might be bunched together.
Correct. And so having those 2 days is not admitting that we're not efficient, because I contend that we are absolutely efficient and we're on the top of our game. I have one lady who does nothing but handle our cars. I mean, it's like I always just say thank you so much, because she's a miracle worker. And I'm like, so where are these cars? She goes, oh my gosh, Bobby, I got these going here and these going here, and we used to be able to manage our fleet better as well, because we could reroute cars. But part of the new tariff is now if you don't have more than 2 rail stations between where the car is and the destination, you're not able to move the car. So there's lots of things that have been put in with these tariffs and changes that make us less effective and less efficient at being able to perfectly receive every single car that comes back and ready for constructor placement.
And so at this point where I think that, because we've heard it a number of times, and, there are additional railroads going today, but, I haven't seen from the other railroads that are left to testify, I haven't seen the same complaints, and I haven't seen the zero free time practice. And so one of the things I really commend the folks from UP yesterday and Kenny Rockers coming back up when there was quite a bit of questions on the unit train practices, and came up and brought some additional light to the issue. And I think all of us appreciated that very much. And so if I could be so bold as to say that, listen, there are repeated at every single panel about zero free time, operational perfection and still leading to demurrage, as well as people not understanding why private cars are treated different than system cars. So I would encourage the representatives from Norfolk Southern who are here, if they would consider at some point today, in the similar manner that UP did, and in the interest of finding constructive solutions in light, whether it's a representative of NS or someone who works for NS, to come up here and perhaps consider shedding more light on the zero time practice, particularly as it relates to bunching and differential with system cars. And again, this is in the interest of clarity and constructive solutions.
And I'd also like them to talk about the congestion charge if they choose to take us up on that offer. Demurrage, could I ask you a quick question? In your testimony, you indicated the amount of demurrage charges for the 3 carriers that occurred in 2018. I'm curious if you have any year-to-date stats, given a lot of changes since January. Do you know, are things looking like they're doubling and tripling, or static, or what?
I don't have that information on me right now, but I would say it's probably going up, but I would have to confirm that.
All right, and then it's also, these charges are based on the U.S. operations, or both U.S. and
It was
Canada?
both. It was both. Yeah, it was primarily due to the bunching from the U.S. to Canada.
Or at least that's what the Canadian carrier said?
Yes, yeah.
Just to quote you.
Yeah, sorry.
And then back to the conversation you were having with Patrick about the final offer arbitration. Could you just give us a sense of how much time that took?
Sure. We initially filed for final arbitration during the process that we went through in August, I believe, and we had our final offer actual arbitration in October. So it was, and throughout that we had a few pleadings and different issues that came up, but it was, I would say it's roughly half a year.
And how quickly did you get the response, the answer, the decision?
It was relatively quickly, I would say a month or two.
And it's confidential, isn't it?
It is, yes, it is confidential. But you can publicize, it is publicized, but you can redact certain information. So all of the pleadings are online.
All right, thank you.
Just a few questions, and those you to follow up. I was trying to understand as well the demurrage charges. So CN is going to be here shortly. The $477,000, is that demurrage charged in Canada?
Yes, it's in Canada.
So none of that was incurred at your plant in Tennessee?
I believe it was split between the two.
But, so I'm not clear, CN, I assume, is not delivering these cars to the
CN is delivering to our Tennessee plant. It's our end carrier at Tennessee and in Brantford, Ontario.
Oh, it is,
Yeah.
okay. So, but not, you're saying not all of the 477 is incurred. The reason I'm asking you this is that as much as I'd like to consider the rest of North America, when CN gets there, I want to talk to them about what they're doing in this country. So some, but not all, of that 477 is a result of charges based on what's happening in Tennessee.
Yes, that's correct.
And is all of the basis of these demurrage charges bunching? And therefore, as I sort of skimmed through your statement, it sounds like as a result of bunching, you need to keep cars longer because you have more unloading to do than if they spread them out.
Yes, I wouldn't say all of it is due to bunching. I would say the majority is due to bunching.
Right.
And yes, you're correct. We would have to have it longer just because we would get it all at once. We would get it on a Friday, and we would not have enough time to produce.
And when you tried to challenge that at the CTA, and the CTA said, we're not going to deal with the part of it that's in the United States?
Yeah, they don't have jurisdiction for any portion in the United States.
So have you contested that portion of the CN charges directly with CN?
We have, and they would blame the other carriers. So we asked to bring all of the carriers in and sit down and discuss what is happening with the bunching, and because we are missing information. We don't know the information of when the interchange happens. Who apparently there's one carrier notifies the other carrier when the cars are available. We don't have that information, so we don't know who's bunching it, when the bunching is happening, what is occurring. So we're missing information. So they're reluctant to sit down and discuss with us.
Well, is it CN's position when you contest these, is this still pending, the dispute with CN?
No, not that I'm aware of.
They've rejected it.
I believe so.
So do I understand it this way? CN says, it's not your fault, and it's not our fault, it's some other carrier's fault, you pay anyway. That their position?
They don't say it's not our fault. They usually also blame us, and they also blame a different carrier. They just choose to not accept their fault, any fault on their own part.
Well, let's assume they aren't at any fault
Okay.
for the moment. They seem to be saying, even if it's another carrier's fault, you pay.
Exactly, yes.
And have you said, no, make the other carrier pay?
They want us to prove that it's not our fault.
They just put the burden on you to prove what the other carrier is doing. Is that what you're saying? And on what basis do they say part of it's your fault?
Well, sometimes, I think when we do order cars, sometimes it is our fault, and we would accept some of the charges. That's completely our fault. So
In what way is it your fault?
when we order too many cars or at one time, and we have extra cars sitting there or we aren't producing fast enough, so we do have extra cars.
So sometimes you just misjudge how many cars you
Exactly.
need? And are you able to sort out which parts are attributable to what you've done and which are attributable to some railroads bunching?
We have tried to our best ability, but majority of the time it's as a result of bunching. Because we do strategically order cars, and we know how much each plant needs to produce what we need to, our input.
And in your dispute process with CN, do you provide them with this evidence to say, look, of all these incidents, we overordered here, but the rest of it we didn't, and they say, we don't care, you pay anyway? That's what I'm trying to get at here.
I'm not sure if we did that with CN, but I know with CP, we did when we sat down in Canada with them, with the Canadian equivalent. We just basically had an entire spreadsheet created of what we were ordering, where it was getting bunched, and what we were receiving, how much demurrage occurred. And because we were missing that information of the interchange, they essentially didn't consider it, and they wanted us to bring more information to the table, which we weren't able to obtain.
You'd have to do some kind of formal discovery process, I gather, to get data from the other railroad, from the
Exactly.
interchanging railroad. But that's the Canadian problem. Is all the CP 430,000, was that all in Canada?
I believe so.
So, all right, well, I'll pursue it further with the railroads, but, you know, we're grappling with this idea of incentivizing. There's no incentive that would cause you to be able to control what some delivering carrier is doing with bunching. You can't do anything about it.
Yep.
So making you pay doesn't help the system. Is
Exactly.
that a fair statement?
It is.
Bobby, I just want to clarify a couple things. First of all, before I ask you a question, I'd just like to note that one of your grandfather's shredders is in my ward in Chicago. And it's a very impressive operation, but the reason I know it's there is that it occasionally shoots out big chunks of metal into the backyards of some of my constituents.
Yikes.
And they made that clear to me.
On the advice of counsel,
But Marty remains unbiased.
My former constituents, it's not your yard, and the yard's moving, finally.
I know which one you're talking about.
Yeah, it's quite an impressive operation.
Yes. There
And
are
actually, they're family friends, actually, the owners of that, so I can feel free to say what the facts are. I just wanted to make sure the record was clear here. You know, I went into great length with your counterpart in Harrisburg yesterday. You seem to be physically in a similar situation, landlocked in terms of being able to spend capital if you wanted to spend it. It doesn't sound like that's an option for you.
correct, yes, sir.
So if you tried to separate out the effects of deliveries from PSR from the reduction to 0 days. In other words, if you had, sort of to follow up what Patrick says, if you had 1 day, could you avoid all of these demurrage charges?
I didn't do that calculation. I asked the lady that works for us, if I asked her the question, if we had 2 days, what would happen? And I don't know the percentage, but the vast majority go away. So in other words,
With 2 days?
With 2 days. I did not run the calculation with one, but I said, go back and run it. And she said, yeah, they basically all go away other than those that we may occasionally do to ourselves.
So the bulk of that 750,000.
Yes, sir.
So if we're trying to say, where's the pressure point in the system? You seem to have no place to move over here to spend unlimited capital if you had it. And over here, it's the railroad having to give up from 0 to perhaps 2 days to resolve this problem. That seems to be the options.
Yes, sir.
And I say this so facetiously, but only partly facetiously, if Wall Street has moved them from 5 to 4 to 3 to 0, 2 to 0, is the next move to -1?
I wish you wouldn't have said that.
You think they needed to hear it from me to get that idea in there? All right, I just sort of, so again, the $750,000
Would
is
go away.
no incentive. There's nothing you can do to avoid it.
That's exactly right, and that's what I was trying to say.
So
There-
that it's all,
revenue.
it's all revenue. It doesn't fulfill the purpose of the demurrage statute to make the system flow, because you're, to accept Patrick's premise, you're operating, if not in perfection, you're operating as efficiently as a business can.
I take a lot of pride in the way we operate. We have really good people that are not only thinking, they're proactively and predictably thinking about, oh my gosh, what could happen. We're analyzing rail cars and movements. I think we do a really, really good job.
They're not sitting around with their feet up eating barbecue and not
No,
eating
sir.
shred.
Which is why I've come to my personal conclusion, which to me is just that a negotiating tactic has been taken to an extreme and a compromise back. I think that's the solution. That's
Yeah.
my personal 2 cents.
And if I
Thank
could
you, yeah, thank you, Bob.
Yes, sir.
And just quick, just in the interest of fairness, I think both Ms. Merriman and Mr. Rich, you both touched on something, which is it's not the case that when a bunch of cars in some sort go back to the facility, a bunch of empties that outstrip capacity, it's not the case that it's not your fault. In other words, there are some bunches, because you order too much, where it is your fault. So it's kind of tricky because
Not
sometimes
us.
what?
Not us. We don't order.
So when would talk me through an example where demurrage you would rightfully get demurrage? Is it
Okay.
just on the loading and unloading?
Okay, so a case where we would rightfully have demurrage
Yeah.
is if we have a scheduled outage at our plant and we
Okay.
have no product to ship.
What about? But Ms. Merriam, you said sometimes you order too many cars,
It doesn't happen that often. I was just giving an example.
and I'm not saying it happens often, but I'm just in this. Let's say you both never did that, but let's say there's a hypothetical example where you may have ordered too many. How could we differentiate the case that I've kind of been using, over and over again? Probably people are sick of it, which is the 5, 5, and 5 on 3 separate days that come back for a facility that has 10 spots that come back as 15. Okay, that one, just natural, the way I've been describing it is natural variability in transit time plus efficiencies with railroading. It comes back as 15, outstrips capacity. That's just a cycle time back. Everything's cycling back, all right? Now, talk me through that, using that kind of hypothetical or however hypothetical you want, about when a bunch would be the fault of a receiver.
I don't know if there would be an example when bunching would.
I don't mean, maybe just get away from the term bunch, but
Okay.
just too many empties relative to your capacity. How would we be able to verify that that was your fault? Not your fault, a receiver's fault.
I would say, so having too big of a fleet, if you have more cars than you can have in your fleet because of ups and downs in the markets, you have to respond by sending excess cars to off-site storage, which we've done, as I told you, about 106 or 110 cars. We acknowledge that we have too many cars in our fleet, so we've had to take actions. That's not instantaneous. That can't happen one day.
So, normal, I'm sorry about that.
But so, and just furthermore, I mean, going back, the Doraville yard, the NS yard that's adjacent to us,
Sure.
historically, and we've had storage issues in the past. 4 or 5 years ago, we had an issue that really had to do with, we went to open gate because they wanted us to be open gate. The problem with that, the crews wanted to supply cars LIFO
Right.
instead of FIFO.
Yeah.
So I had some cars up at the very front of the yard that didn't move for a year.
And
so-
something we haven't talked
we-
about as much, but the LIFO FIFO issue is important. Yeah.
So we went back and forth with them, but
Yeah.
and the way we ultimately settled that peacefully, amicably with my counterparts at the railroad was, look, Bobby, we think that you having 85 cars in our yard is the right number. Meaning that's about 5 days. I'm telling you the conversation 4 or 5 years ago. And so they said, look, so maybe what we could do is if you ever have more than 85 cars in the yard, then you acknowledge or you stipulate that you have too many cars in our yard, and then we're going to charge you. We bantered that back and forth. He took it up the ladder at NS, and somebody didn't like that, so we didn't end up doing anything with that. Today, we're asked for that if we have more than 28 cars, which would be 2 days of switching, if we have more than 28 cars that were causing congestion, to have zero demurrage. we would have 14 cars because that's all we theoretically could take in one day.
I hear you. But so I want to get back to that. I want to quick just make sure we get the LIFO, FIFO, because it's not an issue that we've talked a lot about, but it's been mentioned, I think, in 2 other testimonies. Is it your view that cars that are fungible should be treated kind of neutrally for the purposes of demurrage, if you know what I'm trying to get at, which is that regardless if one, came in earlier and the one came in later, but the later one's easier to get out, you basically, can transfer that so you're just not continually getting demurrage.
Yeah.
If the cars are fungible, that is what a reasonable practice is.
Yes.
Okay. All right. Now going back to the example, it is just an interesting scenario though, because all right, so you have the 5, 5, and 5, and then you have the spots for 10, and then 15 all come back. How, and what I gathered from what you're saying is, okay, so you're going to get demurrage on that 5, and you're going to be loading and unloading the 5. But if you were to say reduce your fleet to 10 and just do 10, you would have a car shortage for that 3rd day of loading. If you're tracking with me.
We would. We have to have more cars to make up for
Right.
the way cars come back.
Okay, but now take a scenario where a fleet is too big. Right? And so that's what I'm hearing you're describing. Here's demurrage that our fleet has just been too big for the normal cycle times. And so we're actually using railroad capacity and in a way that there should be some sort of incentive for us to deal with that. Okay, how would we know, when somebody's fleet is too big? Do you know what I'm saying? Like when we're thinking about the bunching issue, it strikes me that some bunching is going to be because people's fleets are too big or they're making too many empty car orders or something. And some bunching is going to be, listen, things are going great, but there's just outstripping capacity due to natural variations. And what I'm struggling with is how to differentiate.
Sure. It's inevitably messy because of normal changes in, there could be weather-related things, there's railroad-related things, there's breakdown-related things. The best way to do it is acknowledge that it's never going to be perfectly timed where the cars are going to get released from steel mills to the railroad to building a train to back on a just-in-time basis. We are going to be forced to pay, if there's 0 credit days, we will be forced to pay more money for having provided a fleet to do business with the railroad. And I think most shippers probably have good relationships with their railroad partners. I'm just assuming that. But the way it would have happened, or not in the past, but even right now, they would say, hey, you got more cars than we need in our yard. What's going on here? Yeah, we're charging you demurrage, but you need to move some cars out. And that's what happened in February after we had $130,000 or $135,000 bill. It's like, okay, you guys are now moving cars a lot faster. We got more cars than you want in your yard. We are now going to have to make arrangements, and we had to go negotiate a deal. We had to send cars to storage. You have to pay the freight to get them to storage. You don't get to use your empty move to take them to storage. So that was another $100,000.
So
Sorry.
no, it's very, very helpful. So to kind of put one way to look at it, just to kind of summarize, one thing that we're hearing is, the board ought to think that 0 hours of free time is just unreasonable, right? Because of the natural variability, right? And then, is another way to think about it that 0 free time should be presumed to be unreasonable unless the carrier can establish, that for what either, there's capacity in the ship relative to what the shipment size is, and are there, is there something that where 0 hours free time the carrier could overcome and actually show that something actually could be reasonable based on what the actual capacity is? Like, in other words, presumptively unreasonable unless on a showing that it could be. I'm just thinking about ways that people are telling us to think about this. And I know what you're telling us is that for your case, 0 is always unreasonable. But you know what I mean? Is that
I think
is it possible that
I think anybody who would come and say 0 is reasonable is not being truthful or not really looking and doesn't really granularly understand and watch the movements of rail cars.
Or they could have a lot of capacity relative to their shipment size.
That's correct. I truly believe that, and I believe that, and I'm telling you the truth.
Thank you all, really super helpful, very informative, and we will call up panel 10. All right, now we'll be on panel 10, and why don't we start with Steve?
Thank you. Honorable members of the Surface Transportation Board, thank you so much for holding the hearing today. We really appreciate it. I was just telling some of my colleagues, in the first part of March, I was with our Transportation Advisory Committee. 95% of them are rail customers. And we had rail demurrage on our agenda. And we talked about how we help our members file complaints on demurrage charges. And if we had one continuous theme to run throughout all of those complaints as a proper resolve to this situation, what would it be? Well, little did I know, 10 days later, I'd be notified that you were held in a hearing. So it was kind of strange that it all happened. And I'll just tell you something a little more about the association. We were formed in 1891. 25 warehouse guys got together to discuss rail demurrage. Here we are 128 years later, and we're still talking about it. And it's just kind of an interesting thing. And I'm just going to kind of bottom line it a little bit to say some of the things here, but bottom line is we really believe the resolve from the people that were in the room, that the resolve is define demurrage as after actual placement, 48 hours to unload. We have members that unload grain in bags. We have them unload chemicals, lots of boxcars, lots of food. Just about all of our warehouses are food grade, sanitary. It's important that when we receive a boxcar of goods that it is intact. Sometimes they're not. More so since there's been more bunching, because the more times you slam into that car, the more the load shifts. So there are lots of issues for us. And when I say actual placement, what do I actually mean? For a shipper, and I might even suggest that the STB might want to create a key performance indicator of these so that you can develop hard data that's verifiable. Right now, it seems like all the data we have, we beg for from the railroads. And this would be verifiable from shippers and receivers. And it would be at the door, released from the door, time and date, and then at a receiver's door, at the door, date and time of release. That gives you hard data to compare up against. And you don't have this thing where, in one of the statistics I heard from the railroads, well, 73% of our loads are delivered on time. Well, that's on time to the local yard. What good is that? That doesn't help the car get unloaded. That doesn't put the car back in service. It doesn't do anything. And we talked a lot about last mile. And it is in the last mile. It has to get to the door, and it has to have a crew and stacking equipment and all kinds of stuff available to the warehouseman in order to do that. And so absent that, there's nothing that our receivers can do to do it. And I just go through it. You know, we talk about control over the cars. Who has control? Because without control, you can't do anything. Nothing. And for us, until it shows up at the door, we have no control. We can't get it there. Nor can we get it back in the yard afterwards. We are totally reliant on the railroads to do that. But they seem to have a different system. They think once they get to the yard, we start into system 2. Well, shippers aren't paying for system 2. They're paying for the load to be delivered to the receiver. Period. So, you know, I hear all of the things out there about demurrage and time and dwell and everything else, and you can read my written material, and it's very specific. And fortunately, I was playing devil's advocate with our own members, same as the questions you're asking the group. Asking them about this and asking them about that, and how's this work and how's that work. And the only thing that we could get, I could only get 75% agreement in the room that actual placement 48 business hours would work. That would work. I talked to him about 24. I did not talk to him about 0 because that's outrageous. And we all recognized that was outrageous. So I talked to him about 24. Well, it all depends what they're unloading. If they're unloading grain, they can't unload a car in 24 hours. If they're unloading everything on a pallet, it might take them 2 hours. It just depends what kind of loads they're getting. Well, they don't know what kind of loads they're getting. So how do you set a rule or best practice and put it into place without doing that? So I just wanted to let you know that. We have no control over the railroad's tariffs. We have no control over when they change their tariffs. But you do, as the STB, and the warehouse has no control into the when, how, or the timing or anything else of that. So again, I just suggest if we could get a date and time stamp on those 4 indicators, it could be verified outside of the railroads, and you would have concrete data. And it would be very measurable concrete data. And if you're going to make decisions in the future, we have to do data. And we're all big data today. Everybody's big data today. Oh, by the way, I was sitting with some receivers out in the audience, and they're all watching to see what cars are arriving. They're getting it on their phones. They're watching it. They're going out in the hallways making calls about making sure, because they're here, they want to make sure they're doing it right. And they're all doing it. They're active members in this. They want to serve their customers well. Their customers are the shippers, because they get paid by the shippers, and they don't get paid until that car is emptied. They cannot bill it until it's empty. So they have no investment in anything up to that point, although they can be penalized. And I don't like it very much when they're penalized, when it's like, I got my hands tied. You know, I've got service days, but I don't get delivered. I only get delivered 2/3 of the time. I ask for more service days because I got 15 cars in the yard and I've got 5 doors. I need another service day. I don't want to pay more demurrage. I don't want any demurrage charges for my shipper. I don't want any of this. How do I get another service day, et cetera, et cetera? So I asked myself, how does it work with other industries? Well, our guys receive trucks all the time. But you're given a window. Your truck has to arrive within that hour-long window. And we are given a window often by the shippers as to how long we have to unload that truck. So when it has to be back out on the road. Happens all the time. You see it in the airlines. You see it all the time. You see the times being adjusted. Thank goodness for Google. We can all see where the congestion is. We have guys that deliver auto parts. They have 26 touch points every month. Different hours of the day, 6 days a week. 26 touch points. If you hit all 26 touch points by your assigned time, let's just say 10, 2, and 6, you get a 2% bonus. Now that's an incentive to try to hit every touch point. You miss 1 time and you get paid your contract. You miss 2 times and you subtract 2% off your. That's a 97% rate that you have to meet in order to get your contract. You have to do it. That's how you get paid. And you're not going to make any money if you don't get to that standard. Well, you come to the railroads and we talk 73% to the yard. We talk 38 to 50% of the customers are billed demurrage. That's a failure rate. That's a failure rate to serve their customers. And they're telling you what it is. 73% delivery rate? Come on. What is that? We don't have that anywhere in the logistics industry. I remember when my daughter sometimes was whining, and I heard a lot of whining from the railroads. It's too complicated. It's too complex. It's too much government oversight, elaborate dispute systems, notice before changes. Oh, asset utilization, I love that. We all want to utilize our assets. We particularly want to utilize our assets. It's not just the railroad that wants that. Every supplier wants that and every receiver wants that. Well, what is that? It's the same for everybody. We value our customers. Well, no, you don't. You only have a 73% success ratio in getting it to the yard on time. You haven't gotten it to the end receiver, only to the yard. And you've got a 38 and 50% demurrage rate. Well, what does that say about how you value your customers? There is no valuing of the customers. It's all about their business. It's all about their business. And I remember one time when my daughter was in college and she was whining about how tough life was and all of her problems and how it was so hard to study and everything. And I told her, you know what? You're just going to have to suck it up. Because that's the message we have to sort of send to the railroads. It's time that you start performing and stop listing all of the things that stop you from performing. They keep blaming others, and yet we don't get paid unless the goods arrive. There's nothing we can do about it. So when I talk about actual placement, that solves. And you've got all these credit systems, all these storage systems, all these leasing systems, you got all these other things. Why? Deliver the goods. Stop writing all these tariffs. Deliver the goods. Start the clock then. If we don't get our job done on the other end, then we can start talking demurrage. But don't start talking demurrage if the goods haven't been delivered. That's just ridiculous. You can get a door time. They know when that car is put in service. They know how many doors the receiver has. They can get a door time. They can alter that door time as you move along. If the receivers know what the load is, they can estimate their unload time. They can work with the railroads, and often do. And a lot of them have really good relationships with the yard people, and they work together to make sure. But what we have happening now is we've got longer trains. You know, we talk congestion. I didn't even know there was a congestion fee until I arrived. Nobody in our industry had talked about it yet. And it's kind of interesting to see what was happening here. But the trains have gone from 400 to 600, and I'm getting this information from my members, they've gone from 400 to 600 feet to 600 to 800 feet. So they are delivering 33 to 50% more cars to a yard. And every time they build a train, they're building it with 33 to 50 more cars, 53% more cars. Well, what does that do to a yard? How do you handle 50% more cars in your yard and get it all managed so you can get it out on the service tracks and get it delivered to your customer, or get them back and get them built up so you can send them back? They created their own issues of yard congestion, and now they developed a fee for it. It's amazing. It's just absolutely amazing. And they've done it with, and not only that, because it doesn't work, the demurrage clock goes off as well. All the clocks go off. And you can see from my testimony there, I started in this industry in 2013. The demurrage charge was $50 a day per car. We've heard testimony here, nothing was below 130, a lot of them were 200, okay? We went from 48 hours to 24, my testimony says that that's an 800% increase. I happen to be a statistician, I'm firm in my numbers. It's an 800% increase in 6 years. What? Reminds me of that little insurance commercial. What? You're stealing from me? It reminds me of it. We've just got to move forward with this. I've watched systems with the truckers, and I've watched our systems managing brokerages. I've watched the airlines. I've watched them all. They got the boards of movement. I'm positive that the railroads have them. Our customer service departments follow all of those trucks all the time. We know where they are. We send messages out to our customers all the time saying, we're stuck in traffic here, you know, at Cincinnati Bridge, we're backed up 2 hours again. You know, we've had an accident here, etc. All of those messages go out all the time. Our customer service representatives, our CSRs, are busy all the time because we take care of our customers. You get any of that from the railroad? Oh, you better go check their system. They can't tell you, they tell you to go check their system. You heard that testimony. Well, you have to go check our system. No, You need to know what's in your system and where your cars are and whether you're providing service to your customers or not. It's not for the customer to whine about going in to check it. It's about your making sure you're providing the service. And that's what it's all about. I'm sorry to be so forceful and so straightforward. We've had this problem for 125 years. In the last 6 years, it's quadrupled. When we gave the railroads the right to write their own tariffs, we trusted them that they would use their numbers and their knowledge, and that they were sincere about their wanting to provide service, etc. And so we gave them the right to do it and stop all the oversight. There is no trust anymore. You've heard so much testimony from so many people that they got something they didn't know was going to happen to them. And they won't trust the railroad ever again. Ever. Because they got rolled over. Multiple $100,000 demurrage bills for a little $3 million operation? What is that? I mean, there's just no concern, no working with the customer, no nothing. I listened to them up here, well, we'll consider that on a case-by-case basis. No, you are systematic about sending those demurrage invoices. You don't even double check them, you just send them. And then it's up to the receiver to double check them. I love your questions, by the way. Do you ever look at them? They don't. They're system generated. And they're awful. And they pile up. So we are considering putting into our standard contract a demurrage mitigation fee. Because it takes so much time. 38% demurrage charges. Look at all the executive time. Look at all the manager time. Look at all the logging time. Look at all the cameras we have to have out there to look at the loads to make sure they came in. Look at all the evidence we have to create in order for somebody on your staff here to say, yeah, there's enough evidence there, if the railroads still refuse. I mean, it's just outrageous. You have a whole staff to it. Our members have a whole staff to it. The railroads have whole departments to it. What is this? Get rid of it. Actual placement. Time to unload. Reasonable fees. 48 business hours. If you make it business hours, doesn't matter when they bring the cars. As long as I can get a crew in to unload it. If I know it's coming, it's even better. But if I have a crew there and you don't deliver it, shame on you. The railroads should know better. It's just awful. They're not a good partner. They are good at moving goods long distances, and they are good at heavy loads. There is a place for them. You'll see in my testimony where 55,000 loads, truckloads, go unshipped every day. We need more logistics movement than ever, but boxcar shipments are down 16%. We get charged demurrage. One of the companies, if I took their quarterly demurrage charge for the first quarter of 2019, would have $1.5 million in demurrage. They could buy 10,000 boxcars for that at $140,000 a car. It's not about dwell time. It's not about it. You ride by any yard, you'll see boxcars sitting on the sideline. And if you ride by it 5, 10, 20, 30, 2 months, 6 months, they're still sitting there. Maybe they're broken. Who knows? But why would you have a broken car sitting on the track? Particularly when your yards are full. You would get rid of them. There's all kinds of things out there that make you question what is really going on. I'm hearing this, but it doesn't marry up to what I'm seeing. I'm hearing this, but it's not what's happening to me. I'm hearing this, that they're open, but every time I talk to them, they're really difficult to deal with. So with this, I leave you again. The easy, really easy answer. Actual placement. 48 hours, 48 business hours to unload. It just simplifies everything. I thank you.
Thank you very much. Catherine?
Good afternoon. Good afternoon, Chairman Begeman, Vice Chairman Fuchs, and Board Member Oberman. Thank you for the opportunity to testify today on behalf of the International Liquid Terminals Association. And I also want to thank the board for not only holding the hearing, but in the inclusiveness of the hearing. And if I may compliment you on your stamina, that of your staff, so thank you very much for that. The International Liquid Terminals Association represents more than 85 companies operating liquid terminals in all 50 U.S. states and in 37 countries. Our members' facilities form a critical link in the transportation of a wide range of liquid commodities, including crude oil, refined products, chemicals, renewable fuels, fertilizers, vegetable oils, and other food-grade materials. We view ourselves as an intrinsic part of the transportation system, and largely because terminals provide essential logistics that enable interconnections between different modes of transportation, including from different modes to and from rail in commerce. This is obviously a very complicated set of issues. We have heard over the last day and a half many different aspects that the board is taking under consideration. My remarks and the position of the ILTA is very focused on one very specific issue. And that has to do with the responsibility for demurrage charges. Our issue actually also differs a bit from some of the other testimony that you've heard, because it does not arise from the last 18 months in precision railroad modifications and innovations, but rather back to an STB decision in 2014, which held that the railroads were able to seek compensation for demurrage from consignees rather than solely from shippers. While it is not a perfect analogy, and you've got my written testimony, I thought a little bit about how to be a little less dry than the written testimony. So forgive me for using an analogy. It is not a perfect analogy, but what comes to mind is many states will tax tobacco because they want to incentivize people to not expose themselves to health risks. And we have a public shared goal of increasing public health. In this situation, we have a shared goal. All of us, the terminals, the railroads, all of the shippers, we have a shared goal of having the most efficient, productive system possible. In the case of tobacco, we disincentivize the public health consequences, the illness, by taxing the direct tobacco product. So the user of that product receives a tax. If we were to take the kind of analogy to what we're seeing in the terminal business, it would be as if we were taxing people for breathing in secondhand smoke. Now, I suppose that could work through peer pressure, that you could then incentivize those secondhand smoke breathing individuals to go to the smokers and ask them to stop smoking. But it would be an awfully indirect way to go about disincentivizing smoking. In just the same way, by charging demurrage fees to the consignees rather than the shippers, you are divorcing the action from the responsibility. And for taxation to work, if you ask, or any kind of disincentive charges, if you ask any economist, you have to be attaching that taxation or that fee to the behavior that you want to avoid. Terminals are not customers of the railroads. They have no direct contract or service agreement with the railroads. Instead, we share customers. And those customers have contracts with the terminal to provide a fixed volume of storage and a rated capacity to load and unload rail cars for those accounts. While terminal operators serve as agents for their customers in directing railcar activity at the terminal, they operate at the behest of their customers when placing cars. Terminal operators do not own the products, do not initiate the shipments, and do not schedule receipts. We believe that the rule in 2014 had this effect as a purely unintended consequence. But by creating the ability for railroads to seek compensation for demurrage from terminals or other consignees, it severely weakens the intention of what demurrage is about and the kind of behavior it is meant to encourage and the kind it is meant to discourage. In the last 5 years, we've seen the situation become increasingly untenable for terminal operators. In its 2014 comments, ILTA noted to the STB during the rulemaking process that this rule would virtually guarantee constant disputes and endless litigation on behalf of terminals and railroads. And in fact, that situation has come to pass. Railroads and terminal operators are increasingly involved in litigation over payment for demurrage incurred on shippers' rail cars on their behalf. Most terminals do include clauses in their contracts requiring that shippers would pay any demurrage fees that were incurred by no fault of the terminal operators. However, in practice, terminal operators often find that they are unable to just verify the basic validity of the demurrage charges levied on them by the railroad. So because of the lack of visibility, the lack of transparency in the information provided by the railroads, even under the theory of the case that we could pass on those charges to the shipper, in practice it does not prove workable. The demurrage invoices provided by the railroads often include rail cars related to numerous shippers. The limited detail makes it difficult or sometimes impossible to determine which specific rail cars and shippers were at issue in each case of demurrage. In many cases, railroads have not been able to provide further substantiation when the charges have been challenged, and terminal operators have been forced to establish and maintain management systems that are in many ways duplicative of existing railroad systems to track rail car activity through their facilities to attempt proper valuation of the demurrage charges. And this has, of course, resulted in some considerable administrative burdens. The absurdity of treating terminals as if they were in some sense aggregate shippers is perhaps, to my mind, best encapsulated in the dilemma over free day credits that are assigned by the railroads. So confusion arises because the railroad will aggregate the free day credits across multiple shippers that do business at that terminal, and then leave it to the terminal to decide how to then pass on, assign those credits. For the terminal operator, this creates a very difficult dilemma. Allocating the credits between shippers is impractical, first in many cases because it lacks the detail that we would need to disaggregate and assign those credits onward to the shippers. Even more problematic, even if we could, to be fully transparent to the shippers, we would need to provide documentation explaining how the allocation of the credits fell across the entire transactions on the terminal property, which would mean disclosing proprietary information. Conversely, if the terminal decides that this is intractable and not possible, it's arguable that we are denying a benefit to the shippers that is owed to them under their contracts with the railroads. ILTA members have been actively pursuing resolution of these challenges associated with demurrage through outreach both to our shipping customers and to the railroads. In some cases, shippers have refused to accept demurrage charges, citing the 2014 rule. In some cases, the railroads have also cited the 2014 rule, saying that they have to charge the terminals due to the rule. We are left, unfortunately, having pursued what we believe is all other recourse in negotiation and outreach to partners, no other recourse but to come back to the STB and ask for a revision to the ruling. Going forward, even if the railroads were able to provide enough documentation to justify demurrage charges, we think that the 2014 ruling had, again, an unintended consequence of creating an unwarranted expectation that terminals would be the mediators on demurrage between railroads and shippers. Again, we thank you for the opportunity to be here. It is a critically important issue to our industry, and we ask that the STB explore ways to amend the 2014 ruling and remove the option of direct billing of demurrage charges to consignees such as terminals. Thank you very much.
Thank you, Catherine. Lowell?
Thank you, Madam Chairwoman. Appreciate the opportunity to be here. My name is Lowell Randall. I'm with the International Association of Refrigerated Warehouses. And we really appreciate the opportunity to speak at this hearing and the fact that you're holding it and recognizing that there is a significant challenge facing the industry right now. And I want to associate myself with the two other panelists and really echo a lot of the things that they've been talking about. But before I go into that, just a little bit about who we are. We're third-party logistics members in the temperature-controlled space. So these would be refrigerated warehouses that are third-party, so we're not owning any of the product. So much like the terminals or many of IWLA's members as well, we're in that third-party logistics space. So we don't have the control that's been talked about already on the panel. So we feel like we're uniquely positioned and uniquely disadvantaged, and part of that does stem from the 2014 ruling. So we would wholeheartedly concur that it is very appropriate to reconsider those policies and some of the unintended consequences and see if there is a way to more equitably look at demurrage liability, because we do feel like our industry and the third-party logistics providers in general are being disadvantaged, and specifically so. But rail it's an important option for our members, and we just did a recent survey of rail utilization in our industry. About 2/3 of our member facilities have functional rail spurs and rail access. That's actually down. So when we commented during the 2012 through 14 process on the previous ruling, I think that number was about 80%. We're starting to see members weigh out, does rail make sense for our facility? And demurrage is one of the driving factors. Now, obviously, some of it is customer base and market conditions, but we're seeing overall fairly low satisfaction rates with the rail service, and it's becoming a significant challenge for our members. All the while, we recognize that rail is good for the environment. There's fuel efficiencies, infrastructure benefits, but demurrage is limiting our ability to take advantage of those benefits. Just an example from one of our larger members, Americold Logistics. They've got 70 sites across the U.S. that have the rail access, and that has represented about 4,800 rail cars so far in 2019. Over the past 3 years, their demurrage charges have gone through the roof. We're talking millions of dollars just for that one company alone. And as has been discussed, the dispute resolution process needs reform as well, because they tell me they would need full-time people just to deal with processing demurrage disputes. So again, we really applaud the STB for holding this hearing. We think that, again, revisiting the 2014 decision is one distinct issue that we would recommend that you take on, but we also agree with the panelist with Steve's suggestion on actual placement. For third-party providers such as our members, actual placement is when we have control over the situation. And so to place that liability on us when we don't really have control over the situation does not appear to be equitable and is disadvantaging our membership. Bunching has been talked about a lot, so I don't want to go over that too much more, but just to reiterate, that is where our members tell us is the biggest culprit when it comes to demurrage. They don't think it's a warehouse capacity problem in large part. It's really demurrage is the largest contributor. Our members try to plan out labor very carefully, and when cars are inconsistently placed, we've got lots of labor and no cars, or conversely, sometimes there's lots of cars Inconsistent delivery means we may not have the labor available because there's too many cars there. So, and we don't have control over the bunching. So this idea of how do we assess that liability again is something we really believe needs to be addressed. I see that I'm out of time, so I will just close by reiterating actual placement, revisiting demurrage liability, finding ways to assess that liability when bunching occurs and credits have been discussed, and improving the dispute resolution process. We think that those are some ways that we can improve this situation.
Just a couple of questions. Catherine, you said that some railroads say they're required to bill demurrage to your people.
Yes.
Can you tell us which railroads take that position?
Yes, so Kinder Morgan is the company that's had that happen, and you heard actually my board member, Josh Etzel, spoke to that earlier. Yes.
So that's what you had in mind, CN's position? Well, I understood him to say CN's position is they're required to bill demurrage to somebody, but you think their position is they're required to bill it to the terminal?
I believe we can clarify
Yeah,
something. I'm not
okay.
sure.
Well, we're going to clarify it with CN in a minute.
Yeah, but that is my understanding.
And they find this requirement somewhere in 707? Or do they find it in the statute, or do they find it in the ether?
I guess I can't really speak to their
I mean,
their
as you-
motivation. Right, but
I mean, what's the stated justification?
That
I
is-
mean, I'm just sort of puzzled by,
that it's the 2014
that it's that
language.
rule,
Yes,
that they
exactly.
say somehow.
Yes.
So, do they say we can't bill the shipper?
You know, I wasn't party to the conversation.
Okay.
My understanding is that, that they pointed to the 2014 rule and said that their interpretation was that they must bill the consignee. If there was a consignee, they must bill a consignee.
And do you all, let me just ask you this, Lowell, Maricold, they're all over the country, so
Yes, sir.
this multi-million-dollar demurrage charge, that's more than one railroad, I take it, or
Yes, sir.
it's basically everybody?
Yes, sir.
And do I understand for you intermediaries, the problem is almost entirely bunching?
That's what our
you
members
said,
report to
Lowell.
us, is that
Catherine,
bunching is the major contributor.
do you agree?
You know, for us, I think it's a little different. We really are agnostic to the cause of the demurrage because our issue is that we are not the appropriate party to be in the dialogue about the cause of demurrage. We are not a party to a contract with the railroad, and so whatever the cause of demurrage is something to be dealt with between either the railroad and the shipper, or if the shipper says it was because of a fault at the terminal, a subsequent conversation after the railroad and shipper have ironed out their differences, a subsequent conversation should then occur between the shipper and the terminal. That's when we would be party to any discussion of demurrage.
Well, one of the reasons I'm trying to get at this, you've heard a lot of conversation, I assume you've been here, about the whole concept of demurrage being an incentive to avoid demurrage.
Mm-hmm.
So you all say you don't control it. It's not a question of you're not having enough track space to take cars in, I take it. Is that a fair statement? Your members? Dave?
Our members have between 3 and 25 doors. A lot of them are smaller, 3 to 5 doors, and so they don't have track space. They're just about all in industrial parks, and so there's no way around it.
So, and are they getting billed demurrage because more cars are coming in than they have space to take them in?
Yes, and in answer to your question, I see it as bunching, scheduling of days, and missing of those days. I mean, it's not like, if I have 5 doors and I got 15 cars, I would like to get an extra service day. So I call the yard and I see if I can't get it set up, and a lot of times we get a yes. Then we come to our next switch day, there's no switch. Well, in services, okay. Then about 3 weeks later, you get a demurrage bill for the switch that did not happen. And you're getting it for all 15 cars.
So,
And it's amazing the amount of work we put into making sure that we get it right. And then a third of the time it comes out wrong. And here's the real kicker. You get a demurrage bill this week, you try to solve your issues. You get a demurrage bill next week, you try to solve your problems. The third time you get it, it's like, what is going on here?
so
It shouldn't be more than that, but 38% of the time, you're getting demurrage bills.
let me see if I understand the difference between the intermediaries and a shipper or a receiver that's the end user. Your customers, you're not ordering cars from your customers. Your customers are shipping to you, and they control the rate at which the cars are shipped. So you have nothing to, well, when you have a deal with your customers, that they say, well, we're going to ship you 10 cars, are you in a position to say to them, well, we only have 5 doors, don't ship us 10 cars, or how does that work?
That is an absolute conversation that they have. But again, we've had shippers that would send 2 cars every other day
And then,
because we have 3 service days. I got 5 doors. Got other customers coming in, of course. They think that they're mitigating for us and helping our members to not incur these kinds of things. And then they might get bunched, and in the
So-
one scenario that I'm thinking of, they shipped 2 a day. I don't understand this. And then they delivered 9, not 10, 9.
well, one was wandering around. So you do have some control in the sense that between you and your customers, you can make arrangements with them based on the capacity of your facility about how much and at what frequency they should ship to you. That part you do have some control over when you make your deals.
Somewhat. It depends how many customers you have in the building. Most of our buildings have 10 to 30 customers in them. So depending on how many are shipping via rail, we may or may not know how many cars are coming. We know because of the system will tell us, but we don't necessarily know because of the customers. Because again, they're under constraints on their end to get their cars loaded and released.
But
That's why I.
Don't
say
you have
one KPI was-
some ability to restrain your customers as to how much they ship to you? So if the railroad were operating perfectly, that you don't want them shipping more than you can handle, it seems to me. I'm trying to understand the
Yeah,
business.
if I could try to
Can't
add.
control all those
Right,
customers.
yeah, I would say exactly, so limited control. For example, pre-2014, it would be, it could happen that a customer that normally loaded 3 rail cars a day might, because of business reasons, having a particular client or deadline wanting extra surety, might order 6 cars to have 3 just in case. That shipper could direct that all of those cars, the 3 plus the additional 3, would all be directed to come to the terminal. The terminal would not be able to prevent that. And so if that shipper didn't use those cars, there would be demurrage fees. Now, pre-2014, in this scenario, that could be perfectly valid and welcomed by the shipper. They would take that as a business cost that they took on intentionally because they wanted that certainty. Post-2014, what's complicated is that now that shipper, hypothetically, could have that extra resilience or that certainty from having additional cars, but not have any obligation to pay demurrage because the terminal would cover it.
So they have no incentive to not do that.
Exactly right.
So the incentive part of the demurrage system is
It breaks down fundamentally.
fundamentally broken down.
Yes.
And you're saying previously, even if the shipper was going to ship more capacity than your terminal had, you didn't care because it was a cost they chose to absorb.
Absolutely.
So so since 2014, have you tried to change your arrangements with your shippers to say, don't do that anymore?
Yes, and there are clauses in the contracts that stipulate that, but in practice, both because we lack the detailed information to make clear that that charge belongs to that shipper of the many shippers that might be on the terminal. Or if we have data, we may not be able to show it all because of confidentiality. Most of the time, our members say that they are not getting sufficient data from the railroads, which is causing them to have to set up their own management systems that parallel the railroads to try to decipher which cars had demurrage and were attributed to which shipper.
Could your problems be solved if the railroads gave you all the data that normally a shipper would get when they want to fight a demurrage charge?
It wouldn't because the data would all be aggregated.
Bulk.
Right.
It wouldn't break it down
Well,
as to which of your customers is responsible.
So it cuts both ways, unfortunately. If we have the data aggregated, we're not able to break it apart and attribute it appropriately. If it's broken down, to be able to show our shippers what we're charging them, to make our charges to them transparent, we would have to show them all of that information. And so then we are violating proprietary business information. So it cuts this either way.
Is there any other railroad besides CN that any of the three of you know of that takes a position that they are forced under the law to bill you? Or is that some unique idea that CN came up with?
I don't know that, but 707 allows for the consignee to be billed. It allows them to be billed, and even though they don't have a contract with the railroad.
Well, it may or may not allow. What it allows is something, I think that's an open question, particularly if there's no showing of causation, but that's a separate point. But I'm just trying to figure out if railroads are doing it because they think they can, or if they're doing it because they claim they're required to. That seems to me a difference. CN takes that position, you say, and I think they have, from what I understand. But the rest, nobody's told you that.
No.
It comes down to customer relations. We're not their customer, so we don't have a relationship. The shipper is the customer, so rather than confronting the customer, it's a lot easier to confront the receiver.
Got it. Thank you.
And then we have to confront the customer.
Couple questions.
Well, I'll be quick. Unfortunately, I've actually left the 2014 decision on my desk with all of the stuff I was looking over. I'm trying to quickly pull it up on my phone here. So obviously, my colleagues are not at fault or guilty for the board's good intentions, and I can assure you the board had good intentions. Actually, I'm reading quickly the summary, and it says that the board is adopting final rules establishing that a person receiving rail cars from a rail carrier for loading or unloading who detains the cars beyond the, quote, free time provided in the carrier's tariff will generally be responsible for paying demurrage. So I'm wondering if now that there is no free time, whether or not, just thought I'd throw that out there. Catherine, we've had the chance to talk earlier this year. Steve, I'm sorry that you don't feel at all compassionate about these issues. I wish you'd kind of hop to it on the second day of the hearing here and get us back to where we needed to be. Look, I am sympathetic to what you and your colleagues and Joshua, others have shared with us. And I'm just trying to understand if the board's decision were to be reversed, and again, the board acted because we were trying to resolve a dispute between the two circuit courts. So we were, again, doing something that we needed to do. But so if, I'm not sure, are you asking for the decision to be entirely reversed or to be modified? And upon answering that question, I'm curious to know whether or not, so would instead of the carrier charging a third-party receiver, if you will, demurrage, it would go to your customer who is the actual shipper. But someone does have the relationship is between the railroad and that shipper, but yet there are times when you are responsible, correct? So now that this is good and confused, help me understand.
Sure. And thank you, and I well appreciate the good intentions of the board and believe that this was an unintended consequence from trying to fix another problem. I'm not a lawyer, but I do understand.
That's okay.
Yeah, but I do
The
understand.
majority of us up here aren't.
But
He tells me that all the time.
I would welcome, and ILTA and our members would welcome the opportunity to try to work with the board in finding language that could revisit that earlier problem, ensure that that is not disrupted, that there's a solution that remains in place for that, but closes this gap, this uncertainty that was created unintentionally. So I believe that there will be a way that we could revise the rule so that the original intent would be met, but to clarify that this state of affairs was not what the board envisioned. The practice before the 2014 rule, we would also welcome, maybe it would be appropriate to have comments from shippers. The terminal industry's position is that things worked well back before 2014, that on a case-by-case basis, customers would raise concerns and say, I was charged, demurraged by the railroad. In fact, it was because you had a labor issue or an equipment issue that then caused me to be late in loading my cars. We believe that worked well, so that the shipper and the railroad had a contractual relationship. They would agree on how the demurrage would be attributed, and then the shipper, with their contractual relationship with the terminal, would then, in a second step, come to a resolution. So I think it would be prudent for shippers to have an opportunity to comment on whether the pre-2014 state of affairs was working. My industry would venture that it did work well.
Quick question. As I understood that 707, it was aimed at making sure you didn't get billed if you didn't have notice that there was a demurrage tariff. That the distinction was whether you could be billed if you had no notice. That was the circuit dispute. You don't want to get rid of the requirement that you can't get billed if you have no notice.
That's right.
You'd
That's
like to
right.
keep that part
Right.
in? Okay.
It's the consignee versus
Yeah,
the shipper, yes.
I just want to put that on the record, because the notice part was the benefit, the terminal.
Right. Thank you.
Catherine, I was wondering, can you, you said it would be prudent for the board to get comment on the shipper perspective. Can you preview, in your view, what you think we might hear?
My expectation.
Charge us.
Yeah, please. We have a contractual relationship with them.
Right. My understanding, my expectation would be that you would receive comments that worked well, that because they had a contract and there were provisions in the contract saying that we have a duty of service, that we were, and our members were liable to provide service and would make the shippers whole if we caused demurrage charges. So I expect that there would be, the shipping community would welcome a return to that. I know that our terminal members that have gone to their shippers and have asked them, would you go with us to the railroad, and ask them to return to the practice of billing the shipper directly, when asked, have been willing to do that. So my expectation is that it would be met favorably, but since I don't speak for that,
I just wanted a preview. Thank you.
Yeah,
That's great.
Steve, if you could, or if you could make me a little clearer on something. Catherine, I know exactly what you're saying. I mean, I understand your request of the board. Steve, what I'm a bit confused on, are you, you got a lot into the actual placement issue, the 48 hours issue. Does it all stem from the 2014 decision, or do you have is that a different issue? Were you caught up by the 2014 decision, or is your issue separate? You would have received demurrage, or
We were caught up in the 2014 decision because they were able to bill the consignee, and now we're caught up in the issue of the increases
impact. Okay.
and the lack of service.
Thank you for clarifying.
Just one further clarification, Steve. You said 48 business hours. You don't mean 6 8-hour days, do you?
I mean 5. Basically, when we think of business hours, we think 8 to 5, Monday through Friday. Those are business hours, okay? Now, I'll be the first one to tell you, our members work well outside of that. They would be accommodating. But as far as the rule goes, they think that it has to be definitive. If we leave it squishy, then it will get really squishy. We can always go to the railroad and say, hey, will you drop cars on Friday? We'll unload them on Saturday. When you bring our load in on Monday, you can pick up those cars.
So
That would be great.
48 hours, when you're urging that that's what we do, you don't mean 48 continuous hours. You mean,
I mean 48 continuous hours. Yes, I do.
so, well, because
So,
you
2
said
days.
48 business hours.
2 days.
But you're talking about 2 days.
2 business days, Monday and Tuesday.
Okay.
Bring cars in on Monday, we'll have them ready for you Wednesday at the same time.
Just wanted to be clear. Thank you.
But Saturday and Sunday don't count, unless you make an agreement.
7-day week operation.
2 quick ones for me. The date, actual placement idea, if I could hone in on that. I think, Lowell and Steve, you said that it should just be on actual placement. You know, there are scenarios when something is in kind of constructive placement, and we've heard that a receiver, maybe not your members, but a receiver, if the person were not to order the switch or, get a switch, then they'd effectively be getting, incurring car storage, you know what I mean, within a railroad yard. So if we were just to measure on actual placement, would that create a disincentive for cars that were placed in constructive placement to, basically get released to a receiver's facility, such that the person would basically be getting automatic free storage?
In our particular case, because our guys don't get paid unless they unload that car, they don't want any of them in constructive. They want them all at the door as soon as they can get them to the door.
So as soon as they're in constructive placement, you want them in?
It's just that simple, but that's a different scenario with 3PL.
So when you're saying
Because
actual
our guys
placement
get
should be
paid
the
for working.
when you say actual placement should be the standard, you're saying that in the 3PL world, there's such a great incentive for things to get out of constructive placement that measuring off constructive placement is just not worth it.
Totally.
Okay. And then the timestamp idea. You all work with both rail and truck. Is it your experience that trucking companies provide, good timestamps, date and time, in a way that's superior to the rail industry? When they serve your facilities?
We work with large trucking firms. We work with a lot of brokerage firms.
Yeah.
I go into our offices, they got all the screens, they're watching all the trucks
Sure.
all the time. If you go to a large trucking company, you go into their
Right.
customer service centers, they got the big boards up, they're watching every truck.
Right.
They know which truck's falling behind, et cetera, and they're out there and they're responsible for certain trucks and they're communicating all the time what's going on. And yes, they stay in great communication. And so it's usually with whoever's in charge of your dock doors on the trucking side. On the rail side, we have some of that information because we go in and look at the
Right.
system and we look at it. And some of our guys, because of their logging, take screen prints all the time as to what's in the queue, what's in the queue, where it's in the queue, et cetera. And they're doing that, and then all of a sudden, it gets to the yard and all the ETAs become suggestions, not real. And the service days don't work and you don't get switched. And all of a sudden it falls apart. It's all, for the most part, the biggest issues that we have are the last mile.
Yeah, that's what we're hearing over and over
So that's
again.
why we keep saying, let's not do this constructive stuff because it's in the last mile and they think they've delivered when they got it to the yard.
But specifically on the timestamp issue, you're talking about the timestamp of when cars are spotted. That's what you want. And what you're saying is for the equivalent process within the trucking industry, you got all that information. In the rail industry, that's what's lacking. Is that accurate? Lowell, is that for you? And you don't think it's accurate?
No, I would agree.
Okay. All right. Thank you.
All right, thank you very much. Greatly appreciated. Panel 11. I'm sorry, yes, 11 is next. BNSF, Canadian Pacific, Canadian National. Okay, panel 10. Jill, we'll start with you.
Thank you.
I'm sorry, 11. Panel 11.
Thank you all for the opportunity to be here today. Does that get me? Yes.
Thank you all for the opportunity to be here today. We've been carefully reviewing customer comments and also your own lines of inquiry throughout the proceeding. Given the significant amount of testimony so far, I will limit my comments to a few key areas of BNSF's demurrage program, as well as the efforts we undertake with our customers in this important area. BNSF's core focus, second only to achieving our safety vision, is to deliver for our customers on the operational and competitive potential of our rail network. That means maximizing the efficient use of railroad line haul and terminal capacity and equipment, ensuring that the network can function effectively in the interest of all of our shippers. As detailed in our written comments, BNSF puts significant energy and resources into assuring the appropriate and tailored use of demurrage as a tool to support that goal. Demurrage is not treated as a revenue-generating opportunity at BNSF. Simply put, our goal is to collect less demurrage from our customers. Every demurrage bill issued represents a missed opportunity to obtain an operational efficiency in the loading and unloading process that's important for all our customers who rely on our network. In that same regard, when delays or other inefficiencies are caused by BNSF, our consistent practice is to eliminate the demurrage charges for impacted shippers, which creates incentives for BNSF to act efficiently ourselves or bear the associated costs with that. As preparation for this testimony, I reviewed the day-to-day efforts that our customer service and demurrage professionals put into achieving that goal. BNSF provides a significant number of tools and communications aimed at allowing, first, greater customer control of pipeline decision-making to avoid demurrage in the first place. Second, the review of data relating to any charges that are incurred, and then finally, clear and timely dispute mechanisms. As part of the pre-billing process, our demurrage, and I'm talking about pre-billing just to be clear, our demurrage team members who are assigned to specific regions and fleets of equipment review estimated demurrage charges in light of variability in our service. That can include things like our current flooding challenges, general metrics of performance of our network like dwell and velocity, performance against a car's individual trip plan, local yard challenges, and missed switches. In addition, our customers are able to see that same estimated but not yet billed demurrage and communicate with their BNSF marketing representative or engage directly with us through our demurrage tool about the service challenges they are seeing. That tool does contain the information that was discussed on the last panel in terms of times of placement, release, etc. This early pre-billing review and customer engagement helps to ensure that bills going out the door do not assign shipper facilities responsibility for railroad-caused events. We are not perfect, however, and have simple-to-use mechanisms for customers to dispute bills after they are issued, including using that same one-stop demurrage tool to flag charges for dispute and provide additional information that we may not have considered. Our goal is to respond within the next business day. And in many cases, we can actually resolve disputes in a few business days. When we can't do so, it's often because of the complexity of the operation or the facility. And what we do there is assign a customer a specific representative, a live person within BNSF to work through that. But even before a shipment starts its movement on our network, a BNSF facility can use our Rail Central suite of tools to see all shipments that originate or terminate at their facility, and they can track them across the entire route as they move on BNSF's network. This is an important data set for a lot of reasons, but for demurrage purposes, it allows a receiver to understand, first, the number of loaded shipments being ordered into a facility from any origin on BNSF. Second, the number of cars already en route to their facility. Third, the number of cars that have been constructively placed in the yard adjacent to their facility. And then finally, those cars already sitting on their track. With that information, a customer can make better pipeline decisions, including whether they need to adjust the number of cars being released into the system at origin, make requests to divert shipments to other facilities, consider modifications to the use of their existing track, or consider longer-term options like alternative storage locations. I would like to confirm that for all these BNSF tools, there is full access for receivers as well as our freight-paying shippers. We have many receivers who make very effective use of those tools to avoid demurrage charges, resulting from imbalances between releases at origin and the actual destination capacity. Behind those tools are also dedicated and knowledgeable BNSF team members, engaging directly with repeat demurrage customers in a very personal way that looks to address situations at their facility and their own traffic flows, and outline specific ways that they can manage rail inventories and obtain reduced dwell and increase their last mile throughput. BNSF will continue to develop and implement innovative programs, processes, and technology to support that ongoing dialogue. All these efforts ensure that situations that warrant demurrage are the ones that are being addressed through our billable charges. That's important for BNSF because the starting point of our partnership with our customers is a shared interest and expectation in creating a fluid operation at all points in the route of movement, including the origin and destination. Those assumptions underpin our approach to the commercial marketplace. When service interruptions occur on our network, we react quickly and work hard to restore consistent throughput, and we see our customers do the same things at their facilities. Because of that joint interest with our customers in working to protect an efficient, reliable, and competitive service product, the inefficiencies associated with disruptions or outlier customer facilities are not built into the system as an assumed cost. Instead, situation-responsive tools like demurrage fees are used to address the outliers when it comes to overconsumption of common rail facilities and equipment. In conclusion, BNSF takes seriously its obligations as a common carrier and our role as a business partner to our customers, and that informs the commercial programs that we implement, including demurrage. Central to our approach with our customers is a common interest in efficiencies that can be gained across the entire transportation route, including the first and last mile. We appreciate the opportunity to share with you all how our demurrage program works to support those efforts, and we're happy to answer questions that you may have.
Thank you. Pam?
All right, good afternoon, and thank you for having me, Chairman Begeman, Vice Chairman Fuchs, and also Commissioner Oberman. I am Pam Arpin, and I'm the Assistant Vice President for Canadian Pacific Railway, and my role is as I do all of the work with supplemental activities, including operational support and invoicing. I'm going to focus my comments today on pre-invoicing measures with our customers, CP post-invoicing measures with our customers, ongoing dialogue that we have with our customers to improve our services and tools, and lastly, facts around billing and collections. CP would like to start, however, by reiterating comments by CP's CEO, Mr. Keith Creel, to the STB on February 4th, 2019 regarding the demurrage system and its importance to the health of the rail network. Effective management of rail cars is important to maintain fluid operation of the national rail network, as well as the sidings and facilities of rail customers, logistics providers, ports, and customer stations. Shippers and receivers are in a unique position to coordinate rail shipments to make efficient use of rail cars and other rail assets, including track and yards. Cars that are not timely loaded, unloaded, or released congest track and yards and impact the network's ability to handle the customer's next shipment and the ability to serve other traffic. The rail industry and the United States Congress have long recognized demurrage as a necessary mechanism to ensure a fluid rail network. I'll now talk to our pre-invoicing measures with our customers. As described in our May 1st submission for this proceeding, CP has established mechanisms in place intended to ensure that inventory and service performance, including events that impact demurrage and accessorial charges, are properly reflected in demurrage and accessorial invoices. These measures include CP's onboarding team. This is available to new customers to provide onboarding services, including familiarization for our customers around CP's tariffs, how they are applied, and the tools available through our CP portal. CP's local operating planning team. This team is unique in that they develop local operating plans and build trains for our operating teams based on customer spot and lift requests. After CP has provided the planned service, CP audits and reports internally the actual performance against the initial customer requests to confirm the level of success delivering to our customer requirements. These reports are produced daily and viewed by all levels of CP's operating team, including senior leadership. Our Demurrage team also uses this information to monitor for exceptions and adjust demurrage records as necessary prior to invoicing. CP's Customer Station Login Issue functionality also allows shippers, receivers, and third parties the ability to flag concerns in real time as they relate to inventory reporting, transit, and local service. This also, as BN spoke to, looks at the facility, the yard, and the inbound pipeline in terms of information that's available. CP provides customers with visibility to demurrage days accruing for each car. Concerns reported by customers are addressed by CP's customer service team and reviewed by our demurrage staff when compiling month-end statements. Our last item in this area is CP's pro forma process, also known as pre-invoicing. This was established to provide parties receiving a demurrage statement a channel to submit consolidated feedback prior to formal invoice issuance. At the end of the month, a dedicated CP representative issues a pro forma statement to a customer in order to provide an opportunity for A, dispute aspects within the statement, B, for the customer to request further details, or C, approve the statement. The goal of the process is to attain agreement on the final amount to be invoiced while working collaboratively on mitigation of demurrage and accessorial charges going forward. Next, I'll talk to our post-invoicing measures. Once invoiced, customers may log disputes and raise concerns through the following channels. Disputes may be logged within CP's customer station using the Manage Invoice tool. CP commits to responding within 15 business days. If CP does not timely respond, CP accepts the dispute as written. Concerns may be raised with a CP inventory control specialist who will work with customers and CP operations in an effort to mitigate systemic events that are leading or could lead to demurrage and/or accessorial charges. Our CP account managers are also another area of escalation. Concerns regarding rates, terms of service, as well as accessorial demurrage invoicing may be raised through this channel. In such instances, the account manager will help to facilitate resolution through the appropriate parties within CP. The next area I'll talk about is ongoing dialogue with our customers and stakeholders to improve our services and tools. We at CP continue to evolve our services and technology through direct dialogue with our customers. The following are examples of CP's efforts to maintain lines of communication with our customers to improve the customer's experience. The Customer Advisory Council is an initiative started in early 2018 to pull various customers together from all lines of business to discuss fluidity, technology, and communication. As part of this Customer Advisory Council, CP engages in touch points throughout the year with specific focus groups led by our customers on key areas to develop a multi-year roadmap around customer experience. So we do have plans in place and a multi-year roadmap that involves technology, communication, and service with our customers. Using a third party, CP also conducts annual customer surveys across our customer base in order to measure customer satisfaction on various elements of our service. We also issue 2 surveys each year directly around our customer portal, where customers can provide feedback and identify opportunities for improvement. CP engages with customers at industry events as well. This includes, when requested, participating in discussions with shipper organizations on accessorial and demurrage charges. CP's senior management also participates in monthly meetings with the STB to share real-time key performance information supported by operating and performance data, and to answer any questions or concerns brought forward by customers to the STB. Of note, while we have received individual feedback on specific customer concerns on our invoices, we have received very little feedback on our overall accessorial and demurrage program, which has been largely unchanged since 2015. The next area is around our billing and collections, and just to provide some facts in that space. Demurrage and accessorial charge revenue does not drive CP's financial performance. These revenues represent less than 3% of our operating revenue in the United States and just over 0.5% of operating revenue for CP as a whole. While absolute dollars of billings increased in 2018, the increase is not disproportionate when looked at as a percentage against the total amount of revenue increase over this period. Furthermore, when you look at CP's demurrage in isolation, excluding any container storage, while our revenue has increased by approximately $280 million from 2016 to 2018, our demurrage charges have dropped as a percentage of total revenue as well as absolute dollars. 2016, the revenue was $18.6 million. In 2018, it was $17.7 million. CP's collection rate when comparing billed versus collected on a yearly basis has averaged around 90% in 2016 and 2017, and our collection rate increased to 94% in 2018. CP's percentage of adjusted bills has also decreased over the 3-year period as well, from 8.9% to 6.7%. We believe that the increase in collection rate and the decrease in adjusted bills is a reflection of improvements CP has made in our processes in communicating with customers and in our technology. These improvements, supported by our people, ensure we are providing accurate invoices to our customers. We know we're not 100% perfect, and therefore, as discussed earlier, CP offers further opportunities post-invoice for our customers to raise concerns. It is CP's perspective that for the vast majority of what CP issues for charges, shippers and receivers are paying the charges that they deem appropriate. This is in part due to our robust processes for addressing demurrage and accessorial concerns, and in part due to the benefits of CP's maturing PSR program. Our customers have by and large adapted to PSR. Under PSR, our customers enjoy more reliable and predictable service, which in turn makes it easier for customers to avoid demurrage and unnecessary accessorial charges. It is important to note that CP's accessorial and demurrage charges include charges for optional services and products, and that these are value add to our customers. These services and products include, for example, container storage. Container storage accounts for 29% of CP's demurrage revenue in the first quarter of 2019. Accordingly, CP cautions against drawing negative conclusions from increases in demurrage and/or accessorial revenues, as they may simply be a reflection of the carrier offering a value-add service at a competitive price. Additionally, it is important to note that CP's demurrage rates do not go in one direction only. Congress requires that rail carriers charge demurrage in order to ensure adequate car supply. When demurrage is high and car supply is tight, CP may increase demurrage rates in order to encourage more efficient use of equipment. Conversely, when demand for cars is low and supply is adequate, CP may reduce demurrage rates, as reflected in the data CP provided to the board on May 1st. In closing, CP believes that its practices around demurrage and accessorial charges are balanced and reasonable. We proactively deal with issues where we can, and we provide appropriate channels for escalation of issues after invoice. Furthermore, CP has not had any substantial changes to our policy during the period in question. It is the responsibility of all parties in the supply chain to ensure a fluid network. A fluid network ensures customers receive consistent and reliable service that they depend on. Demurrage is a critical tool to ensuring that all parties in the supply chain behave responsibly. As demand for rail services increases, CP is investing in its network to meet the challenge. However, it is prudent and incumbent on CP to make the most of our existing assets. In significant part, CP's relentless focus on making more efficient use of our existing assets enabled CP to move 219,000 more carloads in 2018 than we did in 2016, a 9% increase. Thus, through efforts, we ensured that 219,000 more carloads of various commodities were available to fuel the economy. This increase has been made possible through our operational excellence and precision railroading and by ensuring we have appropriate policies in place that incent behavior around asset use. We are proud of the work of our over 13,000 employees, our CP family, to accomplish this. I would be pleased to take any questions you may have.
Thank you. Kathy?
Good afternoon, everyone, and thank you so much for having us today. My name is Kathy Gainey, and I'm U.S. Regulatory Counsel for CN, the U.S. subsidiaries of Canadian National Railway Company, which is celebrating its 100th year anniversary this year. CN welcomes the opportunity to testify before the board regarding our demurrage and our optional services, to discuss CN's policies in this area, and to answer any questions that the board may have. As with all aspects of CN's business, our top priority is operating a safe and efficient rail transportation network. Demurrage and optional services play an important role in promoting the network fluidity and high-quality service that our customers expect, while providing the additional optional services that some of our rail customers sometimes request. I'm pleased to introduce CN's two witnesses today. Derek Taylor is CN's Vice President, Southern Region. In this role, Mr. Taylor is responsible for CN's operations in the United States. He oversees CN's efforts in the U.S. to maintain network fluidity by reducing cycle times for equipment and increasing asset utilization. Before beginning his current role in August 2018, Mr. Taylor served as General Manager in CN's U.S. headquarters in Homewood, Illinois. Derek Taylor joined CN in 2000, and he's held positions ranging from train master to general superintendent across CN's system in both the U.S. and Canada. We also have Keith Cottrell, who is Senior Manager, Service Delivery at CN. In this role, Mr. Cottrell leads the optional services team that oversees the application of CN's demurrage and accessorial service tariffs. Mr. Cottrell joined CN in 2006, and he served in a variety of roles, including Manager, Innovation and Strategy, Senior Manager, E-Business Manager, Sales and Marketing, and Carload Service Delivery Operations. With these introductions, I will turn the presentation over to Mr. Taylor.
Thanks, Kathy. Appreciate that. Good afternoon, everyone. As Kathy mentioned, I'm CN 19 years old, which have been in operations. I'm here today. I'll explain the importance of steadily pursuing efficient rail operations to maximize network fluidity under widely varying conditions. That's ranging from record-breaking cold temperatures to unprecedented flooding, which some is going on today, to searing heat. CN railroaders are dedicated to safe and efficient transportation and meet the needs of our rail customers by providing reliable rail service. Fluidity is particularly important to CN's U.S. operations, which are conducted on a largely single-track network. Page 2 will show our 19,500-mile network in the U.S. and Canada, as well as what commodities CN moved in 2018 and where CN traffic goes. Page 3 reflects CN's ongoing efforts to increase capacity, resiliency, and network fluidity. These are necessary for CN to drive customer service and growth. With scheduled railroading as a foundation and safety as a core value, CN is focused on reducing cycle times, increasing asset utilization, and increasing capacity and network fluidity. While one aspect of network fluidity involves trains operating consistently and on time, it is equally important to maximize asset utilization of rail-owned cars and private cars on the rail network. This is particularly true during times of reduced capacity, such as the winter months or when maintenance and capital improvements require maintenance windows for work blocks, all of which require changes to our operations. It is also true during times of congestion, because such congestion can cause ripple effects and require a railroad to stage trains and sidings miles away waiting for the congestion to clear to access the yard that's required. Slide 4 illustrates that many factors impact railcar cycle times, which in turn impacts network fluidity and operational efficiencies. One factor is train and track capacities. These determine loading capacity and train speed. CN invests each year in capital to enable growth. This past year, CN set a record capital program of $2.9 billion in 2019. Over the past 2 years, CN will have made a capital investment of $5.7 billion. We reinvest 25 cents of every dollar in revenue into our network. In 2019, in the U.S., CN investments include $190 million in Illinois to strengthen the rail network and across the state to boost capacity and network resilience, which totals more than $1.3 billion in Illinois just in the past 5 years. CN is also investing approximately $120 million in Wisconsin this year, and we will now have passed the threshold of $1 billion in Wisconsin over the past 5 years. In addition to investing in maintaining train and track capacity, CN also works hard to increase asset utilization by encouraging equipment to be loaded and unloaded more quickly. When cars cycle faster from origin and destination and back to the next origin, the same number of cars online can move more loads for rail, which translates in improved network fluidity by reducing delays from congestion of trains and cars in the network. CN is fostering resilience to respond more quickly to real-world disruptions in railroading. This includes disruptions caused by severe weather that can cause plant closures, equipment failures, or limit the ability to operate equipment safely. Slide 5 is a picture showing some of the challenges in operating a railroad in severe winter conditions. For example, in this past year, the extreme cold temperatures this past winter made headlines when in Chicago it was colder, as many of you know, than parts of the Arctic, the Yukon, or even Mars. And I lived through the real polar vortex of 2013 and 2014 in Wisconsin and Minnesota when I was general manager. And it's a tough working environment when it's 40 below Fahrenheit outside. CN engages with its customers on a regular basis to encourage their cooperation in facilitating a fluid and efficient rail network. The faster customers unload and release equipment to CN, the faster that equipment can be returned to the system to serve another customer for loading. In that regard, an empty load is just as important as the load itself. An empty car is the next loaded car. By ensuring that those empty cars are returned to the system as soon as they are available, the entire supply chain benefits. When car cycle time is down, fewer cars online can serve demand, thereby alleviating congestion and increasing capacity. One of the many ways in which CN encourages efficient asset utilization and movement of cars is through demurrage. CN imposes demurrage charges when customers exceed the free time allotted for loading and unloading of rail cars. The purpose of demurrage charges is to incentivize customers and receivers to load and unload equipment quickly. Customers can make decisions to decrease their demurrage charges by configuring their facilities to increase track capacity, improving loading or unloading times, or operating 7 days per week. CN prefers customers and receivers to load and unload equipment within the free time rather than charging for demurrage. That would mean that CN's equipment was moving at maximum efficiency to the benefit of all CN customers and receivers across the entire supply chain. Everyone benefits from moving freight more efficiently, not from collecting demurrage from cars that are not moving and dwelling in CN's rail yards, CN's sidings, or CN's tracks. By encouraging efficient use of equipment, CN's policies promote commercial fairness to our customers. Cars that are occupying space in CN yards or tracks or awaiting unloading or loading at a customer facility make it harder for CN to provide fluid service and efficient asset distribution to other customers who are efficiently loading and unloading their cars. And the longer that a customer takes to unload a CN-provided rail car, the longer another customer has to wait for that equipment. Policies that encourage better asset utilization by penalizing delays are fair to the many customers who do load and unload equipment efficiently. What would be commercially unfair would be to let a minority of customers, through their own commercial and operating decisions, not to promote efficiency at their facility, degrade service to other customers and receivers in the broader rail network and supply chain. The board has also asked about accessorial charges. In general, accessorial charges fall into two categories. Most charges are for a menu of optional services that customers can request that CN provide over and above rail line haul services. For example, some of the optional services CN offers include inspection services, private rail car storage when available, and additional switching within the gate. Many customers choose to perform this work themselves or to engage a designated agent to perform the services on their behalf. Other customers prefer the convenience of CN providing the optional services described in CN's tariffs. Some other accessorial charges serve a penalty function similar to demurrage and are designed to discourage customers from engaging in unsafe practices. Safety is CN's core value. Accordingly, CN charges customers for unsafe practices such as tendering overloaded rail cars or for the cost of securing rail cars, leaking hazardous materials or dangerous goods. These charges highlight the importance of safety and act as a deterrent to protect the safety of CN employees and adjacent communities near the rail line we operate through. The purpose of these charges is to encourage safe handling practices. In conclusion, CN believes that its customers benefit from CN's approach to demurrage and accessorial charges, which are aimed at providing services to CN's customers that they want and encouraging asset utilization to promote CN's safe and efficient network. Thank you.
Good afternoon. I'm pleased to describe CN's efforts to be transparent when CN administers as optional services tariffs and CN's development of a customer-centered focused disputes resolution process. CN has developed tariffs to clearly explain the applicable charges and policies for demurrage and other optional services. The tariff changes are communicated directly via email to customers and receivers to ensure that they are all well notified in advance of upcoming tariff changes. In addition, CN's tariffs are available on CN's website through our e-business price documents tool. Each tariff version contains a summary page, and at the end, tariff version revision, I should add, a summary page, and at the end clearly identifies each change made in the particular version. In the event that CN becomes aware of a customer or receiver confusion regarding tariff language, the tariff language is reviewed, and CN may include clarifying language or offer specific examples to ensure tariffs are transparent and straightforward moving in a further revision. CN Optional Services team works carefully to ensure that demurrage and optional services invoices are correct. Slide 6 provides an overview of CN's invoicing process. Invoices for demurrage or optional services can be system generated. They can also be manually based on employee instruction from our crews. Invoices can be subject to manual review when circumstances suggest further review is appropriate before the invoice goes out. I will add that we also have a pre-invoicing process similar to CP, in where we have active dialogue and discourse with customers before invoices are released. CN Information will review relevant information such as contemporaneous crew reports to determine whether demurrage charges are appropriate before charges are invoiced to customers or receivers. If CN personnel determine that the delay is attributable to CN, adjustments will be made for CN to take responsibility and reduce or cancel the invoice. I would like to add in the last 5 weeks, 80% of our customers did not receive a demurrage invoice. Slide 7 summarizes CN's robust dispute resolution process that is designed to ensure that charges are fair and customers and receivers have an opportunity to raise questions about a charge if they have questions regarding that charge or believe it to be incorrect. This informal dispute resolution process provides parties responsible for demurrage charges, such as customers or receivers, with a full opportunity to dispute charges that they believe to be incorrect. Optional services invoiced under CN's Tariff 9000, including demurrage, are covered by CN's 18-15-15 billing and dispute resolution guarantee. Under that process, CN commits to invoice customers within 18 business days of the service completion date, and as well as 15 business days to respond to file disputes through e-business and 15 business days to come back with an answer. If CN fails to meet any of those deadlines, particularly the 18-day invoicing rule, we do not charge that customer. If the party responsible for the charges disputes the invoice in CN's e-bill application within 15 business days, CN does commit to respond to the invoice within 15 days. If CN does not respond within the 15 invoice days, CN will accept the dispute as registered. On some occasions, a dispute that a customer or receiver timely raises and which to CN timely responds may take longer to resolve. In all cases, CN works with its customers and receivers to resolve disputes amicably wherever possible through this informal process. Keeping CN's Tariff 9000 18-15-15 guarantee requires constant effort from the optional services team to promptly issue invoices. We have a staff of 12 people that directly review and deal with customers on these. They investigate the underlying service, and as well as addressing either issues around tariff language and the specifics of data. CN views these efforts as part of our commitment to provide timely and responsive billing to customers and its receivers. Because of the detailed process CN follows to ensure accuracy in its invoicing, it is imperative that customers and receivers do their part to promptly dispute invoices by bringing any concerns to CN's attention with sufficient detail to allow CN to complete a thorough review. Through CN's informal dispute resolution process, it works with customers to understand whether any adjustment to the invoice is appropriate, such as an issue with CN's service. As an example, CN customers can request an interplant switch move online, wherein CN moves cars from one track at a customer's facility to another. If the actual work was performed and the car was placed in the wrong location, the customer can let us know and we will correct that invoice. While CN accepts responsibility where appropriate on the circumstances of our particular invoice, if it is determined that the charge was improperly assessed or that CN was somehow responsible for the resulting charge, CN's expectation is that customers and receivers should accept responsibility and pay valid invoices. In conclusion, CN has multiple levels of processes and people in place to help customers and receivers understand CN's demurrage and optional services policies, and to provide a fair and transparent process for its customers and receivers to address any concerns they may have with invoices for these charges. Thank you.
Thank you. I'll start. I actually have a question for the panel. You've been sitting through the testimony for the past 2 days like we have. I'd like you to comment on what your reaction is to your customers or I'm sure one of your customers probably testified, given the number. Do you have any takeaways, any responses, any thoughts, any feedback that you would be comfortable sharing?
Alphabetically, I think I'm probably on the hook. I think there's a couple things. I think that as we've been here, BNSF, we have not had as many specific instances brought up about our programs. And I think there's a part of us that takes comfort in that, because I think we have a lot of confidence in the processes that we put behind our rules. We feel our rules are clear, and we think that the effort that we put behind that to make sure that the rules are then applied in the right circumstances bears out in terms of our relationship with our customers. I think that doesn't mean that there aren't some folks who would point to parts of rules or have experiences where they would like exceptions or a greater leeway. But we've taken the opportunity, as well as listening to the customers, to talk to some of the customers in the room and seek the feedback in terms of what does work well for us, what are things where they'd like more opportunity to engage with us. And in general, it's been a good experience to hear that. I think that in terms of takeaways for what we might do, I think that we're very curious about where the board is going to go in terms of directions.
I bet.
Yeah, certainly. And like I said, we've been listening carefully to questions. I do think there'll be an opportunity probably in the panel, and I'll let other people react first, to talk about some of the things that we do think that are reasonable in terms of our program that have gotten a lot of discussion, like zero free time, like constructive placement in yards. So I don't want to jump ahead in terms of digging into the content there, but I do appreciate the opportunity to be here and give you guys some of our thoughts on that.
Did you say you thought zero free time is reasonable?
We have zero free time on some of our shipments. I assume we'll talk about that.
Pam?
I'll go next.
Yes.
So, it's interesting being here because we have started our Customer Advisory Council a couple of years ago, and so a lot of the feedback we've received and changes we've made in our product overall has been a result of that feedback. And so I can relate to this environment, although a little bit more charged than I'd say our Customer Advisory Council, in terms of be actively listening. We need to actively listen, and we need to ensure that we're taking a balanced approach. That being said, we are very mature in our precision railroading model at CP, and so we have the benefit of looking at it in the rearview mirror versus being in it. Was it difficult at the time, making tough decisions with our customers? Absolutely. But we have been able to garner significant benefit, some of which I talked to, in terms of the volumes we're able to move, the customers that are coming back online with us, the contracts we're negotiating because of our efficiencies. And so, we have, I guess, a different perspective because of where we are at.
Derek?
And I echo those comments. I mean, you heard me say schedule rarity, and that's what CN did starting when I've been here, 19 years. It was the original one. So we're mature in that concept. But, one thing that I heard from some of the customers, first mile, last mile, that's something we have been focused on for quite some time. And by no means are we perfect, but we know that's a critical touch point with our customers, especially at the last mile. So a lot of the things we have molded over the years, and as we've adapted and changed and evolved, has been focused on that. And, a true supply chain approach that's really been integrated in our mantra, and that's really started in earnest. I'd say I was actually in Vancouver, British Columbia at the huge, that's the biggest gateway to Canada at the time, but imagine Chicago with a port. That's Canada's version of Chicago with a port, basically. So that first mile, last mile touch point is something we have and continue to really focus on. But yeah, no, I'm just using an example by the, that's their biggest gateway. So, but it's very similar to Chicago in some aspects. It's a smaller Chicago, but with a port. So, it's one of those items that we realize there's those touch points and they're critical to it. But once again, similar to CP and the evolution of it, we've been I don't say the granddaddy of it, but at the end of the day, this has been going on in our area since 2000. So while we still have, I'm sure, agree to disagree with some of our customers from time to time, overall, the relationships are much improved and we continue to grow our business. Of all the class ones, we've had the largest amount of growth. And April of this year was our record GTMs of 1.5 billion a day on average over 7 days. It's never been done before in the history of our company over 100 years.
Pam, I have just a couple of questions based on your written testimony. You had mentioned you have CP's customer service team, and I'm curious how many people you have assigned to that.
So we have just under 60 individuals assigned that support both carload and intermodal volumes.
60?
60.
And you also had mentioned that you conduct surveys periodically, and do they touch on Demurrage and Accessorial? And if they do, could you comment on what some of your customers have responded?
Yes, they do. And so we work through a third party, Ipsos Reid, to ensure that we have phone calls and or emails to ensure we reach a certain amount of population. So it's also statistically solid as well. And in terms of the questions we ask, it is about overall operating service. We get into invoicing through the myriad of, I'd say, the 360-degree view of a customer from the moment that they contract with us through to invoicing. We ask them questions about all aspects of the business. In terms of Demurrage and Accessorial, to be quite frank, we get more feedback about our invoicing than we do about Demurrage and Accessorial. And invoicing, I mean our freight invoices and our processes around our technology than we do specifically about Accessorial. Now, that being said, we do get some feedback from our customers around operations and first mile, last mile. And that is why we have instituted some of the processes that we have in terms of how we build our trains and our yards and our audit procedures to ensure that we are successfully looking at that component of the business. So I'd say largely we're hearing first mile, last mile, and that we're seeing that dial move over the last couple of years given our focus in that area.
Move positively.
Yes, correct.
And I think you also said that largely your tariffs have been largely unchanged since 2015. And I think, I'm going by memory yesterday, but I believe NGFA testified that there's a new charge, something to the effect that there's a $500 diversion fee for a car, somehow even if CP is responsible. I didn't have the exact language in front of me, but maybe you know what I'm talking about and you could explain it.
I do, and I wasn't going to talk to it unless you guys brought it up because that information is incorrect. We have not changed our diversion fee since January 1st of 2016.
Is it not $500?
It was $533 and it moved to $535 on January 1st of 2016.
So it's a okay. All right, thank you.
Just jumping into the idea of credits, for, I guess, Derek and CN, can you maybe explain at me at the outset why you all give a credit generally?
Sure. So we give credits for two reasons. One is we have a loading and unloading credit, so this is built in to the rate. And then we also give credits that are related to service. So if we have missed switches, or we start to see an accumulation that's related to CN activities, we give credits to compensate.
And on that latter category, it's because you all believe that your service caused some sort of harm to the receiver or shipper that you want to account for with that credit.
We believe that the shipper was not in control of the circumstance that caused the incident. So yes, we provide a credit to correct for that.
And you'd agree when that usually happens, there's some sort of negative effect on the shipper for some sort of railroad caused delay.
I think that really depends on the shipper themselves. If they're in a situation where that product,
But sometimes that's true.
Sometimes it may be true.
Okay. And so I noticed that your all's credit expires in a week?
So that's the loading and unloading credit.
Okay.
So the service credits do not, they're effectively, they offset something that's incurred.
I
So
see.
The fact that something may go over the span of a week,
Right.
it doesn't, there's no impact.
I
We
see.
Continue to credit essentially until that situation has been resolved.
I see. So would it be fair to say that your service-related credits don't expire?
That's right.
Is-
They're applied immediately to offset the underlying condition.
Okay. Is the same true for CP and BNSF? Do any service-related credits expire?
So for CP, it's on a 30-day.
And why is that?
So the reason for that is that we do believe at some point in time, having credits extend for unknown periods of time does not have the right behaviors in terms of ensuring our assets are moving.
Why is it the right behavior at day 29 but not the right behavior at day 31?
So fair enough, there had to be a cutoff point.
Why did there have to be a cutoff point?
If we leave credits going in perpetuity,
Right.
then I guess the question I would ask back is what then enforces the behavior of having those assets fluidly moving?
I would say the same reason that you would excuse something at day 28, which is that you, in some cases, imposed a harm on someone that you'd want to make up for. That's the whole purpose of the credit, as I understood it, right? If there's a service-related credit, you imposed a harm by missing someone's switch, so you wanted to remove a debit, which is a harm, I guess, could be considered imposed on you all or some other customer. And so, it's kind of what's fair is fair.
So I can understand your perspective, and again, just speaking to why CP has put the 30 days in place is that we want to ensure that there is behavior change when there is demurrage charges, and that having credits that go on for perpetuity may mean that the customers aren't making the right decisions around the assets.
But,
and we've seen it.
And we all want an efficient movement of cars. And so, the way I look at it is like, if there's a misplaced switch, or if there's a missed switch, then that's not an efficient movement of cars as well. There's some sort of, some of it could not be your fault. Some of it might be your fault, right? There might be a missed switch that's just your fault. Yeah. And there's a national need for the efficient movement of cars. And that's an instance where maybe it didn't fulfill. So if a credit expires, then doesn't the incentive work on the other foot, which is that, hey, this credit was given because I've now contributed to the lack of efficiency in the rail network. And therefore, if the credit's just removed, then that means that the credit is a lower incentive for you all. Would that be a fair statement?
Yeah, and I just want to make sure it's understood that for us, it's a rolling 30, not that if you have the 28th day, on the 30th.
How often do
day,
credits
that's
expire? I mean, is this even a problem?
I honestly don't see it as a huge problem. We have very large customers that, generate a lot of credits. And to be frank, and I know it's discussed before, is that if there are issues where customers bring that up as being an issue into the next month, we will review that.
Okay. And then talking about deadlines for responding, I think, Joe, you mentioned that you all endeavor to get back to people within a day or two, and I take that to mean substantive responses.
That's our goal, but
Yeah.
certainly we make sure that we get back to someone within the next business day, knowing that we've received the complaint. And often, they're straightforward.
Yeah.
So we're able to address with them in a couple of days.
And I think that's great. And, it sounded like everybody has at least 15-day deadline. Is that fair?
Not for us.
No, not for you all, but at least 15 days, or I'll say better, 15 days or sooner maybe to respond. Is that fair?
That's particular to our invoice.
I see.
That doesn't include all the work we do up front.
Sure.
To try to prevent the invoice.
Right. No doubt. No, I hear you.
And a lot of that work is done without the customer even being involved, because we're auditing operational movements and making adjustments to records.
And we've heard a lot about the burden of disputing things. And, I guess the first thing is just, getting a response, right? And so can you all, is there a scenario where if a railroad failed to give, I'll say, a substantive response within 15 days, that would be appropriate or reasonable? Is there a scenario that you can think of? I mean, you all seem to endeavor either require internally yourselves to do, or, much better, So I'm just wondering if there's not a railroad response within 15 days, is that ever reasonable? Substantive response.
I can answer for CN.
Yeah.
So typically, we're very specific in what we put, actually applies our 15-day billing guarantee. So the ones that we're not able to get timely information back, it's typically things that we're working with another third party to essentially cross-charge or bill that our customer on behalf of that third party. Those we would exclude. In every other case, we typically are able to respond much faster than 15 business days.
I have many, but let's just keep rotating.
Hi. I'd like to just dispense with that last point quickly and then go on to some questions I have. At CP and CN, if the customer doesn't complain within 15 days, are they out?
No, they're not.
So there's no time limit on their complaining? It's just if they take longer than 15 days, then you don't obligate yourselves to get back in 15 days?
That's correct.
Okay. Is that the same at CP? So let me go to some broader questions, and I'm just go down the panel. Jill, of your typical demurrage charge, I assume it's 150-ish in that ballpark?
It is generally 150
Yeah.
for merchandise, yeah.
And how much of that is penalty and how much of that is compensation?
A couple points on that. One is that we have not actually changed our rates since 2015, I believe. So our rate has been fairly constant. So in terms of a recent increase that fits into one category or the other, we just don't have that history or experience.
Well, when you set it at 150,
Yeah.
what part of it is penalty and what
Yeah.
part of it is compensation?
I think, to be frank, we are really prioritizing driving the behavior. So in terms of the cost at an individual location, what part of that would be compensated by 150 is going to be frankly wildly variable, depending on the day, the terminal, the facility. And so I think in general, if you talk to our operating folks, because of all the costs associated with a delayed shipment beyond the actual cost of the equipment, so the track, the crews being burned, I don't think they would really think of the 150 as an opportunity for a full cost pass-through. Instead, what I think we do is look at is the rate that we're charging effective to get the behavior? That's not irrelevant to cost, but it's not driven by cost.
Well, when you set the rate at 150 several years ago, you set the same rate for everybody.
We did.
So in order to arrive at that rate, did you figure that some of it was cost and some of it was penalty?
We thought of it, I believe, as fully incentive, though obviously if you're collecting something in terms of incentivizing behavior, that is going to defray costs. But we do not have a component that says $100 is the cost and the $50 is the penalty. And part of the reason why I think that's a reasonable approach for us is because we do then spend the time saying where there's railroad fault, then we're going to not have demurrage apply in that instance. And so the sort of split between what's penalty versus what's cost is perhaps more relevant when you're talking about not properly taking responsibility when it's railroad fault. But I think we think of that as sort of we think of it as our entire program and how all of those terms come together to make us feel like what we've done is set the right incentive with reasonable terms and reasonable application.
I'm just going on some of the case law. Not all of it, some of it. It's not all totally consistent, but there are cases, which I'm sure you know, that say that unless you can show the shipper is at fault, you can't collect the penalty portion of the demurrage charge. So if you were in such a litigation session, how would you tell the court or this board which part you're entitled to collect and which part you're not?
To be honest, I'm not sure that that's really case law that applies to current circumstances. I believe there was some subsequent case law that talked about the fact that the responsibilities of the railroads are to look at where we are at fault and make adjustments and not put a customer on the hook for a charge associated with that. But we can provide a more fulsome response.
I'm going to come back to that issue in a minute. I'd just like to find out if the other two can answer that question. Pam, do you have a portion of your demurrage charge that's attributable to penalty and a portion attributable to compensation?
So the way we look at it is that we are looking at the costs, and I can deconstruct some of that for you without getting into particulars because of antitrust, but I will do my best. So what we look at is, so car hire, there's a certain charge for car hire per day. We look at cost of failure to supply for the next move, and the next move may be for that customer and or other, which is an opportunity cost. We look at rolling storage prevention. So we do have customers in particular that participate in spot markets where their forecasting is not known to us, and therefore we have to, it's surge capacity that we were not aware of, and they take advantage of our assets as rolling storage. We also look at incremental yard switching and processing costs. So excess equipment in the yard causes more switching. And then we look at our local service failure costs. So yard congestion can risk crews running out of time to service other customer needs. And this requires us to provide credits to other customers that we weren't able to fulfill their demand or incur costs of a recovery switch. So those are all some of the things that we look at. And to be quite frank, the charges that we have do not cover that cost. And therefore, I would agree with BN is that we're looking for the rate that incents the behavior change because it is not covering our cost, but we're trying to be balanced and fair to our customers to see what is the charge that will create the necessary change.
So is it your testimony that no part of your daily demurrage charge is penalty? It's all compensation?
It is compensating for our costs.
Entirely?
Entirely.
And you're saying it doesn't always meet it?
It, in most cases, would not cover our costs.
Marty, could I jump in on this?
Sure.
I know you were.
No, go ahead.
It's because it's something that came up in panel 2, and I'm trying to understand, and so maybe this panel can kind of bring a little bit more clarity. You said it's the charge necessary to incentivize, or I think you said that necessary to incentivize the behavioral change you all want, or the necessary behavioral change, something to that effect?
Because we feel that covering our total cost would be detrimental to our customers.
Okay, so I guess I'm trying to understand, how do you define what is the necessary behavior? Do you know what I mean? 'Cause every dollar you add, it's going to change the cost calculus for somebody, right? Someone who's evaluating whether or not to continue to pay the demurrage charges versus whether or not to invest to expand their facility. The higher and higher you go, the better and better that investment looks, for example. And so you all have to draw the line. What are the specific criteria for evaluating the behavioral change that you want? What are you looking at? How do you know that you've gone too much or too little?
And I think that there's some factors to that, which I've included in my testimony, is that we're starting to see our demurrage charges going down, which means...
I mean the rate.
Okay, the rate itself.
Yeah.
But I am going to relate it to that in the sense that when the demurrage charges go down, that means we're incenting the right behavior.
Right.
As everybody is saying, is that we are not here to get revenue from demurrage. I would rather get a freight movement. It is much more beneficial to the railroad to get a freight movement than to have a car sit. And so we know when we're doing the right things because we can actually see the inverse happening, which is it's not going up, it's going down. I feel that when you're seeing increases, then maybe you don't have the right charge in place.
Is that a sufficient criterion? Because you could imagine, I hate to give these crazy hypotheticals, but I'll give you a crazy hypothetical. Some of you are used to them. If you were to charge $1 million a day, you'd probably get no demurrage. You know what I'm saying?
And no customers.
Right. Well, exactly. And so I guess that's, is that, you want to charge up into the point where, so what I'm hearing is there's a revenue curve and you're charging at the top of the revenue curve.
Not necessarily, and our program maybe works a little bit different than others in that we do it based on our fleet as well, right? And fleet. the supply and demand of our
Right.
fleet will also change our charge.
Right.
Because if we don't have that next opportunity.
But you know, I'm hearing from this that the primary evidence that you're giving that you think you've hit the right balance. And I think I keep on focusing on the level of charge because it's easy to conceptualize, but I think the same applies to free time as well, by the way, and other practices and credit usage. But the evidence that you're giving is that now your demurrage charges, the total revenue is going down, right? And, you know, and so like, is that the criterion railroads should just keep on decreasing free time and increasing rates until we start to see demurrage charge go up and up and up until there's something that happens where demurrage total revenue goes down? Is that what we should be looking at for the appropriate criterion? Or is there some other way you price? Or think about running your systems.
We go through all of the criteria which I just stated.
Yeah.
But then we are trying to be rational and balanced. I get that you're trying to say.
I know. I'm just
keep
missing
charging
I guess I'm just
until-
missing the criteria. Like, is there a change in, like, let's say percentage of shippers who unload within 24 hours, right? Percentage of shippers who leave things in constructive place. I mean, the actual things that the incentives are linked to. Are you measuring each of those and seeing how you move the dial and that sort of thing? That's what I'm kind of
Yes.
looking for here.
Yeah, so we are looking at the data to say how long are cars dwelling at a customer? How long until they're able to take them in to their facilities? How long are they even in their facilities, depending if it's private and or railway equipment? How customers release that equipment?
Yeah.
We look at all of that.
Yeah.
But at some point, because we can't fully recover our costs,
Right.
we come up with an amount of a charge that we feel is reasonable.
Okay.
And that being said, in regards to free time, I'll
Yeah.
just comment on it now. We have had free time since back in 2013.
Right.
So
Okay.
we haven't changed that at all.
So I don't want to, because I know my colleagues have a question. So you mentioned reasonable, so I think it's the next step, which is, okay, so you're saying that you're not recovering, you know, your costs and you're looking at the incentive and you would actually like to go more, but you've made a determination that, or, you know, obviously you want to cover your costs, right? So you'd like to go more, but you've made a determination that anything more in terms of either cutting free time or increasing level would not be reasonable.
Correct.
Okay. So if the board has a reasonable practices authority, and we have to make sure that things are reasonable practices. So, you know, demurrage is a practice, and what you're saying is you've made the determination on what's reasonable. Okay, so if you were sitting in our shoes, what is the criteria you would, receiver comes and says, I think this is unreasonable. I'm like, well, if we were to take the CP test, what would we do?
Okay. Can I provide some further information in terms of some of the expectations we have from our customers?
Yeah.
Because I think yesterday it went from A and I'll say Z.
Yeah.
I'm from Canada, but I'll say Z.
Okay.
So some of the things our customers can do, I did listen yesterday, so I made many notes. I've been very thoughtful about this, so linear volumes. So looking at the volumes, providing accurate volume forecasts. There's a lot of times where volume will just show up on our line unexpectedly. We have to plan, as other roads, a huge network. We have crews, we have locomotives, we have assets that we have to prepare for. Ensuring adequate track capacity and or private storage is available. Loading and unloading schedule for staff to mitigate demurrage. So, you know, I did hear not all, but some customers talking about that they work Monday through Friday, 8 to 5. We're a 24/7 operation. And as such, we would like to keep those assets moving effectively for all customers. Utilizing tools available. So customer login issue. We have opportunities for our customers within the visibility that they have within the tools to log issues with us when they see that there's an issue with the movement. Manage invoice dispute process. Reviewing inbound pipeline and monitoring car statuses, ordering from the pipeline. We at CP offer a service, particularly because we know people don't work 24/7, where you don't have to wait for that car to arrive in the yard. You can order it from the pipeline while you're still at work for the day. And then managing the whole pre-invoice process. So, you know, for for us, there's a lot of things that are within control of shippers and receivers as well.
And I appreciate the thoughtful documentation and listening to everybody's testimony, and because I think a theme was yesterday is what can shippers do. So I appreciate you laying that all out. I think okay, so those are all the things they can do. And one of the things that Derek said that I thought was really interesting is if some customers are not loading and unloading efficiently, it could hurt other customers. And of course, generally hurting the rail network and then hurting other customers and hurting you all, at the same time. So is that how we should be thinking about reasonableness? Which is, look at, okay, what are the effects of that loading and unloading practice if it were the less efficient one, relative to all the different ways that a shipper could comply. And if there are scenarios where the cost to the shipper are greater than the effects of not complying with the lower free time or what have you, that we should say, that's not reasonable. If you have to spend $1 million in track and, whatever benefit you're having for the rest of the customers is smaller than $1 million, we should say, this bill's not reasonable. Is that the type of thing that we should be thinking about?
Well, maybe I can bring an operational point of view to this. Obviously, how the demurrage rates are set, that is not what I do, but perspective-wise, like you said, the operations teams, I don't want to collect demurrage. I want to have a fluid rail yard, a happy customer, and move their product safely and efficiently. And that sometimes I think gets lost in some of this because it's so contentious, but from an operations point of view, we don't want to collect that. And the supply chain is very important. As she mentioned, forecasting is a huge part of what we do. It takes us 6 months to qualify a conductor. It's 9 months to get a qualified engineer. We're the only railroad that was in market for locomotives. GE had to reopen their factory in Fort Worth, Texas. Imagine lead time on a $4 million Tier 4 locomotive.
Right.
So the scalability for a railroad, we want to be nimble, we want to be customer-centric, but we can't always be as nimble, especially, we are commodity dependent, so are many of our customers. Those commodities have seen some pretty significant swings over the past decade. And, commodities are important too, because price has a lot to do with that. So when you look at a supply chain, you have, say, a customer that gets a very good price on a product, they can maybe say, hey, handle 5 cars a day, 5 days a week. Well, they may go buy 100 cars of that product, and it's going to come. It's a business decision they made. I don't blame them for making that decision, but then all of a sudden demurrage becomes contentious. But even with the demurrage rate, they still make money on it. So those are part of the supply chain challenges that we deal with on a daily basis, and we're not always perfect. The customer's not always perfect, but our ability to be nimble isn't as quick as many people would expect, just because of some of the things we have to do to ramp up or ramp down.
I hear you, and then I appreciate the operational perspective, and it came through in your testimony. But I'm thinking, for Jill and Kathy, from a legal perspective, is a what I'm kind of describing as a benefit cost test that was talked about yesterday. I think particularly in the chemical panel. Is that type of thing appropriate for judging the reasonableness of demurrage fees?
I think it would be particularly difficult to try to develop or endeavor to develop a one-size-fits-all cost-benefit test that would apply to all of the varying circumstances of different customers and terminals on individual railroads and the multitude of factors that go into the supply chains and the commodities that are shipped on the rails. One theme that has emerged from all of the testimony that the board has heard over the last 2 days is that there is really no one-size-fits-all solution here. And that might be particularly frustrating or dissatisfying, but I think it's fully consistent with the long line of demurrage case law, both at the board and in the courts, where the board and courts have struggled with the fact-specific circumstances in individual demurrage cases when they are not able to be resolved and they result in litigation where a carrier is trying to collect demurrage charges from a customer. And then it's really delved into the details of the particular invoices, the particular service, what happened on that day, was there over-ordering, what contributed to it. And so it is very challenging, and I'm not sure going to be the right use of the board's resources or time to be focused on that aspect, as opposed to focusing efforts on other areas. And One area in particular, improving dialogue and transparency, the way that the board has asked the railroads to make more easily available the demurrage revenues that were previously reported to the board in a line item in the R1s. That's an area where it seems like very easy for the board to do, and it makes that information more readily available to customers. We, of course, are speaking individually with our customers on a routine basis about these issues, and we work hard with them to try to minimize the amount of demurrage invoices that they're incurring, because as Derek said, we want them to load and unload the cars as quickly as possible, and we wouldn't want anything to incentivize them not to do so.
The last part I'm wondering about, but it sounded like you've done kind of an exhaustive analysis of the case law, which is very much appreciated, and I guess I'm wondering, okay, so cost benefit test, impractical to apply, predominantly not a good use of the board's resources. And so what are the guiding principles we should have for the reasonableness of demurrage, maybe with an example of, give me an example of a demurrage fee that is unreasonable, and hypothetically even.
And let me be clear, when I say not reasonable or not a good use of resources, I mean in a broad general, trying to construct in advance a one-size-fits-all rule that would govern all future cases, as opposed to the individual adjudication, the way that this demurrage
But if we were to
typically resolved.
When you say one size fits all, if the board were to just come out tomorrow, and I'm not suggesting that what's what we want to do, but it was a suggestion yesterday. If the board were to come out tomorrow and say that, shippers and receivers can challenge any, when we look at reasonable rules and practices, if anybody can bring a complaint that basically says for their particular circumstance, the cost of complying with this is not it's not worth it compared to what the railroad's getting if I did comply. With that, what you're saying is that would not be a good policy statement for the board to make.
I'm not sure that would be the best way to focus the board's resources, and I welcome, of course, Jill's and other people's inputs on these topics, but in our view, this is a very fact-specific situation.
But we would still be talking about fact-specific cases. I'm saying the policy statement would be, when you bring your fact-specific case, tell us about your fact-specific costs, and the railroad would say their fact-specific benefits. So it would still be fact-specific.
So at that point, is it very much like an adjudication as
Yes.
opposed to a policy statement, or as opposed
It's a
to
policy statement that would guide an adjudication.
I wonder, though, whether that would be possible to be done in the fact-specific context of an individual customer or an individual terminal on an individual railroad. These issues don't wash out the same way with respect to various commodity groups, and it is very, I can't emphasize the amount, and I'll turn to Derek here as well, to which these issues are very fact-specific and very much depend upon individual contexts and are not the same. There really is not a one-size-fits-all solution here, but the most important thing for us is incentivizing efficient loading and unloading of rail cars so that we can maximize the asset utilization on our network.
It's highly variable when you look at the customers. They all have different supply chains, different needs, different commodities. But one other thing for the last few days is a lot of the folks talking about just working Monday through Fridays, and you've mentioned it here, both of you. Could you imagine if the railroad decided to shut down our 4 hump yards, our mechanical facilities, and everything else on Saturdays and Sundays, what that would do to the supply chain? And I don't mean that in a disrespectful manner, but it's one of those things where we have terminals in certain locations that only work Monday through Friday. Cars keep coming Saturday and Sunday. So it's one of those things. It's not meant to be a penalty or anything else, but we really try to get everybody in the whole supply chain for that 7-day week.
But you understand that maximization of loading and unloading implies not considering customer costs. So are you saying that we should never consider customer costs in evaluating the reasonableness of a rule or practice?
To Kathy's point, it's very specific. We have a number of, call it smaller customers and operations that they don't have the volume that we'd never expect them to do that. We actually have called day-week service. Our transportation service plan is set up where we are very intertwined with those customers. So we say we have somebody that only has a 2-car spot. Well, they may only have enough business to only service them 2 days a week. So we tailor that. We may go service them on Monday and Wednesdays. And we're not perfect, and neither are they. But in some cases, we've had some of those smaller shippers have some pipeline issues, and because they want to order a cheaper product, and we work with them. But we work with them to balance that out. They come to us for help, and it's so very.
And I don't want to dominate the question. I know Ann's got questions. I'll just say that you all are familiar with benefit costs in a number of contexts. And if you were to go to the FRA, for example, and say, I want you to make decisions on benefit costs, and it's separate from doing a decision for a regulatory policy versus an individual policy between two businesses. I understand that completely. There's a million reasons why. But if you were to say that, you know, if you were to say FRA maximize safety versus FRA weigh benefits and costs, those are two different concepts. And so if we're maximizing loading and unloading, that's like maximizing safety, right? But you all, in other contexts, frequently say, consider cost, consider cost, consider cost. And so I guess I'm never hearing as part of this discussion a consideration of customer costs. And I guess I'm wondering, is it not appropriate that we should even be thinking about that? Is it in the demurrage context, it's so different than the regulatory context, we shouldn't care about customer costs? Somebody help me out with that.
Yeah, maybe I can try. What I would say is, I don't think it's irrelevant, but I think also you have to take a bigger picture view of the cost and benefit. And if you're going to judge the reasonableness of a demurrage program, you need to think about not just, I think maybe we talk about the network, but in reality, the network is our collective customer. There's 272,000 cars on our network right now. We're not trying to get efficiency because it makes us feel good. It's because we have a bunch of shippers who need us to deliver their freight. And frankly, I think a lot of those shippers would be concerned about not having clear general rules of applicability that tell them the rules of the road and say, okay, I know what I can and can't do to avoid those costs. And I give you the tools. What I think in terms of reasonableness for us is we give you the tools that enable you to engage with us, to show us when it's our fault, to make sure we're taking credit for when it's our fault, because then we bear those costs. So that goes right to, those inefficiencies fall at our foot. But if you're thinking just about the cost to an individual shipper who may not be operating their facility in the same way that most of your customers are, then I think you're going down the wrong path in terms of what the STB has also previously recognized in terms of the level at which you're supposed to consider reasonableness.
So I think yesterday I mentioned the one-size-fits-all concern I have, not from your perspective, Kathy, but rather how demurrage charges are being imposed on the variety of customers. You know, we heard, and I'm not picking on any of you necessarily. I think we heard a lot about, I'm going to say, you know, Ben from the Consolidated Scrap Resources and what was going on with NS's new charges, where no matter, I mean, he doesn't have the space in which allows it, so he can do anything to avoid the incurring demurrage costs based on the changes that they've made. They basically have imposed it sort of a one-size-fits-all. We heard from the Barilla just a few moments ago that they can't unload a unit train in 24 hours, but that's, you know, UP's one-size-fits-all demurrage imposition. And so you got to look at it both ways. Or reconsider it, I guess I should be saying. It's that, I mean, I know that it is good to have clarity and transparency, and I guess I mentioned more, maybe like, I don't want to say uniformity in any type of a antitrust concern for the railroads. I don't mean it that way. Maybe the uniformity needs to come from some direction from the board.
Well, if I could comment on you mentioned the unit train. I remember that was a topic of discussion yesterday. You know, from an operational point of view in our supply chains, and you know, we've been at this at least from our schedule rating for 20 years. We know what facilities in the supply chain can actually do a train if it's in 12 hours, 18 hours, 24 hours, and we've worked with them so where we know we can maximize the use of our assets, working with the supply chain, whether it's the receiver or shipper, we do that. But they also know if that sweet spot's going to be more than 24 hours, we moved that in the manifest network for the last 20 years. So it's one of those things, it is about balance to your point, but at least I can speak on behalf of CN from an operational point of view. We have that dialogue so we know what customers can be unit train centric and actually turn the assets that quick. We know what facilities can do the same thing on the receiving end. And you know, we had some contentious stuff with a facility and a shipper and ourselves, and we sat down in a room and we worked it out. Then we went out and set a record the following year, the best we ever had for all three of us. But it's that supply chain mantra that you've got to work on there. At least from a CM point of view, we work with them so they realize this makes unit train sense. It's capable through the whole supply chain, not just, okay, we can load it at origin and 16 hours, but then it goes to destination and sit for 3 days to unload it, because it's got to match, and that's at least what we've done over the years. So at least at CN, that is not as contentious of an issue.
Well, I will say it's not lost on me that the two carriers that seem to have had the least amount of criticism directed or concerns directed at them during these 2 days of hearings have been BNSF, who is not doing precision scheduled railroading, and I would say KCS, who is in the early stages of some elements of it. And so I think that's somewhat informative as well.
I'd like to pick back up on just finishing the line of questioning and then go on to some other, a couple of other subjects. So let me go to CN on the question of telling us how much, if you can, of your demurrage charge consists of compensation and how much of it consists of penalty. Are you able to answer that question?
So I would tell you that our response is very similar to CP's, and the fact that it's incredibly complex to look at an individual yard and customer scenario and try and determine the costs related to it. We, as well as similar to CP, believe that in most cases we're actually undercharging compared to our costs for said service.
Well, when you set the amount, which is, what, 150?
So actually, just
Typically.
a point of clarification on the amount. So we actually have different amounts based on the terminal. So it was mentioned before, the Chicago terminal and Vancouver areas have higher rates because those are key. They're the heart of our respective networks in Canada and the United States. We are trying to drive the right behavior, and it is our view that a higher charge in those areas drives that behavior.
Well, it's $300 in Chicago.
It is not. It is $170 for a system car.
Oh, okay.
And is $120 for a private car.
So the 170, did you calculate at the time you determined that to be 170, that a portion of that was for costs, compensation, and a portion of it was for penalty? Or did you just not make that analysis? That's what I'm trying to get at.
It's, I don't have that information. I believe we did do an analysis. I cannot give you the breakdown of what that cost might be specifically for Chicago.
How about any other place?
Not with me today.
Can you provide us with that information? If you did make, and I'm not asking you to go out and make a new calculation. I want to know if you made a calculation before these hearings started to separate out the amounts. If you didn't, okay, and if you did, I'd like to know what it is.
We can respond to this question after and under seal.
Okay. The free time currently on BN is?
So it depends on the equipment involved. So for railroad-owned equipment, in that instance, you have a shipper who is potentially responsible on the clock for demurrage purposes for when it's sitting in our yard, so when it's constructively placed and when it's actually placed. And so for an empty car that's being loaded, there's a 24-hour or one credit. It's 24 hours, one credit assigned to that. For unloading, because that's a process that often takes longer, it's 48 hours or 2 credits. And so that's for your railroad equipment. Now, when you switch to private equipment, this is something I think is helpful to give a little information about. So private equipment, we do actually offer less free time. And part of that is because there's actually only constructive placement time that you're on the hook for. Because when it's your own equipment, once we actually place it at your facility, then you're not on the clock for demurrage. So it makes sense that there's a differential between a railroad car and a private car, because you're not trying to account for the loading, the actual loading and unloading. You're only dealing with when it's sitting in the yard.
But to make sure I understand that, Joe, sorry to jump in. For the unloading, so the difference is it's 2 versus 1 credits per. Yeah, okay. So I've been kind of wondering this. You've heard me wonder this question. So okay. So are the 2 credits broken up such that one of the 2 is only for CP or constructive placement?
No.
So in that sense, you still could get a marginal benefit for being a a system car relative to a private car, such that there are scenarios where you could be 2 days in CP and 1 day if you could unload really quickly.
Yes, exactly. And we don't, sticking with railroad equipment for a second, our approach there is, and it's applicable also if it's private, but our approach is, once you come into our yard, after the actual day of placement, then we are paying attention. And you have a credit that gives you I'll stick with the loaded, that gives you 2 days to do that. And what we do is we say you come into the yard and you go on to constructive placement. So we start the clock, after the point where you're free.
Sure.
Then as soon as you request that, you go off the clock.
Clock stops.
It stops. And so if you're a piece of railroad equipment, then if we bring it right to you, if we miss a switch, if you're open you release it on Friday, but you're not open again till Sunday, you stay off the clock until then we actually place it. And then we blend the two times together. So you do have the flexibility to make up if you were long on CP, make it up on the actual placement side. So we don't try to micromanage that between the two areas.
I understand it now. Thank you.
Okay.
You were about to say what the free time was for private cars.
Yes. So for private cars, you get the benefit of the actual placement, which I recognize if you're getting it right at midnight, that's a half a minute. And then you would go on to the clock. But if I can...
How long's the clock?
Sorry, there's zero free time. So you are on. But if I could explain one thing as well. We have different types of facilities. And so 85% of our facilities are spot-on arrival facilities. And so that means they're not in CP unless they don't have a space. And so when something is coming into our pipeline, they have said to us, we are spot-on arrival. And so if I've got 5 track spaces open, you can bring it on in. And we adjust for if they're not open on Saturdays and Sundays. But so you can actually designate yourself as a spot-on arrival facility, in which case you don't get constructive placement unless you have 0 space at the facility.
But the zero free time, to that degree, it sounds like it's the same policy as NS. Is that right?
I'm not sure. I'll be honest with you. I don't.
Okay.
I pay attention to our policy.
Well, it sounds like it to me. And
Yeah.
how long?
It is a 0 free time policy. That's absolutely true, and it has been since 2015.
Well, I was going to ask you, how long have these free time times been in effect? All of them since 2015 this way?
We haven't, and possibly even earlier. We haven't changed anything since that period.
So it's at least since 2015.
Yeah.
All right, and I'm going to come back to you in a minute, but I'd like to go down the line and
Sure.
get the same answers. Pam, what is your free time? If you could
So
just
again, it differs. It's almost exactly the same as what Jill described. We have 0 free time for privates. That being said, we do have open gate, which is the same as place on arrival, where we do provide a credit for that and as well, if you switch your own facility, you get another credit. So there are opportunities.
And for the system cars, it's 24 and 48?
It's 24 and 24 for ours.
Okay.
Yeah.
Oh,
And our policy has been in place since 2013.
okay. And how about CN?
So for CN, it's 1 credit day for loading, 1 for unloading for system cars.
24 and 24?
Yes. And for private cars, so we have a slightly different definition of free time. Ours is actually aligned to the service window. So an example might be if a car arrived on the weekend and the customer is normally serviced Monday, Wednesday, and Friday, they have until 4 hours before their service window would start. So again, their service on Monday, let's say from 8 a.m. to 4 p.m. If they order the car in before 4 a.m. on Monday for that first day's service, they do not pay any demurrage. So in that example, the car was CP'd on Saturday. They would have all day Saturday, Sunday, until Monday morning at 4 a.m. to order the car in before incurring charges.
Okay, and if it comes in on Monday, so I'm lost.
Okay, if it comes, sure. So if it comes in on Monday, and the next service is Wednesday, they would have until 4 hours before the Wednesday start of their service.
Well, it depends on your service plan for that, or the days of service for that particular customer when the clock starts.
Yes, it's personalized in that regard.
Okay, so it's not zero for very many people, it sounds like, unless,
As I mentioned earlier, 80% of our customers do not pay demurrage.
well, are you implying that for people for whom it's zero, they end up paying demurrage?
No, I'm not, sorry.
Oh, okay, well, is it 80% of your customers who don't have zero free time?
That's a mix of between
Is it-
system and private cars. So
Okay. And how long has this program, the 24 and 24 plus the complex description here for private cars, how long has that been in place?
The actual style of ordering it has been in place for at least 4 years. And the credits, we changed the credit from 2 to 1 days on loading in January of this year.
Say that again, the credit?
The credits for the system cars on unloading went from 2 to 1 in January this year.
Oh, it was like BN's prior to January 1 for unloading.
Yes.
Because I'm looking at the numbers and I'm trying to match up the numbers with the practices. So let's go back through the panel here. BN, Jill, your yearly demurrage has gone up 50% in the time period, since before your time period, at least 2015 you said. It's gone from maybe you went up in 2015, because it was 134 million in 2014, and it's been close to 200 million, went down a little bit in 2017 since then. So was there a change between 2014 and 2015?
You're talking about the annual revenues that we've collected?
Yes.
Yeah.
I'm looking at the table.
We feel pretty comfortable that the changes in the amounts that we collect are reflective of changes in volume and mix, and not changes in the rules or changes in the dollar amounts that we collect. We have more traffic, frankly, that's moving, and so there's more.
So the more business
Yeah.
the customers do with you, the more they pay for demurrage?
Well, no, I mean, the more units that are on the system. So
Well-
as a percentage.
Well, that's the more business they're doing. That's how units
Yeah.
get on the system.
Yeah.
I mean, you went from the first quarter of last year to the first quarter of this year, you increased 25%, 46 million to 56 million, or actually 47 to 57. That's a pretty hefty increase quarter to quarter.
But I also think within
So
that period.
what caused that?
I think actually, and I'm looking for the numbers very quickly, but I think if I'm not misremembering our data, there's actually a fair amount of variability within the calendar year.
No, it's only up. It went from 47 million to a little over 47 to 56. I'm sorry, it did go down to 54.
Yeah, I mean.
And then it went up to, but
Yeah.
I'm assuming it's fair to compare quarter to quarter, because winter's different from summer.
It's not just seasonality, it's the mix of our business. Are we moving a lot of unit trains? Are we moving a lot of single? Are we a lot of privates on our system? I mean, there's huge amounts of variability and it's not just seasonality.
I mean, this is an incentive program. We all agree with that.
Yeah.
So what happened to the customers in the last year on your line, or over the last 4 quarters, to change their behavior, to stop being incentivized because they're paying more, so the incentive isn't working? I don't get it.
I don't think actually we've seen that the incentive is not working. I think that what we see is, in terms of the folks who are collecting demurrage, and we pay extremely close attention to who is paying demurrage and why. I mean, I think that and for the reasons I described in my testimony, is because we do think that there are situations where, with better information and better understanding of our rules, customers can change their exposure to demurrage without capital investment. So I think that's an important element. And because of that, we do spend a lot of time on root cause analysis associated with that. And in talking with our teams who are responsible for that, they are pretty comfortable that that is driven by changes in volume and traffic mix.
It's just puzzling to me, because your railroad is the one, at least it says it's not, and I assume that's accurate, didn't jump on the BSR bandwagon full blown, at least as others. And we don't have a lot of complaints about it, but the charges, just seems to me there's been a significant increase without a change in the free time program. So I can't figure that out. And
Yeah, I mean, I think I'll just stick with what I said, it moves in relation to volume across our railroad, and we don't necessarily have consistent volume from quarter to quarter because of change in mix and demand and all sorts of
well, is your
things.
quarter, is your volume up 25% from first quarter of 2018 to the first quarter of 2019? Were those quarters that much difference?
But
in
I think it
volume?
also came down in the intervening period, so.
A little bit, but quarter to quarter, you had $10 million more in demurrage this quarter than you had the first quarter of 2018. So is that all based on a difference in volume between those two quarters?
In terms of my conversations with our internal experts, it's largely driven by volume.
All right, well, look, you know what, I don't have them in front of me. Let's take a look at the volume numbers and see if those graphs go together. Let me go to CP. I see a similar problem or pattern anyway in your first quarter 2019 demurrage is 11 million. First quarter 2018 it was 4 million. I mean, what's the cause of that?
So per our testimony, in those numbers, the way they were sent to you, they include container storage as part of demurrage. It's in that envelope, and over half of the dollar value from January to March 2019 is container storage.
And container storage went up double.
Container storage has gone up as a result of volume that we've secured in terms of international agreements on the intermodal side.
So you're saying that you're charging people for leaving containers on the ground?
This is
Is that what they're paying for?
They are being paid. It's a service that we provide where they can store their equipment at our terminal, yes.
So is that really it's really not demurrage in the traditional sense, is it?
It is not, and
I mean, you're not trying to incentivize them to not do that.
No, it's a supplemental service, and we can break that out differently
I would
for
be
you.
interested if you could break out what the demurrage, that's the incentive to change behavior part of your
Yeah, I
numbers.
have that number, if you would like it, but we can do that going forward in terms of the information we
Okay,
provide.
yeah, rather than take up the time now, why don't you
Okay.
send us something on it?
Okay.
And for CN, there's also, it's just an interesting trend here. You were 10 million demurrage first quarter of 2018 and 19 million, it's almost double first quarter 2019. How does, any of the three of you, how does that get explained?
So I apologize, I didn't bring the 2019 quarterly numbers, but I'm looking at the last 3 years in the board requests of 2016, 17, and 18, and we're effectively flat.
That I see, but 2019, first quarter is $19,640,000.
Yeah, so there is a lot of seasonality to the number. Winter, because of conditions, we generally see a much higher charge, and then in later quarters, it's reduced. So I think if we had to, to forecast what 2019 would be, it would be very similar to the previous 3 years. So
Well, let me tell you this, based on the previous 3 years, you only got $12 million to go for the next 3 quarters of 2019. So you better keep those demurrage charges. I mean, if that's really going to stay flat, it's a significant change. Let me shift gears here because I don't want to run out of time. Keeping you all here. Pam, you made a statement which I find interesting, and I've asked others about it, and I'm going to ask some questions about it. That the Congress requires rail carriers to charge demurrage. And I'd sort of like to find out why you came to that conclusion.
So I think what I said is long recognized demurrage as a necessary mechanism to ensure a fluid rail network, not that we require.
No, here's what you said in your written statement. I think you actually said it today on page 6. Congress requires that rail carriers charge demurrage in order to ensure adequate car supply. I'm sorry, is that your statement?
Okay,
Or is that
see on
CN?
page 6, yeah.
Yeah,
Congress
no, that's
requires.
Pam, yeah. And I think you read it, or said it orally here, but it's in your written statement, I highlighted it. So, where does that come from?
So I think more the perspective I was trying to provide is in relation to the comment that I made on the first page, or I should say the second page, is that it's long recognized that this is a mechanism to ensure a fluid rail network. So perhaps not the best use of words on page 6.
It's important, because you're not the only railroad who's made that representation. And you're not suggesting that if CP said, you know what, we don't need demurrage anymore, so we're just not going to charge it, you'd be in violation of the law. You're not suggesting that, are you?
Not suggesting that at all.
All right, so I'm going to take this as a friendly amendment to the word requires.
Absolutely.
Is that a fair statement?
That is a fair statement, yes.
I want to shift to Kathy and ask you the same question. Is it your view that your railroad is required to charge demurrage?
We believe it's important for CN to charge demurrage in appropriate circumstances to customers to incentivize them to unload and load cars quickly so that they can be released back into the national supply chain.
Being important is a separate concept than whether the statute mandates that you charge it.
Demurrage is expressly authorized by statute under 10746, and I believe the phrase in the statute is shall compute.
Compute, but not charge. Would you agree?
One could argue that shall compute, if you're going to actually incentivize rail cars to move fluidly throughout the network through efficient loading and unloading at facilities, that one would need to invoice a customer in order to incentivize behavior. In those circumstances where demurrage invoices are appropriately assessed.
Well, I really want to press on this issue because I think it's quite important for how we deal with it under both the statute and our regulation. So I'm going to press you a little bit on it with all due respect. If you chose, I'm going to ask you the same question I just asked Pam. If CN said, you know what, we're not going to charge demurrage anymore, would you be in violation of the law?
I don't know that we would be in violation of the law, but it would not be incentivizing the rail cars to move
That's a
from
separate
the
point.
network to be loaded and unloaded as efficiently as possible. And where our overall goal is to maximize the capacity of the existing assets and encourage customers to load and unload their equipment quickly and improve network fluidity, it would not accomplish the statutory goals that Congress has laid out or our own goals that benefit the entire supply chain.
I understand that. I am really trying to separate this out, if you'll humor me on this. I want to know if the statute, in your view, requires you to charge demurrage, period. Do you have an opinion one way or the other?
Railroads are authorized to charge demurrage
Authorized.
under the statute, expressly authorized to do so.
I didn't ask if you were authorized. We all agree you're authorized. I'm asking you if you're mandated. Could you just give me an answer? If you can't answer it, then tell me if you want to research it more. But I think it's an important question. It shows up in Pam's testimony and it shows up in your lawsuit with Kinder Morgan. And that's why I'm asking the question.
Our complaint in Kinder Morgan intended to describe and summarize the statutory provision of 10746.
Your complaint says that 746, under 746, CN, quote, has an obligation to compute, you said that, and to enforce. That's what the complaint says, paragraph 10. So if you didn't enforce the demurrage rule, is it your view that you would be violating the statute?
I don't know that I would say it's that we would be violating the statute, but we wouldn't be encouraging customers and terminals to load and unload the equipment as quickly as possible.
Well, that's a separate question, it seems to me. By not charging the full cost, as Keith said, and everybody seems to say, in your demurrage rate, do you think you're not enforcing the congressional policy behind demurrage?
No, we're trying to incentivize customers and terminals to load and unload equipment as quickly as possible. And even if that means that the full cost of that equipment dwelling in a yard cannot be recovered. The important thing is about incentivizing the behavior to try to encourage customers and terminals to organize their actions in a way that will enable them to load and unload the equipment as quickly as possible.
Well, would it be fair, would you agree that the railroads have leeway into how much to charge in demurrage? You don't have to recover your whole cost, none of you do, and you don't think you're violating the statute, right?
Correct. Railroads have discretion in setting their demurrage policies so long as they're reasonable.
Reasonable to the customer,
Reasonable to the board.
to the board. So if you set your demurrage charge at $5 and we thought it was reasonable, that'd be okay?
I don't believe $5 demurrage
No.
would incentivize customers and
No, that's
terminals
not-
to load and unload the equipment as quickly as possible.
That's not my question. My question is, if you decided to charge $5 voluntarily, and we said, that's fine, then we'd all be okay under the statute?
It would be okay under the statute, but that wouldn't necessarily suggest that $5 is a limit on the future amount that might be appropriate to be charged. It wouldn't enable you to conclude whether or not that was a ceiling.
I'm not suggesting $5 is the right amount. I'm trying to understand the law here, or at least in your view of it and the railroad's view of it, so we can have some guidance going forward. Let me shift gears. I'll start with you, Kathy, and come back down. Is it your view that in order to be liable for demurrage charges, the shipper or receiver or whoever is getting the bill must be shown to be the cause of the delay?
Under the case law, the burden is on the carrier as a complainant in a demurrage collection case to show how the charges are computed and the date that the car was placed in actual placement or constructive placement. And then the burden shifts to the respondent to indicate whether or not those charges were unreasonable.
With all due respect, Kathy, it didn't answer my question. My question is, does somebody have to show that the person, the entity being billed for the demurrage is the cause of the delay? I didn't ask you who had the burden. That's another question. It's something I'm quite interested in. But I'm really trying to find out if approximate cause or any cause concept is required before demurrage can be collected.
As Keith explained earlier, under our pre-invoicing and invoicing process, if CN is responsible, CN credits the customer, and that is not treated as demurrage.
I really didn't ask your practice. I asked what you think the law requires. Does it require that the person receiving or the entity or whoever's getting the bill and expected to pay for it be shown? Who has the burden is a separate question. Ultimately, to be found by who's ever going to rule on it to be the cause of the delay in order to be liable for the charge. Is that a requirement under the law to your understanding?
My understanding is that in a straightforward, and we view these as by the time you get to the point where you're actually in litigation with a customer, we have gone through our informal dispute resolution process where CN has a detailed review with our customers about what has happened in the individual circumstances of those particular invoices and has made adjustments as appropriate. And if at the end of that process, if we're not able to reach agreement with the customer and we do have to take that next step of going to litigation, at that stage it's a matter of demonstrating when the car was put into actual placement and constructive placement and how the charges were computed. Because the information has already been gathered and analyzed and looked at about the circumstances of the particular service at that stage.
Does that include your showing that the customer that you're suing was the cause of the delay? Is that part of it?
To use an example, it would be a situation, for example, where a customer is not able to take in the amount of cars that have come to that facility and they're dwelling in CN's yard. And so the customer has not been able to unload the cars quickly enough and thus has incurred a demurrage invoice on those cars that are dwelling in CN's yard. And in that circumstances, we believe it's appropriate for the customer to pay the demurrage invoice.
Even if their failure to take them in wasn't their fault?
These are very factual circumstances that are particular to every individual case that depend upon the circumstances. But in our view, by the time we get to the point where we've filed a complaint against the customer and we haven't been able to resolve it informally through our many detailed dispute resolution process discussions. At that stage, we believe it's appropriate for the customer to pay the invoice.
Kathy, with all respect, I really feel like we're going around in circles. Can we just get to this question of whether, what I'm trying to get at here, it seems should be obvious, is whether there's some strict liability, if there's simply a difference in time, or if there has to be some showing of fault or cause that the customer did in order to be liable. Suppose nobody's at fault. Is the customer still liable?
CN works with our customers in individual situations.
You know what, I can't get an answer. I'll just move on to Pam.
Okay.
Pam, do you have a view as to whether there's any requirement that the customer be the cause of the delay before they're liable for demurrage?
So first, I'm going to start by saying I am not a lawyer, but I'm going to answer this based
Well,
on our processes.
Pam, let me say this. It is a question that has legal aspects to it, although I don't think it's entirely legal, so if you're not comfortable, I don't want to put you on the spot of answering the question, so.
I think
Okay.
you're asking it from a legal perspective, and so I'm not sure I'm going to fulfill it correctly.
That's fine. I don't want to, it's not fair to get you involved in a legal discussion unless you feel comfortable wanting to answer it.
I don't feel comfortable
Okay,
answering that.
and I'm not gonna, do you want to, Patrick says your lawyer's with you, but whoever that is, want to respond? Or?
We don't think it's an appropriate question in this proceeding, Member Oberman, and
because?
Well, because you're asking us in a vacuum to make a legal opinion without context, without a case, without preparation, and completely without notice.
Well, I guess it's fair to say I didn't send out a written notice of the questions that I was going to ask, but it seems to me the concept of cause and fault is replete throughout the case law in this area, which I've studied and many others have studied. So I'm not asking about a specific case. I'm just asking you generally whether your view is that demurrage is a strict liability situation or there has to be some component of causation or fault.
If you give us an opportunity, we'll respond.
All right, I'd appreciate that. I'd like to be edified, but your view, I'm certainly not the last word or even the first word on it. Jill, you want to take a crack at this question?
I will. So in direct response, it's not a strict liability standard in the law or in practice. I do think that the law requires, or the case law and decisions by the STB have required that railroads consider situations where they're at fault. And so I think that, programs, when we pursue the inquiries that we do before we remit a bill, we think that we're consistent with the law. We go beyond that too. I mean, we have language in our tariff talking about force majeure. So when something's beyond the control of a shipper, we do have language excusing that. I think.
So you're saying if nobody's at fault by an act of nature, there's no demurrage liability?
There's an opportunity for a shipper to say, I should not be on the hook for demurrage. The shipper is able to come in and say, there's a force majeure event at my plant or on the railroad or something like that, and so they have that opportunity. In reality, we're already dealing with those on the front end. I mean, we know when we're in a flooding situation, things like that. So we do account for that before things go out the door as best we can. And so, like I said, I think we're appropriately focused on assessing when there's railroad fault in our practices.
Let me ask all three if you have a view as to whether the railroad should have an obligation of some kind of due diligence to investigate the actual cause of the delay or what appears to be a demurrage situation before you send the bill, and if so, how much due diligence, if you can describe it. Because the reason I asked the question is that I thought I've heard, and maybe I've misheard, not from the three of you, that that some demurrage bills just get turned out by the computer if the time clock over here and the time clock over there show an excess of time, the computer spits out a demurrage bill. And then the customer has to go to great lengths to figure out why that happened and unprove it. So I'm not suggesting that is what your railroads do. What I'm really wanting to know is what you think railroads should do before a demurrage bill is sent out along these lines, sort of investigating, pre-billing investigation.
So I think even before you get to a legal standard, our people, I mean, they do think about commercial reasonableness when they approach things. And so part of the process that we've pursued is because we think that that's commercially reasonable, and I think that also dovetails with what the STB may consider as reasonableness. So I think that, you know, does someone need to do exactly what we do? Possibly not. I think it depends on elements of their rules, elements of their own data collection, what kind of network they have. But for us, in terms of our customer expectations, and in terms of what we think is valuable to our customers and reasonable for them to require us, that has informed our practices, which is frankly a significant amount of review before it goes out the door.
Thank you. Pam, do you have a view on that?
Yeah, similarly, and per testimony, my team actually pre-builds all of our local trains for the operating team. And then we audit those trains in terms of what was actually moved, in terms of spotting requests or pulls for the customer. On top of that, customers have visibility within our CP station to see credits that are applied against every single car, and to see the status of the car at any given time, and to log an issue with us. So there's a lot of pre-work that is done before an invoice even goes out. So short answer is we do a lot of pre-work before an invoice goes out.
My question is, should that be a requirement as an industry practice?
I think that will totally depend on each railroad's technology and what information they provide to the customer up front. I can't answer on behalf of the other roads. I can just tell you what we do. And
Well, I'm really asking in terms of what would be a reasonable practice for the board to consider imposing before a demurrage bill goes out. Some degree, you know, just to extrapolate, and I'm not suggesting this should be the standard at all, but we all know before you file a lawsuit, you have to satisfy Federal Rule 11 and so forth, have a good faith and basis for making your claim. I'm not suggesting a standard that's strict, but I am asking whether there should be somewhere along that spectrum as a requirement before you can ultimately send a demurrage bill out if you haven't worked it out. Do you have a view on whether that should be imposed? I understand.
again, I would say that CP in practice looks at a lot of those invoices. We audit, we build the trains. We also have visibility within our systems, and it would be fully dependent on the technology of each of the roads around visibility to the pipelines and what's occurring as to how in depth you would go into that, would be my perspective.
Kathy?
So very similar to CP, we actually have a number of checks and balances before a bill is issued or an invoice is issued. We have, for every single switch or service failure, we have somebody that looks at the impacts and makes a determination of whether it is related to a customer caused issue or a CN or railway caused issue.
Do you think that kind of approach or something like that should be a required standard for the industry?
I can't answer whether it should be required. I can tell you that it's provided a level of transparency for customers that's been appreciated. It has reduced the overall level of, I think, angst by customers. They have a deeper picture into how we operate and what our expectations are for them. So I think that policy has helped us.
Well, and I have to say, you know, I'm not asking these questions in a vacuum. We sat here for 2 days and heard customers complain time and again that they got a bill and they would have to drop everything they were doing and put in a huge number of person hours and expense. And as Ann pointed out, one hired a forensic accountant to figure out if the bill was correct. And the impression we've gotten, and I don't think this applies to your three railroads, but I'm sort of searching for whether there's a solution to the dilemma of a railroad just shooting a bill out and putting the entire burden on the customer to figure it out and disprove it. you're all saying you don't do that, and I think that's good. But we're trying to figure out if there's some way to level this off in the industry. Whoop. I don't know what happened there. I talked too long.
It's an emergency alert.
Patrick, did you?
Yes, a couple smaller things.
Are you done, Kathy?
Okay, so one of the things that was mentioned in the last panel was the idea of like a date and time stamp. Can you give a reaction to that? If you all heard the testimony?
Yeah, I heard it, and as I was listening to it, I was thinking through my review of the Demurrage tools,
Yeah.
and I believe that's actually available in our Demurrage tool, where when you go, if you're a customer or a receiver, so it's not just a freight paying customer, so this is available to anyone who participates in a route movement. You go in and you see all of your shipments, and to the extent they have been actually placed, ordered in, etc., all of those timestamps appear in the tool, and then you have the opportunity to, through a drop menu, talk about, put in comments,
I'm listening.
flag
Cool.
it, that sort of thing.
Yeah.
Is that like the hook?
No. Do you want it to be? Oh, is everyone shelter in place? Okay, let's shelter in place. Are we sheltering in place right now?
There are windows in here, so we probably want to move to the interior hallway.
Okay.
Good news, we just got our second wind. Yes, pun intended.
Yeah. I have a couple. You go. You go.
Pam, one of the witnesses yesterday told us that CP has a fee of $110 for the privilege of your sending them a refund. Is that right?
I wasn't aware that that was, directed at us. Maybe I missed
I
that.
thought it was. I may have, that's what my notes say. You don't think you have such a charge?
Not that I'm aware of.
Okay.
I'd be happy if you gave me the customer's name to follow up with them.
You know what, it's in the transcript, and I may have gotten the wrong railroad. I wrote down CP, but
I didn't
just
hear
like
it.
the railroads and the customers, I'm not perfect.
If it was, happy to follow up with the customer on that.
Yeah, no, they said it was, whoever they were talking about said it was a regular charge, because I asked the question of somebody, but, okay. Anyway, I wanted to clear that up, thank you.
Can I just kind of give, and I know that I've asked a number of questions about it, and you all have been helpful for kind of letting me know your perspective and helping me understand your perspective, but I wouldn't want to leave the hearing and talking to railroads without really understanding what you all view as reasonable. And we've got 40, 50 submissions, and almost every one of them says, this is unreasonable, this is unreasonable, it's unreasonable, and there are different shippers and receivers have put forward different reasons for it. And I understand that it's going to be a fact-specific case, and I think that's fair, right? And so we have to be careful about blanket statements, but I think you can have fact-specific cases with criteria that are generally used, right? I mean, we have criteria that are used for reasonable rates, for example, that then are fact-specific. And so, I don't know if it's giving me a set of facts that can help demonstrate a point, or giving me criteria, but can somebody just please help me understand? People are saying that you all are unreasonable, and obviously you all have made a determination that some of these practices are unreasonable. You all have made a determination these practices are reasonable. I just need to understand from you all. Can maybe a fact pattern of something that is unreasonable would help me understand what is reasonable.
So, I'll wait in. I'm going to disappoint you because I'm not going to go from the fact pattern perspective, because I think sometimes that reasonableness gets lost in that because you're focused on an individual situation with an individual shipper making choices, with a railroad making choices in a specific circumstance. So that's not to mean that that's not relevant and ultimately what you're looking at in an adjudication. But in terms of the sort of I absolutely get wanting to be able to say these are sort of the tenets of reasonableness. I think that
there's room to do that. I think the board has done that in some of their decisions about demurrage and given some of those perspectives. I think that one thing that I would ask is that if you're doing that type of a tenant, and I'll get to some, I'm not sidestepping it, I'll get to some tenants, but if you're doing that, I think one of the dangers is plucking individual aspects of a program and saying, this passes, this fails, this is 24 hours, why isn't it 48 hours? I think one of the things that you have to really think about is how does the entire program look and feel? And so I think I think the board's already kind of going there in terms of the questions that you're asking. You're asking things about are the rules clear and concise? Can someone look at them and say, okay, I know when I'm at risk of demurrage, and I also feel like I'm being given access to information that allows me to adjust in response to it. I think a lot of our shippers, it would resonate with them in terms of having the rules be clear and be rules of general applicability. I think it matters to us in terms of administrating rules, that rules are generally applicable, but I think also it gives customers a sense of reasonableness as well when everyone's being treated the same. And some people may not be completely equally impacted, and maybe that's because of the level of service that we give. And so we make adjustments to free time because of how we serve a facility. But I think some of our shippers would be nervous that there's going to be exceptions that swallow the rule when, especially for a railroad that's had charges in place for so long that have been consistent, they have made a lot of good decisions about how to manage their pipeline, how to make sure that they're scaling the business to the resources, and when they're not, thinking about how they deal with excess production, capacity, et cetera. And so I think that sort of general applicability is a standard that I think should be considered for reasonableness. I know you all are thinking about timeliness to adjust. I do think that's important. I mean, I think there's a statutory minimum. Right. But I also think from a commercially reasonable perspective, we always think about, I mean, there's some situations where we can't wait because there's some imperative and we need to move. But I do think that when we establish notice, we really think about why are we implementing this charge? And if it's a turn on a dime and really leaves people unable to respond, I think you can, that would set up some red flags, but I think also if a carrier is saying, I'm going to tell you what the rule is, but then we're going to phase in and deal with people who can't get there quick enough. And so I think that doesn't, I haven't laid out a formula, and I know that may be
I'm
a little
asking,
frustrating, but I
here's,
think those are elements that matter.
and you don't necessarily have to lay out a formula today. You know, you can also, follow up, we get further conversation, but you all have also done an analysis of what is reasonable before it goes out there. You know what I mean? So it's kind of a,
I think that's part of why we're comfortable with some of our rules being a little bit tighter.
Yeah.
So like on the zero time, because we have other aspects of our program that inform the reasonableness of that.
and including so if you have something on the credit side or when you stop and start the clock or what have you.
If you've got something sitting in our yard and you put your hand up, you're not going to be on the clock if we miss a switch. If you miss a switch, if you give it too late, if it's a Saturday, you're off. And so we think that mitigates that, and that's important.
And so what I'm hearing from you is for tenants, it needs to be clear and concise. The customer needs to have the information necessary to adjust.
Yeah.
The treatment has to be the same, or there has to be something of general applicability for people of class, however defined.
Yeah.
And there has to be sufficient advance notice.
Yeah.
Okay.
And I think also the STB has also spoken about take into consideration railroad fault.
And then there's fault.
Yeah.
Okay. And now, is there any component of this tenant, and other jump in, we can go, is there any component of these tenants that involve an adjustment that is too large to make?
I'm not sure I follow.
The example that we've, kind of used a bunch of times, but the person who's geographically constrained and basically he has no extra,
Yeah.
let's say the person's operating 7 days a week. I hate to go down, but operating 7 days a week, can't expand track, is really buy real estate and build a new facility or pay the demurrage.
Yeah.
Okay, is there something we should be thinking of? And I don't mean to be repetitive,
No.
but it feels like something's missing if we don't talk about the magnitude of the adjustment.
And I think that magnitude of the adjustment is also informed by other things than just the sort of binary situation that you set out.
Yeah.
Because I think one of the things that we've had a lot of success with our shippers in is working with them to be able to use the tools that we have out there to look at, going to your 555 situation.
Yeah.
555, 3 different originations. Those go into the system. There are times when a customer, even before it, and it's not the majority, most of our shippers engage and manage this, but there are times where even before it hits our network, you've put 15 into the system, and based on average release times at the destination, average transit times, you've signed up for a demurrage bill because you're putting too much in. And so I think there's some opportunity to mitigate that
So in
without
my
having to go
example-
straight to.
In my example, the 555, what you're saying is, hey, that customer, the Tuesday, Wednesday, Thursday, maybe ship out on Friday, and you'll only get 10 back.
Yes, and I think it's, in that situation, I do think it's reasonable for the customer to say, okay, well, if you've had a huge spike in your
And that's
well,
it's
and
they
that
have to
sort of
make the
thing, then you
trade-off,
account
right?
for it, yeah.
And they have to. So it's enormously complex, but it's like, okay, well, if they have to delay till Friday, right? There's going to be a productivity loss at that particular plant, right? And at the same time, if they don't delay till Friday, there's going to be a productivity loss at your yard. And and you all have the power to avoid that productivity loss at your yard by charging them, by incenting them to basically change their calculus to move them to the plant. But they're gonna lose, they're gonna have a productivity loss, right? And so they're gonna do that up until the point where whatever the demurrage bill is going to be, it's going to be relative to the productivity loss, I would think, right? And there's two things that it makes me think. Like, one is, sometimes you might not be able to shift in that particular way. I mean, my 555, you might be able to. And the second thing is then it becomes a relative game between the level of demurrage and the productivity loss of the plant. And that's the calculus they're making, and the calculus maybe the board ought to be making. I'm not saying this is, the calculus the board, trying to think about the national interest, is the calculus between your productivity loss and their productivity loss, not the calculus between a demurrage charge and their productivity loss. And I guess, are we fulfilling the national interest if we're not thinking about those two things?
I think I would say our productivity loss is not just our productivity loss. It's, this goes back to my
when I say your productivity loss, I mean, being a network industry, your productivity loss affects other customers. And so I have to try to stipulate it each time, and I'll stipulate it again.
I mean, I think that this is probably not going to be a popular answer, but I think that there's also elements of the service that we are providing.
Yeah.
So, there is the ability for customers to come and negotiate for something that looks more like scheduled service. And we have, not a lot, but that does happen. When we're not in that kind of an environment, then we are ultimately a common carrier. And I think there is an element of, not that we get to do whatever we want as a common carrier, but the responsibilities that we have are not just to the individual shipper, it's to manage the network, like I said, not just for us, but because we have other people who are relying on it.
Mm-hmm.
And so there is this element of, okay, there's a cost to a shipper, to a receiver,
Right.
for that piece of equipment sitting either in their yard or our yard. From our perspective, we also think a whole lot about the fact that that's sitting in a yard and that's productive capacity that we can't use. And the longer it sits there, the more that impacts the 7 other facilities in the area. And so the incentives are important, not just because there's costs being exchanged back and forth, but because there's really, I think it goes to your question about the.
There's going to be a cost to somebody, right? It's good. You're going to have a cost to the shipper receiver. It's going to be a cost well, I say to you all, but and potentially other customers to the extent that the effects on you then affect other customers. There's going to be a cost to somebody, right? I mean, that's the way it's going to be.
I mean, you can talk about it in terms of cost. That's fair. I think that what would be like I don't have a sort of.
Yeah.
I'm never going to have a math equation because
no,
there's a reason why I'm a lawyer instead of an economist. But but I do think that if you're losing sight of the cost to the network, which is not, there's a bottom line cost to this for sure, but there's the cost to the loss of the productive value.
I totally understand.
It's been very important in historic cases.
I totally understand.
And I think it's still pretty important.
And sorry to go around, and we want to ask if anyone else has anything to add to those tenants. But you know what I'm getting at, which is like, should we be balancing the cost to the network versus the cost to the shipper receiver in terms of reasonableness? Because the shipper receiver is only going to be balancing the cost to them versus the cost of demurrage. And so therefore, you know what I mean? I'm trying to, is it the board's role, as a government agency to take that broader perspective? And is that the appropriate lens we should be looking at the reasonableness? And that's what a lot of my questions are kind of getting around, and that's all I'm thinking about.
Yeah.
And I'm just trying to think about it.
Yeah, no, and I appreciate you sharing those thoughts.
All right. Anyone else on the tenants, anyone want to add anything?
No, I think your tenants, in fact, are well-grounded, and I think we have...
They're Jill's tenant.
tenants.
Oh, no.
Yeah.
The one thing I would add...
Yeah.
The one thing I would
No,
add...
I didn't, I assure you. Those are our tenants.
Yeah.
Those are BNSF tenants, I'll say.
The one thing I would add, I know we focused a lot on the case where a customer feels they have no options and their only option is a massive investment to compensate for, a railroad's demurrage charges. I would honestly say that in many cases that, just by sheer number, right? We've heard from a lot of customers, but we have thousands of customers who are not identifying this particular problem. And the reason they're not is because railroads constructively, and I can speak from CN's perspective, we work constructively with customers to make sure, we've done things in the past, as an example, where we've subsidized the purchase of trackmobiles. We've set them in contact with third-party services to help offset some of those, the services they'd like to consume, but they don't want to make the investment, essentially. And so I guess where I'm going with this is there are a number of options. And I think we've heard from a particular viewpoint, which is very extreme, but does not represent a lot of the cases that we encounter on a day-to-day basis.
Kathy, do you have anything to go and add to the tenants or anything?
I think the thing I would say is that the broader interests of the network are very important to be considered. And because it is a network industry, what happens in one particular yard impacts not just those customers that are served locally directly from that yard, but it also impacts the interchange traffic that's going through that yard and interline service. It impacts other trains that are just going straight by the yard. And so the ripple effects when one customer has chosen, either because it's ordered too many cars and they're coming into their facility or for whatever reason, and they aren't able to get those cars loaded or unloaded, and then they're dwelling in the yard and consuming that capacity, it really has a detrimental impact on the network as a whole. And so that's the thing that we're really trying to work very hard with our customers and to encourage them to release and to load and unload cars and release them as quickly as possible.
Good news, you're excused. Thank you very much. We greatly appreciate it, and thank you for sitting through the tornado break. And our last but not least panel, Panel 12, Western Coal Traffic League, PBF Energy, and the Freight Rail Customer Alliance. Betty, can we start with you?
Good afternoon, Chair Begeman, Vice Chair Fuchs, and Board Member Overman. My name is Betty Whalen, and I'm the Fuel Specialist Principal for the Lower Colorado River Authority and currently serve as President of the Western Coal Traffic League, or WCTL. I am also a member of the Board's Rail Energy Transportation Advisory Committee. On behalf of WCTL, thank you for allowing myself and other freight rail stakeholders the opportunity to share our concerns regarding demurrage and accessorial charges. Although I am testifying today on behalf of WCTL, I also wish to express my strong support for the statement submitted by two of my fellow panel members, the National Coal Transportation Association and the Freight Rail Customer Alliance. WCTL is a national voluntary trade association made up of consumers of coal mined west of the Mississippi River and transported by rail. Our membership includes publicly traded companies, local governments, cooperatives, and utilities, all of which depend on the Union Pacific Railroad and the BNSF Railway Company to ship and receive hundreds of millions of tons of coal to and from their facilities each year. As a result, we are, unfortunately, very familiar with the disparity between what is expected from rail shippers versus what is expected from rail carriers. Demurrage and accessorial charges are just another example of this striking imbalance, where shippers are required to meet certain performance standards set by the railroads or be held financially responsible, while railroads have no reciprocal requirements or accountability to shippers. As our written statement details, our members' frustration with demurrage and accessorial fees stem primarily from 4 issues. 1, implementation of precision scheduled railroading. 2, the railroad's failure to recognize and account for differences among commodities. 3, the railroad's inconsistent and often incorrect assessment and enforcement of fees, and the significant administrative burden this places on shippers. And 4, the lack of reciprocity in accountability. Most of the issues with accessorial and demurrage charges that were reported to us came from WCTL members shipping on UP. These members reported that UP's implementation of PSR has driven and exacerbated demurrage and accessorial fees. Members shipping on BNSF, such as LCRA, have reported fewer issues as BNSF has not yet made any material changes to its tariffs over the last few years and is the only Class 1 railroad that has not yet adopted PSR. The disruption and unpredictability in service that has accompanied UP's adoption of PSR has made it difficult for shippers to anticipate train arrival and pickup times. This in turn has made it difficult for shippers to manage their operations. For example, under UP's tariffs, shippers are penalized financially if they are unable to receive a train at the scheduled time, or if they fail to unload a rail car within the allotted 24-hour free time. UP, however, is not subject to any similar constraints or consequences. Several of our members report that UP failed to pick up its train sets at the scheduled times over the last few months, with one member reporting UP left a train set at its facility for 9 days. UP recognizes in its written testimony that, quote, all customers benefit with improved service reliability and reduced cycle times when all assets are utilized to their fullest, end quote. However, it appears UP takes advantage of some customers, like coal shippers, whose facilities are able to store rail cars, and as a result, service for these shippers suffer. The demurrage and accessorial fees are significant. In fact, from January 15th to April 25th, 2019, a period of just 100 days, UP invoiced one WCTL member for $183,000 in new demurrage fees. Another member reported UP has charged it $124,500 in new fees so far in 2019, of which only $9,000 was successfully contested. Like its decision to adopt PSR, UP claims it's decided to standardize and consolidate unit train service terms across all bulk commodities, quote, to drive reliability and efficiency for both UP and unit train customers, end quote. However, just like PSR, UP's standardization of unit train service terms create inefficiencies for our members and higher costs for our customers. As the board has heard, shippers of different commodities have different needs, and a one-size-fits-all approach is not the solution. WCTL members have expended significant resources to adhere to the railroad's requirements when constructing our facilities to handle unit train service. Our members did so based on a good faith understanding of how the railroads would handle unit trains and how they would assess and enforce fees. By streamlining unit train service terms, UP has removed the foundation our members have relied on for years and further eroded our already limited protections. For example, UP's previous tariff 6603C outlined events that would extend a shipper's unloading free time without penalty. UP's new streamlined tariff 6004C simply states charges, quote, will not accrue during circumstances beyond the customer's reasonable control as determined by UP, end quote. The tariff eliminates all specificity and affords UP significant discretion to assess and enforce charges. Like it has with PSR, UP is using its tariffs to lower its own operating costs and generate additional revenue at the expense of shippers. To our detriment, the railroads exercise their discretion to assess fees inconsistently, unpredictably, and oftentimes incorrectly. For example, last month, BNSF incorrectly charged a WCTL member $75,000 in demurrage fees for the entire time a train traveled from Colorado to the member's facility and back, approximately 300 hours. BNSF canceled the charge, but only after the member spent time processing and disputing the invoice. Another member stated that just about any train that shows detention has to be disputed, because BNSF's arrival time at the facility does not reflect the time BNSF actually delivers the train for unloading. WCTL members have also reported having limited success recovering incorrect fees, with one member reporting only a 10 to 12% success rate. This member explained that although the plane keeps records of when a train leaves the facility, BNSF relies solely on its crew's records and never meaningfully considers the shipper's records. It is similarly difficult for WCTL members to process UP invoices. One member reported it has been charged $124,500 in demurrage fees so far in 2019, but did successfully contest one $9,000 charge. The member successfully disputed that charge after it found UP had incorrectly penalized it for a train that was only delayed because UP's own rail crews arrived 12 hours late. UP charged the member $3,000 per engine for failing to timely unload the train. Although UP's invoicing has improved somewhat, one WCTL member reports more than 75% of UP's invoices still have to be disputed. The most significant problem our members and other freight rail shippers face with regard to demurrage and accessorial fees is the complete lack of reciprocity and the inherent unfairness of the charges. These fees and the railroad's assessment and enforcement have added to the imbalance between freight rail shippers and railroads. The imbalance is clear in Kenny Rocker's written testimony for UP, which states, in the third quarter of 2018, only 55% of UP's bulk train customers loaded or unloaded their rail cars within 24 hours. I am pleased to report that statistic is now at 62% for the first quarter of 2019, although yesterday in his testimony he said it was 65%. But as Mr. Rocker points out, despite the threat of significant charges, over a third of UP shippers still remain unable to meet the 24-hour deadline. It is clear that UP's deadline is unreasonable. These charges are purely punitive and are being enforced as an added source of revenue. It is hard to celebrate 7% more shippers loading and unloading their trains within 24 hours, and during this time, shippers were subjected to more than 50% increase in demurrage fees. UP's willingness to provide a shipper with credits to offset demurrage fees does not go far enough, as it is the shipper who is ultimately held responsible for any imbalance. Although our members do not pay demurrage fees on a sitting train, requiring them to abide by the 24-hour unloading deadline when UP is not going to pick up the train the following day unnecessarily wastes shippers' resources. A more balanced solution would be to calculate how often the railroad is late picking up a train over a 12-month period and give the shipper credits or reimbursement based on that amount as a percentage, so the shipper can be compensated for its actual increased costs, not just given credits to offset future demurrage fees over a 1-month period. This would incentivize railroads to evaluate the 24-hour unloading deadline in light of its actual capabilities and avoid unnecessarily driving up shipper costs or creating inefficiencies. In summary, we request the railroads work with shippers to ensure that the accessorial and demurrage charges do not impose unnecessary penalties and burdens, especially when many of these charges are a direct result of PSR or railroad error. More importantly, any next step should focus on increasing reciprocity and rewarding shippers for meeting the railroad's requirements for their tariffs, rather than just penalizing shippers when they fail to do so. WCTL also urges the board to consider any other actions it believes will aid those negatively impacted by the demurrage and accessorial charges implemented by the Class I railroads. On behalf of WCTL, thank you again for allowing me to testify today, and I'm happy to answer your questions.
Thank you. John?
Thank you. Chairman Begeman, members of the board, my name is John Ward, and I serve as the Executive Director of the National Coal Transportation Association. Thank you for your commitment to address this issue and for your stamina in seeking to understand what's going on the rail markets today. Our organization consists of electric utilities, coal producers, and entities that produce, repair, and manage all facets of rail car component parts and systems. Our members have invested heavily in the ownership, leasing, and control of fleets of rail cars, which they provide to the railroads in unit trains of up to 150 cars. These fleets represent about 45% of coal cars in service in the eastern U.S. and about 90% of the coal cars in service in the western U.S. Today, coal represents as a commodity about 36% of carloads originated by Class 1 carriers. At the risk of sounding like a history professor, I'd like to provide a little context concerning our members' relationship with the railroads. Railcar technology and design evolved rapidly during the early implementation of the Staggers Act. At that time, the rail carriers asked coal shippers to provide capital to purchase unit trains of rail cars to serve them, as the carriers did not have satisfactory access to credit. Coal shippers and receivers responded with many billions, with a B, billions of dollars of capital to maintain rail as a viable option for coal shipments. Coal shippers and these investments extended far beyond the purchase of modern train sets to include fast loading and unloading systems, multiple loop tracks, and batch weigh loadout systems. Furthermore, mines and utilities organized to meet railroad schedules on a 24/7 basis and to maintain large and expensive stockpiles of product at both origin and destination. This stockpile factor allows railroads to miss delivery schedules by days and sometimes even weeks, and represents the largest surge or smoothing capacity in the rail system between origin and destination. This stockpiling of product exists at no cost to the rail carriers. That's the history of Staggers implementation. Today, the table has turned. It is the railroads who are experiencing record profitability in the coal industry that is suffering from withering competition from other energy sources and adversarial public policy. Despite this change in circumstances, I'm here to testify that our members are experiencing the same demurrage and accessorial fees issues related to precision scheduled railroading that you have heard recounted over and over again these past 2 days. Our written testimony contains specific examples. I will summarize by stating that coal transportation market is suffering from substantial increases in fees, unilateral changes to railroad policies, and systems that put the substantial burden of disproving erroneous fees solely on the backs of the shippers. Our members still desire to have financially healthy rail carriers that can provide reasonable service at reasonable rates. We fully support the goals of improving efficiency and reducing network congestion. We continue to have productive relationships with railroads on an operational level. Our members' commitment to maintenance, operations, and repair of the tens of thousands of coal cars in their fleets is so significant that we hold an annual conference on best practices for fleet management, which the rail carriers helpfully participate in. But as you've heard during 2 long days of hearings in a very large room, a room where the initial shortage and now oversupply of chairs probably provides some analogy for the concept of demurrage, there is a need for the surface
People waiting outside to get
yeah, another tornado is happening as we speak. There is a need for the Surface Transportation Board to take actions to ensure that implementation of precision scheduled railroading under any name is carried out fairly and equitably. Taking my history professor hat off and becoming an English major for just a moment, I noticed that Member Oberman's interest in definitions. Reciprocity is defined as a mutual exchange of privileges, specifically a recognition by one of 2 institutions of the validity of licenses or privileges granted by the other. The coal industry was there for the railroads when they needed capital for rail cars, infrastructure, and business models that offer schedule flexibility. Fair treatment during PSR implementation is not too much to ask for in return. Thank you.
Thank you. Kent?
Thank you. And good afternoon, Chairman Begeman, Vice Chairman Fuchs, and Member Oberman, as well as the Surface Transportation Board staff, and thanks for providing PBF this opportunity to testify before you today on demurrage and accessorial charges related to rail shipments. My name's Ken Avery, and I'm the Vice President responsible for managing rail activities for both PBF Energy and our Master Limited Partnership, PBF Logistics. Little background on PBF. PBF's one of the largest independent refiners in North America. We have a fleet of roughly 7,000 rail cars. We haul chemicals such as xylene, tetramer, benzene. We also haul a lot of crude oil, propane, and butane. Of our 7 served operations, 57 rail served operations, 57% of them are captive to one railroad. I want to tell you a little bit about myself. I've been in the rail industry for 30 years. The first 16 of that I worked with the Union Pacific Railroad solely in the operating department. The first 12 years of that 16-year span was working in a terminal and serving a lot of customers like who you've heard from today. The last 4 years of that 16-year span was spent in the dispatch center, where I really learned just how complex the railroad is and how many resources are fighting for track time on the railroad. And we're going to talk a little bit about that when I get further into my testimony. Unlike a lot of the testimony the commissioners have heard, PBF has been successful at resolving a lot of our demurrage invoices, but it takes a tremendous amount of energy, persistence. You have to get nasty. You have to climb up the organizational ladder. It's just a process that's way too burdensome, and frankly, I believe it is a deterrent that they try to wear you out. When we were sheltering in place out here, I had a moment to talk with the BNSF. My perception of their tools and their customer service center couldn't be further from what they mentioned to you today. I feel it's absolutely terrible. The good news is we're going to have, I'm going to follow up with the BNSF representative, and we're going to talk more about it. But I just want to tell you, we have polar opposite views on that. I'm going to be brief. You guys have been champions the last 2 days at listening to everybody, so I'm going to make 2 quick points. First of all, my first point is trip plan compliance or on-time service is the key to lower cars online and therefore lower demurrage and accessorial charges. Unfortunately, this is a metric that is just not talked about on the railroad. The railroads can talk to you about velocity, they can talk to you about OR or dwell in their yard, but what they don't talk about is on-time performance, and the reason why is there's not a good news story. It's typically in the low 70s. That's what it is, and it stays there. Now, it's really the only segment in the transportation industry that doesn't talk about how reliable they are, which I find very telling. You might be asking, why is it that they can't get trains over the road? Well, train trip plan compliance is really due to 3 primary factors in my experience. The first is episodic events. When you're in the dispatch center, the one thing you learn is just how many episodic events happen along the railroad on any given day. This can be a crossing accident, it can be a locomotive with a locked up traction motor, it can be any number of locomotive reliability issues where a locomotive breaks down. It can be a derailment, a rock slide, it can be a washout, it can be cattle on the track. But there are a number of episodic events where the railroad just simply stops. The second thing that affects trip plan compliance or on-time performance is planned maintenance. Railroads have done a good job at maintaining their track, but it doesn't come without a cost to the customer. They have tie gangs, steel gangs, what's called a DC car, an EC car, an in-track welder, a track inspector. It goes on and on and on. There are a lot of activities that need to be coordinated on the main track other than just train movement. The third thing that affects on-time performance is crews. And the crews are an issue any day of the week, but they're specifically an issue during the holidays. So we have 12 holidays, but it's not just the holidays that they become an issue. It's Mother's Day, it's Father's Day, it's Easter, it's the Super Bowl, it's the World Series, and it's also hunting season. When I was in the dispatch center, we had a heck of a time keeping crews in certain parts of the country because they wanted to go shoot an elk or a moose or a deer or something. And while that's fine, my train didn't move. And so those are the things that I want to help the STB understand are really the things that are preventing the railroad from getting trains over the road. Now, I know you've heard a lot about first mile, last mile here. I have a little bit different of opinion. I think 50% of the problem is first mile, last mile, but 50% of the problem is just getting the train over the road. The thing is, the customer really doesn't see that very much. So, you know, these are, you know, I would say that the railroads have made some economic decisions with respect to not addressing these three things that, or I should say two of the three things that cause poor on-time performance. As far as episodic events, railroads have done a good job at maintaining their track. Their derailment statistics are going down. But as far as planned maintenance and crews, I think they've done a deplorable job. I think they've just done a horrible job. I think the main track needs more redundancy. I think when they do spend capital, the capital is to bring more carloads on. It's not to get their current carloads more reliable. Capital spend needs to be on reliability before it's on growth. So to summarize point one, railroads have focused heavily on efficiency and done a good job. Again, every one of them can tell you about their OR. The real focus needs to be what every other transportation segment focuses on, and that's how reliable and consistent they are. That's not in their vocabulary. My second point is simply that when it comes contract time, captive shippers virtually have no ability to negotiate on demurrage, accessorials, freight rates, escalations, locomotive fees, etc. Today, my fear is, you know, I should say PBF pays about $500,000 a month between demurrage, locomotive fees, and I've lumped a bunch of stuff in that category, but we pay about $500,000 a month. I'd love to be able to negotiate, but it's hard to negotiate when they are the only player in town. So I have a couple recommendations for the STB. I have some recommendations and some solutions. My first recommendation is please don't talk to the top of the railroads as to what the problem is. If you want to know what the problem is, ask a dispatcher from each one of the railroads to come in here and explain to you why the trains can't get over the road. I think you'll be educated. I would start at the bottom rather than starting at the top. As far as my solutions, I believe demurrage should only be assessed on on-time cars. With this gives the railroad the incentive to improve on-time performance, which if achieved would give customers the confidence to lower their car fleets. We really need a cost-effective way to arbitrate basic fees, and really we need a very fair way to just negotiate contracts for a captive shipper. I think we should consider benchmarking services to develop a railroad customer bill of rights program like the DOT did in 2009 for the airline industry, when the federal government instituted a passenger bill of rights as a direct result of the airline industry's poor, inconsistent, and unreliable service. Lastly, as I hope I've demonstrated in this presentation, we have got to change the discussion from efficiency to performance and consistency. Thank you for the opportunity to testify.
Thank you, Kent. Emily?
Last one. Members of the board, good afternoon. Thank you for holding this hearing and for giving us an opportunity to speak with you. My name is Emily Regas. I'm wearing two hats today. First, I'm here as the Fuels Resource Administrator for Arizona Electric Power Cooperative, or APCO, or Rural Electric Generation and Transmission Cooperative. That's my day job. Second, I'm here as the Vice President of the Freight Rail Customer Alliance, or FRCA, a national association of shippers, and shipper associations. APCO is also a member of the Western Coal Traffic League and the National Coal Transportation Association, where I am the current president. APCO and FRCA join in the league and the NCTA statements as well. APCO and FRCA have several areas of concern and several proposals regarding demurrage and accessorial charges, particularly as they relate to precision scheduled railroading, or PSR. Let me briefly summarize our written statement. First, we are being forced to pay a la carte for services that used to be included in the line haul rate. As a result, we are being forced to pay more to receive the same bundle of services. Second, the higher charges associated with PSR, for example, out west we've seen higher charges with UP, but not with BNSF, at least not yet. Third, it would be one thing if PSR was producing better service for us, but it has been the opposite. UP service has been less predictable and more disrupted. Volumes are not getting moved because of PSR, and the reduction in surge or recovery capacity with PSR means these volumes are unlikely to be made up in the future. Fourth, PSR is causing us to have to pay more but receive less. Fifth, there is an absence of fundamental fairness and basic reciprocity. If we hold on to a train too long, we get hit with demurrage or detention, which we're told is allowed to include a penalty component. However, the railroads do not face any financial consequences if they take too long to move a train or service suffers. Our written statement details a sequence of events with our train set at APCO's power plant, Apache Station, located in southeastern Arizona. Very briefly, we needed a couple of extra hours to unload the train, which we were willing to pay for. We needed to rerun the rail cars through our dumper a second time because we wanted to make sure the cars would be completely empty of coal before we sent the cars to the shop for some scheduled maintenance. But UP insisted on taking the cars while some still held small amounts of coal. This is known as carryback coal, which means additional cost to the shipper. The cars went to the shop, and after they received maintenance, UP was notified that the cars would be ready to return to service on April 26th. We had scheduled the cars for a coal loading at the end of April and obtained a PRB train slot from the UP for that purpose. But UP did not pick up our cars until May 7th, 11 days after they were scheduled to move. 11 days. So our cars sat, we couldn't use them. The shop had to provide space for them, and we had to deal with the mine for the loading delay. But UP did not have to pay a penalty or compensate anyone for the problems it caused, even though UP is quick to impose charges when shippers deviate from their schedules. We offer several proposals. First, carriers should not be allowed to charge a la carte for services that were previously provided as part of the regular line haul service, at least not without showing that the line haul rates have been reduced or service improved. Second, there should be reciprocity. If shippers are at risk for causing delays, then the same rules should apply to carriers. Third, penalty aspect of demurrage and accessorial charges should be limited. Even if a penalty component is allowed or needed, the sky should not be the limit. 25% seems like more than adequate amount. Fourth, the board should consider adopting the approach that FERC uses. At FERC, transmission providers and pipelines are allowed or even required to impose penalties to enforce compliance with reservation rules and the like. But the providers do not retain these proceeds. Instead, the providers are required to distribute the proceeds to those customers that followed the rules. The charges do not function as a profit center, which is the same principle that the board adopted or tried to adopt with the safe harbor for railroad fuel surcharges. Thank you again for holding this hearing and allowing us to appear before you. In addition, we want to thank and commend the board for the release of the report of the Rate Reform Task Force. Reasonable rates, as well as reasonable charges and practices, are all vital to shippers, especially those that lack effective competition. We look forward to learning more about the recommendations and to the opportunity to submit comments on them. We would be pleased to respond to any questions you might have at this time. Thank you.
I just just have a couple. You know, there was a question I meant to ask the other shipper panels earlier today, and I forgot. So I'll ask this panel, and I'll just ask all of you, and then you can respond. Ann had asked yesterday if any of the witnesses had concerns about retaliation if they showed up here today or made complaints. Do any of you have any such perceptions or actual contacts from any of the railroads? Betty?
I would say no, if we have any concerns.
John?
I'm the association guy. The railroads don't talk to me.
Did any of your members have any such perception?
I'm relatively new on the job. I've not had any members report to me any kind of retaliation. I have had some members indicate that it's a fear that they might have.
I can answer for Kent. He's not afraid.
I didn't think you would be, but I'll let him answer.
I know,
I'm not
Kent from-
afraid, but I do believe there will be comments, retaliation. This is something that will be discussed for a long time. Just coming before the board and saying these things.
Discussed between you and the railroads?
Yeah, I think so.
Will you let us know if that happens?
I absolutely will. I can tell you this, is I was contacted by 4 of the railroads before I ever came here.
Today, in connection with this hearing?
Yeah.
To suggest you're not
Just
coming?
ask me what I was going to say and you know, what my issues are.
And have they solved your problems as a result of that?
No. No.
Emily?
Well, I would just say this, for days now, I've been joking that I'm the sacrificial lamb, that I've come here to represent my company and FRCA, a group of shippers that many of which did not want their names mentioned in their statements, and that as well as NCTA members, of which I'm president of, those members also were happy to hear that we were going to come here and talk to you, but they were afraid of the peril that might come their way if railroads found out that they were complaining about these things.
Were any of these people ones who would have said, but for that, they would have come themselves to testify?
I can't say for sure. It's just a general fear of retaliation, though.
Kent, 2 quick questions for you. You mentioned cruise, holiday problems, and so forth. Do you have any understanding or even perception that PSR itself has resulted in a reduction of the workforce or crews, exacerbating what apparently is the usual problem?
I really can't. I really can't say for or against PSR. I can tell you crews have been an issue since Moby Dick was a minnow. So they continue to be an issue.
All right, and the other question, when you said the main track needs more redundancy, what were you talking about?
Well, if there was more redundancy, if there was more double track, more sidings, you know, 2 things could happen. First of all, if there's an episodic event, it's possible you can get around it. Second of all, when they need to maintain the track, they can maintain one and run on the other. That's what I mean by it. You know, my personal opinion is every one of these railroads comes into our office once a year and you know, puffs their chest out and says, look how much money I'm spending on capital. And then when you break it down, it's a lot on maintenance, and they've done a good job at reducing derailments by maintaining their track. But I don't see a lot of capital projects to improve on-time performance. I see a lot of capital projects to bring more carloads on the railroad.
So what's the difference? What's a capital project that brings more cars on?
An intermodal terminal. It could be a project that they're going to do to bring a new customer on. But, you know, I would say track expansion is what really needs to be done, so you have some redundancy to get to an on-time network. I mean, I would hope that the railroad would be able to operate at 85-90% on time at some point in time, but it's pretty much a flat line. And it always has been, right at 70. It might be, somebody might be mid-70s, but that's where they mostly hang out, is in the 70s, low 70s.
Okay, thank you.
Kent, you mentioned that your company pays about $500,000 a month in demurrage and accessorial. Is that what you said?
Close. Yeah.
And is it that you are choosing to pay rather than to, I guess, invest in infrastructure to avoid storage, or is it that you're at fault? Or could you just kind of give us some perspective as to what those charges are for?
Sure, I'd say.
And are they legitimate?
Yeah, I mean, roughly 20% of it is on locomotive fees, and these locomotive fees are for unit trains that come into one of our terminals. We offload them, and if the locomotive sits for a specific amount of time, you pay a locomotive fee. It's kind of like demurrage. It basically is demurrage, but for a locomotive.
But that's different than the UP $3,200 coming and go. I mean, deadhead.
No,
I guess,
I think the $3,200 is if you release the locomotive back to it.
Mm-hmm. So you're
Okay.
holding on to.
We're holding on.
Is it more than $3,200? Well, I don't.
It's probably right around $3,200 that we pay. I would say there's really no difference whether we would release it or not. One of our bigger costs is out in California. I would say that represents half of the money that I talked about, and it's on the BNSF. Look, we have a refinery down in St. Torrance, which is in LA, and there's just no place to build track in the middle of LA. My concern is that the BN continues to either eliminate a demurrage agreement or reduce the amount of cars that we can have. We have worked tirelessly with the BNSF to try to identify a place where we could build track that they would serve. We've looked at a half a dozen spots. Problem is, they don't want to serve any of the spots. So they give me no opportunity to actually build track. So what do? I store the cars in Arizona on a short line. So I move these cars. I pay a lot in demurrage because my only alternative is to pay freight out to Arizona to come back to LA when I need them. So demurrage is going to be cheaper than paying that freight.
Even though the freight is empty?
Yeah. And well, we move loads out there too.
Okay.
We move loads out there as well. Okay. Yeah.
But not just, I meant just, it wasn't just that was where your storage was going to be.
That is where our storage is. I'm not sure if I'm following your question.
I guess maybe you're saying you're actually paying the fees because of the Arizona location. That's where your car's at?
Yes.
Yes, okay.
Yes, yeah.
Well, now you confused me. I thought you said it was cheaper to pay the demurrage than to move the cars to Arizona.
It is, but there are points in time where we have to move the cars out.
Because
the railroad says we need to.
Well, I'm trying to, just on this point, if you don't mind, just to figure out the incentive part of the demurrage fee. Everything we hear is it's to get the system moving.
Mm-hmm.
But it sounds like there's almost nothing you'd have to raise the demurrage fee a lot higher before it became cheaper for you to just send everything to Arizona without being forced to.
That's right.
And you're not encouraging that, I'm assuming.
No.
It gets to the whole idea that, Ken, the trade-off you're making is between paying the demurrage fee and the lowest possible cost alternative to avoiding the demurrage fee. That's the trade-off you're making.
That's the trade-off we're making. That's exactly right.
Okay. Can I get into car trip plan compliance? Because it actually was, I was trying to get it with actually my very first question of the hearing about 19 hours ago. You know, the whole idea of, you hear now with the transition to PSR that car trip plan compliance is a measure that's being pushed out more by some of the railroads. And, just to make sure that I'm understanding what you're talking about, Ken, is there's kind of two initial things I'm thinking about. One is from the time of release to the time of placement, and that could be constructive placement. And then if it's in constructive placement, then it's first mile, last mile. And so are you saying that on that initial segment, which I understand is how they measure car trip plan compliance, various ways, from release to constructive placement, if there's any, for each delay you have there, you should get some sort of credit? Is that basically what you're saying? Like when you say that cars...
I'm saying if a car has a 10-day trip time and
Yeah.
makes a 10-day trip time, then fine, demurrage is fair.
From release to constructive placement?
Yeah.
Okay.
Yeah, but if...
What if it's an 11-day trip time?
I don't think I should have to pay demurrage. And
Ever?
if it's and if it's a 9-day trip time, I don't think I should have to pay demurrage.
In that scenario, so there's two different ways. One is, what we've been hearing is that railroads give credit. They'll give a credit to, because, there's an inconvenience here. And then the other is, but in your scenario, you're saying never demurrage. That means it could sit in a railroad yard in perpetuity without ever having to pay anything. And is that, does that create an incentive in the other direction, or, a lack of incentive that would be problematic for yard capacity?
I think what I've heard here is we continue to talk about customer behavior. We need to incent railroad behavior. And when you're talking about railroad behavior, the railroad behavior that I think we need to incent is on-time performance. And that's where I get to that point. Okay?
Would a credit be a better way of doing that, where if someone misses their ETA, they give credits such that, the credit's going to wipe away, that's some harm, and it's an incentive for them. And that wipes away a debit, right? And so that's their their incentive is the foregone debit, but you don't run into a situation where the car can just stay in the yard forever. So why would the credit system not be better than the never demurrage if late system? Why?
A credit system could work. I'm not saying it couldn't. I'm just telling you my opinion on this is we need to get away from talking about the customer behavior. I think the customers are behaving exactly how the railroad wants them to behave. I think that the conversation needs to change to railroad behavior.
Mm-hmm.
and what is going to drive more reliability. What is that behavior that's going to drive more reliability on the railroad?
I have another question on that, but Marty, yeah.
Just on this point, incenting railroad behavior, and I don't mean to be facetious, but it may sound that way. Every railroad that came through here said, this demurrage is such a tiny fraction, it's really meaningless to us. So if that's accurate, then if you denied them demurrage because they were there in 11 days or 9 days, wouldn't incentivize them to do anything because they say the money they collect is meaningless, if that's true. Or am I missing the logic?
I don't think the money they're collecting is meaningless.
So you don't. So you think it would be an incentive if they couldn't collect that $1 billion?
I do.
So make sure that I'm, because when we went through and you saw the previous panel and the tenets that BN laid out, one of them was fault, and they seem to be putting forward the idea that if the railroad is at fault, there should be some consequence when it comes, to demurrage, or at least that there should be some break in demurrage. That's the way I interpreted what they meant by fault. And I guess I'm wondering, the credit system generally, is there a way to think about the credit system, perhaps, Kent, as you laid out, linked to car trip plan compliance on the initial transit time over the road, and then maybe something on missed switches and other things that get at first mile, last mile? For the general panel, do people have a general view on the use of credits and how the board should be thinking about credits as a way of capturing that fault concept? Can you do it with credits?
Well, I think for unit coal train, I don't know that the credit debit system works.
Okay, explain to me.
Well, because you're moving 124 or 150 cars as a unit.
Right.
Right, and so I think the biggest impact for coal trains is the imposition by UP now of the 24-hour, unloading.
Right.
If you don't make it, then you get assessed demurrage even if they don't come and pick up the train for, a couple of days. So, I know the PSR is looking at moving cars, but coal, we're still really moving full train loads.
So let's say, for example, you have 120 cars. If you held them for an extra day, you get 120 debits, right, of demurrage. If they were late or missed a switch or if they gave you 120 credits for that day, wouldn't that then kind of offset the debits that you'd get if you held it? I mean, talk me through why that wouldn't. What is particular about why that wouldn't work?
Well, I can speak. I can't speak for the UP, but I can speak for the BN that they don't have. They will give us a proposed cycle time, and they will give us an estimated time of arrival.
Right.
But if they don't arrive that time, whenever they arrive is when they start the clock. So I mean, how do you assess that in reverse? Because when they get there, and there's no commitment on their part to say your train's going to be there at noon.
Right. There's no service guarantee.
There's no service guarantee.
Right.
So I think it would be difficult to do that. Maybe there's a mechanism that would work, but I can't come up with a suggestion.
I would say many years ago in some ancient contract that we had, that we did have a mechanism for sorting out that sort of thing. On average basis, cycle time, performance. If they didn't meet that, then you were entitled to something. So it's possible to come up with a way of some kind of reciprocity in that. It could be worked out. It worked before.
And as a general notion, we talk a lot about service measures, and without getting into anything that's pending for sure, but generally, is car trip plan compliance and then something that measures first mile, last mile, are those the two most important service? Ken, it sounds like you think that they are, but the other folks on the panel, are those the two service measures that are most important for you all?
Cycle time is probably one of the biggest service measures for us. And
The actual length of the trip.
yes,
Yeah.
the total trip. And like Emily alluded to, there used to be in contracts, there used to be a cycle time guarantee. And if at the end of the year it averaged out that they didn't meet that, then there were financial ways to take care of that. Well, the railroads have removed that. And they won't even give you a cycle time guarantee. It's a planning mechanism.
But once you establish the cycle time, it's compliance with that cycle. That's a proxy for car trip. If I'm right to think about that as a proxy for what the car trip is, and therefore,
So you can plan how many cars you need.
Right.
To deliver the amount of coal you need
Right.
that month based on their assumed cycle time.
It's enormously important, really, when you're contracting with coal producers and you have a certain volume that you have to move within a limited time, maybe even a month or a quarter, and your planning, your logistics and planning revolve around the railroad assumed cycle time average. If you think your train's going to take 8 to 10 days to deliver a load of Powder River Basin coal to your plant, then it should take 8 to 10 days. It shouldn't be 12 days. And if it continues to be 12 days, then that really pushes you over the edge as far as your producer commitment.
So I appreciate that. And so one last question for me. Just kind of going through these tenants and just thinking through them. Clear and concise information, the information necessary to adjust, treatment of the same for for folks in the same, similar class, identically, sufficient advance notice, and capturing some element where if a railroad is at fault, you don't have to pay demurrage in some way. Maybe it's a credit we were discussing, Ken has other, however, right? So if those were tenants, what is it missing? Oh, the top tier, not to put you on the spot.
Can you restate it?
Yeah.
I don't think I'm following your question.
So if the board is thinking about what the reasonableness of a demurrage charge is, and the reasonableness of a demurrage tariff, and the information was clear and concise, and there was, I guess, sufficient advance notice, and people were treated the same, and you had the information necessary with which to plan operations, and there was something in there that accounted for railroad fault in a true way with credits or some other way. If there's credits when it's late or a missed switch, and it was a good system, while you actually got credits when the railroad made an error, what would still be missing from that?
I don't know that anything would be missing from that, but I would say that if the railroad is the one that is the judge and the jury on that system, like what you have today, there could be some flaws with it.
I see. And then it becomes then the question of the evidence and the dispute resolution.
Yeah, I mean,
and that
that's
sort of
the
thing.
issue today is, you just have to spend an enormous amount of time battling these things. And again, I believe it's a deterrent, is they're going to wear you out. And then you're going to go away. And frankly, I think that's what a lot of customers do.
I think there's a lack of data. You're not able to obtain the kind of data that they have on the performance of your train or their traffic or whatever. And you might talk to them, what happened with my train? Why did it go this way? And how come it took this long? And where are my cars, et cetera? You can have that conversation. You're going to get, unclear answers. But, usually it's just, okay, this time they messed up. Maybe we mess up another time. We work it out. You communicate. But now they want you to go through the service process on the internet and create a service issue. And it's not so personal anymore, I guess. It's not so effective.
Well, I just want to sort of close by saying thank you so much. Even though you were the last panel, you were as informative as the first. And I hope that you know that we have been listening to you very carefully. I also want to thank the folks that have managed to stay to fill the extra seats that are here, most of you. There are quite a few less railroad representatives than there were before, but there are a couple of you. And what I really want to do is also, I want to thank my colleagues and their staff and the board staff. The effort that they undertook to help us have this hearing, including finding us a location and figuring out how to run the lights, et cetera. I am so proud of you. And if you will bear with me, I would like to read off the list of all of the people that have made us look like we know what we're doing. So starting with the Office of Proceedings, Kenyatta Clay, Raina Conti, Sarah Francher, Jeff Herzog, Bernadetta Jones, Raina Laws Byron, Ryan Lee, Ryan and Raina are both here, Tammy Lowry, Rebecca Morrow, also here, who has worked very hard on all these issues, Regina Smith Bernard, Julie Waddell, who Marty mentioned yesterday, as well as Sarah, Cynthia Brown, Scott Zimmerman, Allison Davis, from the Office of OPAGAC, we call that Lucy's Shop, Catherine Borden, Fred Forstall, Mike Higgins, Gabe Meyer, Coral Torres, Crystal Wortham, Janie Shang, thank you, Janie, and of course, Lucy Marvin. From the Office of the Managing Director, Adil Gulamali, Don Sawyer, John Smith, Mike Sullivan, Roberta Workman, and Rachel Campbell. Office of Economics, Alex Dusenberry, Kim Hillenbrand, Dick Clem, Laura Meisner, Doug Paisley, Rob Plum, Pedro Ramirez, Laura Schneider, Jennifer Smith-Bozak, Frank O'Connor, and Bill Brennan. The General Counsel's Office, Anika Cooper, John Raxon, Craig Peets, Judy Leader, who works with us, and of course, Patrick, Marty, Ellen, Lisa, Val, Amanda, who has stepped away, Craig again. So anyway, thank you for bearing with me, but obviously a lot of effort from doing charts and tracking the revenues that we've asked Paris to report, and just putting together the most enormous history of Demurrage. I had no idea that most of these issues are a repeat of hundreds of years of pain and suffering. But really, thank you. As I had mentioned a couple of times, the record will be open for 14 days until June 6th, so that anyone that wants to respond to what has been said today, you are welcome to submit comments. And I, of course, want to turn to my colleagues to offer any closing comments they may have.
Very briefly, you have covered the waterfront on the staff and the tremendous effort that's been put in by everybody. I just want to single out you for having led this effort from the beginning and managed these lengthy and complex hearings. Really, you've done a remarkable job for all of us in getting us through it. And I'm going to defer to how you wind things up. Thank you, but thank you much.
Echo Marty, and thanks, Ann, for everything you've done to give us, really great information to consider this carefully and thoughtfully. And your leadership from before we got to the board has been truly helpful, and and all the staff as well. Ann mentioned the materials, but I think all of us had multiple binders. This is just one of, and then we had a separate one of just analysis, from the legal side and the economic side. And everything in between operationally. So staff did really a tremendous job, and many of those folks are here and listed them. So, and then thank you all to all of you, especially the ones who have been here through it all in all 12 panels. But we know how valuable your time is and how much effort and thought went into your filings, and so it's very much appreciated and made for a very enlightening hearing.
Yes, and I also. Besides, thank you for your written testimony. I mean, the carriers were asked to provide detailed information by May 1st, and they all delivered as well. So again, I think you can feel our appreciation.
I meant to just say, before you get to wherever we're going from here, home, speaking for my own experience here, this has been an eye-opening experience into the railroad industry. I've heard a lot in the 4.5 months or so that I've been here of issues raised by shippers and railroads, but I've never seen so much focused attention and really opening the door to what I think is a significant portion of this industry and the difference of what we're hearing from the railroad side and the shipper receiver side. It has really been a remarkable event, and I think points towards future actions, whatever they are. But anyway.
Yeah, so I certainly hope that the railroads will reply to with the comments that they've heard today, let the board know in their reply what actions they might be taking in response. When I would say I kind of started this effort last fall, it wasn't because any shipper complained to me, believe it or not. It was that I found it questionable when the railroads told me what they were going to do. It didn't seem logical to me for some of their changes, or frankly, it didn't seem fair. So as you saw my letters and my continued letters, so it wasn't that I was pushed. I really think that we can't fix every problem, but we can shed light on issues, and we can take action when we need to take action, and we will take action when we need to take action. A lot of good ideas, constructive ideas were offered, and I am still in the process of considering, frankly, all of them, and we will have meetings and determine what next steps to take. But I do think that things can be, things can be better than they are. The shippers and the railroads need each other, and if we need to be the marriage counselor, we will be. But I am hopeful. I think I really want to commend UP. They have made some adjustments based on your feedback, and I am going to remain hopeful that other carriers are going to do the same. Now, there are some folks, such as KCS, who is also in the room. Maybe they don't need to make an adjustment. Your hair isn't on fire because of their actions. But again, I hope that everyone is just going to be level-headed, consider what they can do for their customers, and how the network can still be fluid, because that is in the interest for the shipper and the carrier and the economy.
Well put.
All right, we'll gavel out, and thank you for everything again.